the way that we intended, or is this a reflection of the fact that the rubric we created for this aspect of SCEF is actually not working as the legislature might have intended?
President Steinberg, I want to make sure I understand your question fully. The technical amendments that we have put forward today, I think would address that somewhat, and I'll defer to our Director Ryer in just a moment. But we do have a section of the bill that will allow us to have joint competitive procurements instead of offering one procurement in each service territory. So let me ask Director Ryer to address how that section might alleviate some of the bottlenecks.
Sure, thanks. Thank you, Chairman. And thanks for the question, Representative Steinberg. So I think the question is getting at what we saw in this year's procurement in the NRES program for the small zero emissions project category. So there's the NRES program is broken up into 4 categories, of which the small category is the smallest. I believe it's under 200 projects that are under 200 kilowatts. And because of the size of those programs and consistent with the LREC-ZREC program, we actually set up the price is not an auction or reverse auction or solicitation like the other categories, but actually is administratively set, the price is rather. And so it essentially functions as a first come, first serve option for customers that put in projects and they receive that administratively set price. Last year, as you are well aware, the caps were increased last year. And so this year there's actually more capacity in that bucket. And so frankly, the result this year is a little bit surprising in that we weren't fully subscribed in that category last year. So the fact that I believe it was in Eversource's territory, they received more than enough and maybe both projects to meet the cap on day one is a little bit of a surprising result, but certainly not now that folks have a year under their belt and understanding the program, and certainly folks were aware of the increased cap. The increased interest isn't surprising. Regarding your question on whether or not we have the right tools to address this problem or the potential problem moving forward, we have the ability to change the megawatt allocations between the size categories. So certainly, and we have an annual review process to evaluate any needed changes in the program to make sure we're cost effectively deploying up to the statutory megawatt cap. So certainly if we saw that there was, we had way more interest in the small category and we were undersubscribed in other categories, it could make good sense for us to reallocate the megawatt categories for future NRES years.
Thank you. That's exactly what I was going to. That's an answer precisely what I was looking for. It does sound as if we are not uniformly utilizing each of the different buckets, and that perhaps at the end of the year we ought to review whether or not those allocations make sense for people. Even for the small projects, they do in the aggregate represent a fair bit of energy, so we'd like to see them move forward. Representative Meskers.
So I want to direct this towards Chair Gillette. I want to thank you for your efforts on the ratepayers going so far, and particularly on those who are receiving energy assistance from the state. In our conversations last year, I had some discussion with you, and I'm wondering if we're anticipating doing anything on the docket in relation to bad debt. The third-party energy suppliers, as I understand it, when consumers don't make payment on their debt and the debt is uncollectible, that it ends up in the general distribution charge. So essentially, we're all paying for the subsidy there for third-party energy suppliers. Are we envisioning anything in the measures you're bringing forward so far?
First of all, you're absolutely correct. The concept of uncollectibles works generally the way that you just described, and it's further exacerbated when third-party suppliers enter the picture, particularly because there's a concept called purchase of receivables, where that problem is further exacerbated. There is nothing specific in the legislation that we're talking about in 6724 to address that. However, I think it's actually the inverse. If you're looking at, what is the number? The HB 6723, then act permitting hardship customers to purchase electricity from energy suppliers. If we can talk about the statute that's seeking to address, my understanding is the existing statutory language in 16245 OM actually acted to require PURA to move hardship customers to standard service and to preclude them from enrolling with third-party suppliers if our investigation, which it did, indicated that that hardship customers were overpaying when they were on third-party suppliers. So that decision was made at the conclusion of an investigation 2 years ago. In the intervening years, in 2021, there was the bill passed that allows PURA a third option, or a second and third option, which is if we find once again that it would be not beneficial for hardship customers to enroll with third-party suppliers, we can either put them on standard service or we can allow them to enroll with third-party suppliers if the third-party suppliers have terms and conditions that cap their price at or below standard service. So that's the docket that PURA is conducting right now. And so we are respectfully opposing HB 6723 because we think that the fix that it's getting at is one that we're actually working on right now in our docket. And so I would advocate that to avoid further exacerbating the issue of uncollectibles that can arise, particularly around third-party suppliers and hardship customers, we would respectfully advise that we'd be allowed to conclude that proceeding and address it that way.
I'm not sure I understand the answer.
Okay.
Most of it, I think I understand. As I understand it, you're addressing the collectibles potentially, and that precludes any commentary if it's in a docket. What I'd like us to take into consideration is collectibles in general for third-party suppliers.
Mm-hmm.
I'm not anxious to subsidize the collection of uncollectibles through the distribution rate generically to all of my customers. So if people want to take the credit risk to be energy providers in my state, they should bear the credit risk of being those suppliers and shouldn't foist it on the rest of my constituents. And I can't be clearer. I'm not sure that's under consideration at this moment. And that's, I guess, the question after the statement.
Very good. Thank you for restating your question. The answer is no, that is not under consideration in the bills pending before you. To address the issue that you're bringing to the forefront, you would need to modify the statutes to eliminate or reduce what's called the purchase of receivables, which allows the suppliers to essentially discount their bad debt. So if they have customers that aren't paying their bills, it's absorbed, at least in part, by the utilities and further subsidized by utility customers generally. So we would need to modify one of the bills under consideration to address that concept.
Okay, thank you very much.
Thank you, Representative. Representative Foster, followed by Senator Fazio.
Thank you so much, Chairwoman, for being with us today. Prior to this public hearing, you and I have had a couple of conversations about arrearages, and I think I've had with just about everyone in the room that we could talk about this. I'm curious about, as you look at 6724, are you concerned, or are there things on your radar related to arrearages that you're concerned about for ratepayer impact? And are there guardrails that aren't in there that you've considered that might be important to be included here?
Yes, thank you for the question. So, the shutoff moratorium and some of the guardrails in 6724 have definitely been something that PURA has struggled with since the start of the moratorium, which was in March of 2020. On one hand, instituting a moratorium, which means that customers cannot be disconnected for reasons of non-payment. On one hand, that's a very important customer protection measure, and it was one that we were willing and happy to implement across all of our regulated utilities for the duration of the pandemic. And on the other hand, the issue that you struggle with is that to the extent that customers are not able to pay their bills and they're coming out of the moratorium, at some point the moratorium ends, and you don't want them to be faced with a quantity of a bill that they simply will never be able to pay. So you want to set up the individual ratepayers for success, but you also want to keep your eye on the total bucket of arrearages, because the conversation I was just having with Representative Meskers regarding uncollectibles, the reality is at some point those arrearages are written off and charged back to all ratepayers. So it's really in our best interest to help individual ratepayers, both with the affordability of the rates to begin with, but also with individual arrearage payment plans, arrearage forgiveness programs, because anything that those customers can pay will limit uncollectibles later, which are charged to all ratepayers. So that was kind of the theory behind the low income discount rate that we established. And it's also a lot of the theory behind, as I understand it, some of the concepts in 6724, particularly the really important provision that would allow PURA to distribute $1 million, up to $1 million in grants per year to some of these individual organizations that are really critical to negotiating individual payment plans for customers when these arrearage management programs that we create aren't the best fit across the board. So I think to answer your question about what's not in 6724 that we're looking for would be the companion bill that I've already alluded to, that PURA is hoping to put forward, which puts some additional guardrails in place around the matching payment programs that the utilities offer, specifically changing some of the provisions to allow for customers to receive an arrearage credit after each month that they participate, rather than after every 6 months. So there's some additional tweaks in that bill, which I look forward to speaking with you about, but I think that bill coupled with 6724 could make some meaningful impacts in the hardship customers who are participating in these programs.
And my last additional question, given that this bill has potential impact to current arrearage, or to extending the current arrearages that we have, I think the utility companies make an argument that without the threat of a shutoff notice going to a customer, it's challenging to get them through the programs to get them back on track for payment. What do you believe our best strategies for addressing the current arrearage balances are? And do you feel comfortable that that we have everything within our capacity to address the ratepayer impact of the current balance of arrearages?
Thank you for the question. So certainly we've heard similar feedback from the utilities along the way that, they've posited that without the threat of termination, that customers are not motivated to pay. I think that we are cognizant of that concern. It is definitely a counterbalance to the continuation of the moratorium. But I think if the moratorium is narrowly scoped, as I understand it here, to be for residential hardship customers, then I think that might, that's certainly a policy decision for you all. And during that time, I think we should focus on making sure that those customers are enrolled in the arrearage management programs that would be enhanced by this bill. I think our low income discount rate proceeding yielded that we had testimony in there that's detailed in our decision that indicated it's not that these customers don't want to pay, It's that they are, seeing no difference between if they owe $100 and they can only put $20 down. They're not seeing a difference in outcome, meaning that they are disconnected whether they pay $20 or $0. So, we're focused on making it affordable up front, which is what the low income discount rate is designed to do. And then we're focused on the arrearage management programs after the fact, being accessible and attainable. I think one thing that we could consider further is whether there is different strategies that we could use for addressing arrearages holistically. Certainly, there have been other approaches that we've seen across the board, and I think we want to keep open, whether there is an entitlement to full recovery of some of these costs that have accrued during the moratorium. There's certainly been some creative discussions in other states. So that's, still top of mind for us as well.
Thank you. I appreciate your detailed answers.
Always glad to hear that other states have some creative approaches. Senator Fazio.
Thank you, Mr. Chair. Thank you, Madam Chair, for your testimony and for your efforts. We talked and you talked in your testimony about alleviating some of the pain that consumers are facing in the short run through relief. There's also proposals that are being heard today that aim to address long-term cost as well, that are being felt by all customers. Specifically, some of the reforms in Senate Bill 123 broaden the renewable portfolio standard, which may or may not reduce costs for consumers in the long run. Has your department at all analyzed the types of savings that we could see from such reforms in the long run?
Yes, I think SB 123, in addition to the changes to the RPS, carry many of the same or similar proposals that we were discussing the last public hearing, and certainly those carry the potential for significant cost savings for customers over time. The RPS provisions of 123, I have asked my staff to analyze as our first take on the language is that the RPS, the changes to the RPS statute that are outlined in 123 may generate savings to ratepayers and have a sizable impact over the course of its implementation. So we are still running those numbers. If it would be helpful for the committee, we could supplement our written testimony on the matter with some of the numbers that we have run, but we didn't get those done for today, but I'd be happy to follow up in writing.
That would be great. I'm sure it would be much appreciated by the committee, certainly by me. I think there's also a matter on your docket to break out some of the costs within the energy bill for consumers: transmission, distribution, supply, policy charges, et cetera, instead of the current manner that electricity bills are broken out for consumers, just supply and distribution, in order to provide more transparency and information for consumers. There's also language in the bill that would put that into statute. Can you explain some of your rationale for wanting to implement that? Already having that idea, wanting to implement that sort of transparency measure for consumers as is?
I'd be happy to. So, a little over a year into my term, we had three things happen, and I'm trying not to take it personally, but we had three things happen. The pandemic started. Customers, especially in the Eversource territory, may recall seeing sizable rate changes in July of 2020, and then the tropical storm happened, and PURA started to have public comment hearings following those last two events in particular. And a lot of the public comments and the feedback that we got, which ended up being the genesis for some of my PURA 101 roadshows as well, were a lot of questions and concerns from customers. They don't understand the difference between distribution and transmission. They don't understand why their delivery charges are 3 times supply historically. So there was just so much about the bill, even as a member of PURA, when I'm looking at my own bill, thinking, I don't know what goes into this. I don't know when these rates are going to change, or what the drivers are. And so one of the things that we announced at the conclusion of 2020, having looked into what caused the July 2020 rate increases, which were attributed to some of the reconciling components on the bill, we decided that there were 2 things that needed to happen. The first was that we needed to change the way that our agency reviewed the costs that go into the reconciling adjustment mechanisms, which are called RAM for short. And then we separately decided, it's time to redesign the bills because we're struggling with the fact that Eversource bills are different than UI bills, and also struggling to explain to customers all of these components that I just walked through. So we undertook a pretty lengthy stakeholder process, which culminated in a decision in July of 2022. And as you mentioned, we did decide in that decision that the costs needed to be further broken out across 4 buckets, which we felt, looking at the evidence in the record, that the 4 buckets were more representative of the cost drivers associated with each of them. And we also felt like it was important for a transparency perspective that customers should know who to advocate before if they have a concern about one of those cost buckets, and additional information about what goes into those costs and when they can expect them to change. So like I said, that decision was finalized last July. At the time, the utilities told us it could take up to a year to implement some of those changes as it affects their billing systems and their customer systems. So I'm sure they're testifying today, and they might be able to provide you an update on where they are. And if not, we can provide one in writing. But I would expect that those bills for Eversource and UI customers begin to reflect those changes that we ordered as soon as this summer.
Right. Well, thank you for your time and all your efforts. Certainly, you did not ask for those, COVID or the storms that you faced, but we're lucky as a state to have good public servants like you in place to deal with them. So, appreciate your time.
Thank you, Senator, and I will concur that we certainly hope the pandemic wasn't personal, but it would be great to know who actually is to blame. So, I don't see any further questions from anyone. If not, Commissioner, Chair, thank you for your time today. And my guess is we'll be revisiting a number of the things we've talked about in the context of these bills and other bills. But we really our efforts to help ratepayers across the state. Without further ado, we will move to the next speaker on the panel, which be the Department of Energy and Environmental Protection. I understand that Commissioner Dykes will not be able to make it today, but she was here yesterday, so she does get credit for that. And we will have Bruce Ho and Entourage, who I understand are all online. Good morning.
Good morning. Can you hear me okay? Good morning. Can you hear me okay?
Oh, yes, I'm sorry. Please proceed.
I think it sounds like the audio is working, but if not, please let me know.
You hear us?
So, okay, I can hear you now. Thank you so much. Sorry for the technical difficulties. So Senator Needleman, Representative Steinberg, Senator McCrory, Representative Foster, Senator Fazio, and Representative Buckby, and other members of the committee. I want to thank you for the opportunity to testify before the committee today on a handful of proposals outlined on the agenda. As Co-Chair Steinberg mentioned, Commissioner Doss, unfortunately, is unable to attend today due to the schedule change, but I'm a senior policy advisor at the department, and I'm joined by a number of my colleagues who would be more than happy to address any questions that you might have. First off, DEEP applauds the committee's continued efforts to find solutions for Connecticut ratepayers through a number of the proposals that have been put on the table. We have filed written comments, testimony on several of the bills, which I will briefly summarize, and then to the extent that there are questions or you would like more details, I am happy to turn it over to my colleagues who can get into that. First off, DEEP is generally supportive of SB 997. We have provided some specific comments in our written testimony on the changes to the NRES, SCAF, and virtual net metering provisions, including some potential tweaks that we think could enhance the bill. On SB 123, DEEP can support some of the principles behind the bill, but we do have concerns with and questions about several provisions. And in particular, I want to note that we strongly oppose the proposed changes to the state's current Renewable Portfolio Standard, or RPS, and we'd be happy to address those in further detail if of interest. DEEP also generally supports the goals of HB 6724. We've again filed some specific comments on the bill. We do have some questions about the proposals to set a reasonable time for amortization agreements and to establish the ratepayer-funded service to assist customers with negotiating such amortization agreements. So we'd be happy to discuss some of our questions there with the committee. We also appreciate the focus of HB 223 to ensure responsible development of offshore wind capacity. But at this time, DEEP does not support the bill. Moving forward, we think that these issues can be best addressed through a regional approach, which is currently underway. And then finally, on HB 5640, again, DEEP supports elements of the bill in concept, but we do have some concerns with the specifics of how it's been proposed. And in our written testimony, we've suggested a potential alternative approach to addressing the concerns around the removal of service cables. So again, that's just a very high-level overview, but happy to get into more details. And I'm joined by a number of my colleagues who can answer specific questions, but happy to hear the committee's questions.
Thank you for your testimony today, and we will look at your written testimony very carefully. With regard to 997, you suggest that you were generally supportive, but there were a number of tweaks you were looking at. Could you just give us the sort of the nature of what you're looking at seeking to change?
Sure, more than happy to. And I'm actually going to turn it over to Josh Walters, who's a staff attorney in the Bureau of Energy and Technology Policy, and he can do that.
Great. Thank you very much for the question. There were probably two main issues with 997 that we were looking at. One pertains to the newly proposed subsection G, which takes the virtual net metering program and removes the requirement for those resources to be placed on a customer's own premises. In general, we support that. We just wanted to raise for the committee that there's a possibility that could cause some issues with some other state priorities, including preservation of prime farmland and core forest. So as part of that process, as part of our suggestion, we would look to work with the committee in developing some sort of process for DEEP to define those terms in more detail, or set up some sort of a threshold or something to that extent. We're willing to work with the committee on exactly what that would look like, but that gives a little bit more of a clear threshold for how those programs would apply in these clean energy programs. That will help both the state in administering the programs, and it should help developers have more of a clear guidance on which types of projects and the types of properties that would be eligible while preserving those other state priorities. And if you could just give me 1 second, please.
Before you go on, though, when you refer to threshold, are we talking about a specific megawattage, or what would be a threshold in this instance?
Sure. That so in right now in our shared clean energy facilities program, we've developed a definition of core forests that we've implemented through the program rules. And basically and we have the definition in our testimony, but basically what it says is, let me just pull it up here in the testimony. So if a project impacts core forest, which is an unfragmented forested land of at least 250 acres, that is 300 feet or greater from the boundary between forested land and non-forested land, a SCEF facility cannot be placed on that parcel. And so when I say threshold, what I mean is something along those lines of providing clearer guidance about the types of property that would be eligible to participate in the program. It could be as simple as applying that core forest definition in the NRES program as well, or it could be as part of a process to look at that some other threshold comes out of that. So I don't think we're prepared to recommend a specific threshold at the moment, but that's kind of the concept of what we'd be looking at.
Thank you. And your second point?
The other point on subsection G is by opening this up to development off premises, it may increase the number of municipalities and state and agricultural customers who are willing to participate. So it would just be something that we're flagging for the committee's attention, to be aware that if more of these entities or more of these customers start to participate, it could potentially crowd out other customers. A mitigating factor is that the capacity of the program was increased last session. So this is more of a flag to monitor going forward. And one thing we flag in the testimony is it could be helpful to clarify that PURA has the authority in the existing statute. They already have the authority to monitor the competitiveness of the procurements. And so arguably that could fit into this situation where PURA could keep an eye on how these programs are being utilized. And we recommend that the committee consider, looking at whether there's certain procurement parameters that maintain that competitiveness, like establishing a subcap on participation by these specific types of customers, or exploring like whether certain types of preferences might be available, but all kind of in the name of ensuring that a sudden influx of interest from these customers don't crowd out other eligible participants.
Thank you for that. And I guess we'll all look carefully at how the program as revised last year works out, but there does seem to be opportunity with some of these buckets being utilized and some not. So we will look at that with interest. Are there other questions? Or Senator Fazio followed? We'll go with Representative Meskers followed by Senator Fazio.
So the House of Commons getting yielded to. Thank you.
I would never call you Bright Honorable.
There you go. I'll take that under advisement. In terms of the commentary I heard about forest land and your concerns there, those are based on concerns about solar arrays or rights of way? Because, I know we're under consideration for some hydroelectric, and I want to know what you're trying to preclude on those protected forests.
So the way it currently works in the SCEF program, the rights of way for interconnection are excluded from a lot of these thresholds. So we're focused on the project site itself when we're looking at these core forest concerns.
But you're talking about projects being solar arrays and large solar displays, or are you talking right of ways for telecommunication, rights of way for hydroelectric power, to high power transmission?
It would be SCEF is class 1 resources. So it typically tends to be solar or fuel cells that we see participating in the program, but it is potentially open to other class 1 resources.
I think that's an answer, but I'm not sure. The question is more specific. Would your suggestion preclude high voltage hydroelectric transmission lines?
This is focused solely on SCEF and the NRES program. So I think those issues would be citing for those types of transmission lines would be dealt with in a different manner. So it would not be covered under this piece of the statute.
Okay, because I have particular concerns. Should we finally get approval from our northern states to do hydroelectric transmission lines to reduce our carbon footprint, I think that benefit, and whether they're underground or above ground, I think, it's something I want to strongly be in support of. That's why I'm asking the question, but I appreciate your answer.
Thank you, Representative. Senator Fazio.
Thank you to my right honorable friends. I wanted to ask a question on your testimony with regard to the proposed renewable portfolio standard changes that you mentioned in your testimony. When we, I think, as a government, as a society, agree that we want to put a strong environmental foot forward, create something like the renewable portfolio standard with the goal of reducing carbon emissions, that's a noble goal. We don't exactly know what form it's going to take. It's going to take in reducing those emissions. So I think the motivation behind the changes would be, listen, we don't know exactly how to reduce carbon emissions, but there's all these different forms of clean energy which could potentially do so, including those like nuclear and hydro, which aren't presently included in the renewable portfolio standard. So the idea of reforming and broadening the RPS is to further those environmental goals and do so in a less biased manner, shall we say. So with that context, I kind of want to understand a little bit more of your opposition to those changes.
Yes, Senator Fazio, thank you for the question and opportunity to elaborate. I'm going to turn it over to my colleague, Eric Annis, who's an energy supply supervisor in the Bureau of Energy and Technology Policy. He can get into it further.
Yep. Thank you, Bruce. And thank you, Senator, for the question. So the RPS originated when we deregulated, and it's really part of a regional market for renewables. And the RPS requirement as a percentage is set so that it expands every year. So you're going to add renewables slowly over time. If the RPS were to suddenly become eligible for all the resources that are mentioned in the current bill, you would flood the market and force the price to zero and wind up supporting none of the resources, because Millstone itself is about 60% of Connecticut's load. So if an RPS at 40% and you add Millstone, which the utilities already own at least through 2029, the entirety of those attributes would end up suppressing the price to zero or near zero, basically just the transaction costs of the paper moving back and forth. So you lose the intent of the RPS supporting resources and you just drive it down. So you get the cost savings, but you essentially eliminated the desire for encouraging renewable resources either staying online or coming online, which is the RPS's intent. DEEP strongly supports a lot of the goals of the technologies that are being added and eligible. So whether it's hydro and certainly Millstone and the nuclear technologies, we have a contract with both Millstone and Seabrook. So those resources are critical pieces of the environmental goals of the state. But in terms of the mechanism of supporting those, the RPS can't handle all those existing resources suddenly becoming eligible. There are rules for hydro in a bill that passed in 2013 that if the RPS is short and we're not going to see new renewables coming on, that we are allowed to make hydro eligible for a portion of the RPS, but we haven't really seen a shortage of RPS like we were seeing about a decade ago at this point. So I think the concern you're raising of trying to encourage those resources is one I think the department is strongly supportive of. It's a significant concern on the mechanism for doing that. And I think DEEP would be happy to work with the committee on kind of working on ways that makes everyone comfortable supporting those resources. We do have authority to procure hydro resources. We are on the waste to energy side. We're working through that issue significantly. Last year, the Senate, the legislature passed the bill to kind of protect the class 2 resources so that they are insured, that they get a price that doesn't get reduced if class 1 becomes oversupplied. And by reducing class 2 and putting them into class 1, and with this program, you would drive that price down to near zero and unwind what we did last year, to make sure that the existing trash to energy resources get ratepayer support to stay in operation. And ideally maybe bring on another resource, but that the RPS probably will not do that by itself. So I hope that answers your question, Senator. Happy to take follow-ups.
Yeah, I appreciate that. It is a thoroughly thought out answer. I guess my thinking is a couple fold. First of all, the bill does include limitations to how much each source can sell into the market and be used to satisfy the market. So that would limit the supply that you're putting into the rec market. The second, as you implied, there is a point that the state will start owning the environmental attributes of the Millstone contract. So the state will have the discretion of whether they want to sell those recs into the market or not. And basically, when they're making that decision or not, they're making the decision whether or not they want to give a credit, reduce the price that consumers are ultimately paying. And we don't live in a vacuum. We don't live we don't live in a static scenario. We're going to see technologies of all these sources of energy changing over time. And I would certainly hope that it is all of our hopes that the technology is going to evolve such that we can easily satisfy what goes up to a 48% renewable portfolio standard mandate in 10 years. And so that naturally the price of these credits will go down and the cost to consumers will go down. Because ultimately, when we're talking about the price of the credits, we're talking about the cost to consumers. And so I'm still I'm not sure why you would want to exclude certain types of energy from the standard as long as they're clean. And I don't understand why reducing the price of the credits, if you are satisfying the clean energy standards, is not desirable when it should be a goal of this committee to reduce prices for consumers.
Understand. I think that a goal that the department shares. The problem is we have to make sure that the market functions and clears appropriately. I think I heard you say that because we own the Millstone attributes, we can the utilities can control the price that of the assets that come on. So if they want the price to go up, they can withhold selling the nuclear attributes, and if they want to drive the price down, I guess they can release them. It's not the market mechanism, which was the origin of the RPS, a desire to bring on new renewables and to some extent keep the existing ones operating. So it's the balance we're trying to reach in terms of eligibility of existing and increasing the demand. So you're kind of having the RPS encourage new renewables come on, and a price that keeps existing on is where you want them to clear at. And it's a regional market overall, and trying to find that balance is what the goal of the statute and the increasing over time RPS. So trying to understand how with these changes we would accomplish the goals that you're laying out is one that I would be happy to work with the committee, and I think the department would be on achieving that goal. I think there's significant concern about opening it up to all those existing resources. The hydro is a piece of it, but nuclear is a very large and would swamp it, and together they would swamp the price. So I hope that answers the question more clearly and gets at the concerns you were addressing.
Yeah, I don't want to monopolize the time, so I do appreciate your answers. The goal is to be clean and affordable, and that's simply the motivation. But I'm happy to continue the discussion offline and appreciate the time.
Thank you, Senator.
Senator, and I think we all desire both goals, and the natural tension between them is something we're going to have to work on. Other questions or comments? Seeing none, thank you everyone at Deep for your testimony today, and we look forward to the additional conversations we need to have on these bills. Next up, we hear from the Office of the Consumer Counsel and Bert Cohen.
Are we good now? Thank you, Representative D'Amico. I guess we're right at the noon, so I'm not sure if it's good morning or good afternoon, but Chair Steinberg, ranking members Fazio and Buckby, and it's good to see Representative Piscopo, Representative Meskers, D'Amico, and Representative Mashinsky. My name for the record is Bert Cohen. I'm a staff attorney with the Office of Consumer Counsel, and there, pursuant to our organic statute, I serve as the broadband policy coordinator. Consumer Counsel Claire Coleman regrets not being able to be here, but presently she's consumed by the United Illuminating and Aquarian rate cases. Our office has submitted written testimony on the energy side of the house, as well as the communication sector. She would be glad to follow up with any of you individually on the bills being heard today. I am here to testify today on the two communications sector bills, SB 20 and SB 19. I know that this committee is laser focused on the energy legislation that's being proposed, but part of my job here is to get some of your bandwidth over to the communications sector, pun intended. So the way I'm going to do that is, if you look at the bills being considered by this committee this session, and you rank them as college courses, the committee is taking advanced energy level 400 courses. Okay. SB 20, however, is a basic foundational course. I'll assume that you're taking it pass fail. So with that, I want to tell you that right now, the state of Connecticut has $140 million ready to allocate to communications companies for deployment purposes under the Federal Communications Act and the ARPA Act. Knowing who owns and controls the companies that populate our public rights of way, regardless of the services rendered, is a fundamental right and duty of the state of Connecticut. And that duty has been delegated to the Public Utilities Regulatory Authority under General Statute Section 16-47, generally referred to as the holding company statute. That statute has been in place since it came over from the 1949 revision. It's been in place for 70 years. It works well. What we're asking, what SB 20 is asking, is a concept, is a technical amendment to include the communication sector that occupies the public rights of way. Very simple. In fact, the statute includes community antenna television companies in that. That was placed in 1647, in 1982, but in 2008, following 2007 state cable legislation, The then DPUC construed the statute as not applying to cable companies, although it did apply to the telephone company. And so right now, you have very unfair, discriminatory statute that applies to Frontier Communications, which is competing with and providing the same services as the cable broadband industry. So, that in and of itself is conflicts with the non-discriminatory provisions in the Federal Communications Act. But in any event, the other 50 states all have variations of our what the bill of the concept bill is called, the mergers and acquisitions, prior review and prior approval. So I just want to give you a few examples because our written testimony goes into a great deal. And I know you have a lot of bills to discuss today, but, and I don't mean to pick on any one specific company, but it has nothing to do with the current performance of the company, but it's just the concept. And in 2015, 2016 period, we had two major transactions that impacted the communications sector in Connecticut. And the one I want to talk about involves Altice and its acquisition of Cablevision Systems Corp. Now, Altice is a European-based company, and presently it has $50 billion in debt. Let me repeat that, $50 billion in debt. It acquired Cablevision, and the only requirement that it really had was to send a change of address letter to Pura. There was no way the state had no opportunity to review Altice's plans, its financial capability, how it was going to leverage the acquisition of a major US company. We didn't have that. And so now, several years later, because of the debt, the company split into two. So it had $50 billion of debt. It then allocated it split into international properties, into US properties. It allocated $24 billion of debt to the US properties. US properties, a significant portion being the Cablevision holdings in Connecticut, New York, and New Jersey. That impacts us. We don't know what the future of Altice is going to be. Personally, I'm hoping that they go forward. They're building fiber. They're doing a lot of good things. They're not perfect. None of these companies are. But the fundamental premise is we need to know as a state who owns and controls each of our major communication sector companies that occupy our public streets and highways. It's fundamental. Like I said, it's public service company 101. So in any event, the future is going to continue to see consolidations, acquisitions, transfers of control. Connecticut, we're a small state, very small state, but we have the top 4 cable broadband providers in the country have divided up our state. That's not going to last forever. It's impossible. So how would you feel 5 years from now if you don't enact SB 20 and one of these companies now sends in a letter to Pura saying, I bought out Frontier, or I bought out Cox Communications and Charter and Altice and Breezeline, which I think is the other small one. How would you feel? We can't allow that to happen. It's not in the consumer's interest. It's not in the state's interest. It's not in the interests of business and industry that relies on the internet. So with that, I'd also like to, as an attorney, I'm very tempted to want to spend time refuting the opposing comments that were filed by my friends in the industry, but I'll do that one-on-one with you. I'm not going to take up your time with that. I implore you to spend some time on this. We're happy to talk with you offline about this. This is an important bill. In my opinion, as a lawyer who's been doing this for a long time, this is one of the most important bills you have before you this session. And I respectfully request, our office respectfully requests that you give it the attention that it deserves. Just briefly, I'd just like to mention SB 19, which is a consumer protection statute concerning communications providers issuing a refund when consumers end service in the middle of the month. A lot of the communications providers bill your services in advance. The cable industry does that, telecom industry, broadband, you pay the month in advance, except for transactional costs. If you order a movie or something, then you pay that following event. If somebody goes into, think of a senior who goes into assisted living in the middle of a month, has limited resources or needs those resources to pay for that assisted living. It's not a lot of money, but they're not getting that service and the companies keep that money. So we would urge you to take a look at that from a consumer perspective. One of the oppositions, I'll have to say this, one of the oppositions cited a case out in New Jersey saying that the court found that that was rate regulation. That's malarkey. That case is on appeal at the New Jersey Supreme Court. The controlling case comes out of Maine. Maine legislature is, they're not taking any prisoners with respect to the communication sector. They passed the same bill, the same players that are here in Connecticut challenged that bill legally. They won at the district court level. And it got appealed. The First Circuit said, this isn't rate regulation, this is consumer protection. And I assure you that it is. And our office stands ready to, if you have the willingness to pass this bill, our office stands ready to defend it if it's challenged in court. The First Circuit Court of Appeals ruled that it's not rate regulation, it's consumer protection. The cable industry appealed it to the U.S. Supreme Court, and the Supreme Court wouldn't take it. So
Well,
that's
thank you
the
for
law.
that. We appreciate your support for both Senate Bills 19 and 20, and we will look carefully at your written testimony, particularly as it relates to your refutations of some of the industry comments. Are there any questions or comments? Seeing none, thank you for your testimony today. We'll see you next time.
Thank you.
We have now gone past our first hour, where we are exclusively talking to elected officials and agency heads. So we will now start going back and forth and adhering to a more narrow time frame. So first up just happens to be Vincent Pace from Eversource, followed by Senator Berthel, who will be up right after that.
Good afternoon, Chairman Steinberg and Ranking Member Fazio, Ranking Member Buckby, and all the committee members. My name is Vincent Pace. I'm an Assistant General Counsel for Eversource based in our Berlin, Connecticut office, and I'm here to testify regarding Senate Bill 123. We filed written testimony. I'll defer to those details. Out of respect for your time, I'll limit my comments to some very brief remarks. Section 1 of the bill impacts revenue decoupling. And historically, energy efficiency advocates and environmental advocates have supported revenue decoupling because it promotes energy efficiency, it promotes conservation, and also the jobs created by energy efficiency programs. The concern we have with Section 1 is it says now PURA can elect to have revenue decoupling, but the current language in the statute says PURA shall implement revenue decoupling. The concern we have is even if the current PURA commissioners say they will not eliminate revenue decoupling, No one here can guarantee what future PURA commissions may elect to do. And so therefore, we respectfully ask you to please preserve the current language, which says that PURA shall implement revenue decoupling. But we want to give PURA a fair opportunity to address your policy concerns. The best way to do that is to put guardrails in the statute that says that PURA has the power to fill in the details, and they can fairly balance the needs of consumers, the energy efficiency industry, and also the utility companies. Section 2 of the bill impacts proposed settlements at PURA. And we support concepts of giving notice to stakeholders. We also support the need to file evidence in the support of the record, but we respectfully recommend a few minor adjustments to ensure that DEEP, the Consumer Council, and other parties can actually implement reasonable settlements. And as I said in a prior hearing, PURA has the power today to be able to reject or to modify settlements. And so therefore, we think the due process provisions proposed in Section 2 are reasonable, but please do not eliminate settlements or tie the hands of the DEEP, the AG, and the OCC to submit reasonable settlements to PURA. Section 3 directs PURA to redesign the utility bill to increase transparency, to identify the distribution charge, the transmission charge, public policy charges, and also supply. We support transparency. We know PURA is working very hard in the current docket. It's docket 140719 RE06 to enhance consumer transparency on the bills. We're working very hard to comply with their orders, and we support all measures that promote transparency to help our customers better understand what they're paying for and to make informed decisions about energy usage. Finally, Section 15 of the bill sets up a task force to look at how the state procures standard electric service. We support that task force. We look forward to participating and offering our constructive feedback to help them make the most informed recommendations possible. Thank you very much for giving me the chance to appear before you today. I'm happy to take any questions.
Thank you. May I assume that in your written testimony, you get into the specifics about the slight changes you would seek to make with regard to the settlements?
We did not offer detailed comments, but we're happy to provide that offline. I can say today the two sections that really focused our attention were, one section said that the duration or the length of a future settlement would be limited to the number of years for the utility company's current rate plan. One concern I have with that would be if a company has only a current 1-year rate plan, then presumably the duration of a settlement would be a 1-year period. We think that the party should have the flexibility to make a recommendation to PURA as to what they think the duration of the settlement should be. Sometimes a multi-year plan, like a 2-year or 3-year plan, could be in the best interest of both consumers and the utility companies, because a multi-year plan provides predictability and stability in terms of letting consumers know what the ceiling would be on their rates for a multi-year period. So we'd like to work with this committee, offer our constructive feedback to help you achieve your goals as they relate to settlements, but again, give parties the flexibility to submit considerations. And as I said previously, if PURA does not like what's being submitted, they have the power to say, no, we're not going to accept the settlement, or they have the power to say, go back and resubmit the settlement. We have these concerns, please address our concerns. The other provision that we had a concern about was one of the provisions said that, and it cross-referenced General Statute 16-19A, which says that there have to be rate reviews for electric and gas companies every 4 years. And what that provision seemed to say was, if the parties negotiate a settlement, they submit that to PURA, PURA approves it, it does not foreclose PURA from looking at rates in the next 4-year period. So one of the concerns would be, why would the parties spend all the time, all the resources, all the energy to negotiate a settlement, get it approved, when the authority can then look at that issue within a year or two? So we would respectfully ask you to consider deleting or modifying those provisions. But the other provisions, which deal with notice, which deal with submitting evidence in the record to support settlements, we think are very reasonable. I hope that answers your question.
Thank you, though I'm not sure I'm with you on the your desire to change the language that requires that they do a rate review within 4 years, or at least gives them that option. this was the core issue we raised when we were talking about it last time, which is settlements which may in the short term be beneficial to ratepayers does not afford PURA the opportunity to do the full scale comprehensive analysis, not only of what a rate case is, but the assumptions behind it. If we were to change it as you suggest, we're right back where we started, whereby settlements continue to postpone that extremely necessary, further, more comprehensive review.
You asked a very good follow-up question. Let me try to explain in more detail. We agree that the current statute and 16-19A that says gas and electric companies should have their rates reviewed every 4 years should remain in place. That's important to ensure that periodically rates are reviewed. One of the concerns we have, which could be solved by drafting, would be if, for example, a settlement is negotiated and it's approved by the authority, we would not want that, for example, to be looked at 6 months later or 1 year later. If it's looked at 4 years from now, then we think you achieve the goal of the statute. But if the settlement's purpose is to have a rate plan in place to provide stability for 2 years or 3 years, we think you need to wait a full 4 years to review it, not reviewing it in a much shorter time frame. So we would respectfully submit that with some very slight drafting adjustments, we can achieve your very important goal of ensuring that every 4 years there is a rate review, but that would not limit or undercut multi-year settlement agreements. I hope that's responsive to the question.
I hear what you say. I'm not sure how you're going to do it. So I guess I'd be very curious to see the language you would offer us to achieve both those important goals. Representative Meskers.
We've had prior conversations, and I've had lengthy conversations with PURA. I'm dealing with a multi-state entity with some of the highest distribution charges in the United States. On the back of those distribution charges, I should own a Cadillac and not a Volkswagen Beetle. There's a healthy goal in the regulation of a monopoly that has a distribution mandate or concession from the state. And that's that we get high quality distribution, well-invested infrastructure, and a strong regulatory authority. My goal is to have a couple of your shareholders yell at me and have a couple of my constituents thank me. The current stacking of the deck is that all the shareholders will be sending me Christmas cards, and my constituents, I will have to lock my front door. So the issue becomes the balance between our regulatory authority and your desire to achieve a maximum profit. And that conflict is a healthy conflict because we want to be able to measure the capital investments and give PURA a good look at the metrics, the achievement of our infrastructure goals, the stability of our infrastructure. There's a conflict between your position and PURA's position on what gives me my best look at the distribution rates. And I'll give both of you the benefit of the doubt, but I understand that this is a armed conflict where I want to make sure that we get to the best strongest distribution, and that having further looks at the fees and rate and structure, I think is imperative to me. So we may disagree on whether it's 4 years or 2 years or 1 year, but I think the look back on capital projects that they achieve the goals, and that if they don't achieve the goals, that it shouldn't be just the ratepayers that bear the brunt of the cost, and that the shareholders find some dissatisfaction with the performance. And so far, I'm not sure where the equation lies, and that's why I'm kind of interested in the regulatory framework and relatively supportive of PURA's request.
Well, thank you very much for the feedback. And I will say that Eversource agrees with you in that transparency is very important to everyone here at the legislature and also to all consumers. And we think that the PURA process is a transparent process, with PURA acting as the neutral arbitrator, the decision maker, and the utility companies offering their perspective, with the Consumer Council, the Attorney General's office, the consumer advocates, all addressing the concerns of consumers. We think that in order to address your very good points about holding us accountable, we think performance-based regulation is the way to be able to do that. In the legislation you passed, as you know, the Take Back Our Grid Act, you said to PURA in section 1 of that bill, we want you to implement performance-based regulation, which PURA is working on very actively. And we think the benefit of that is you laid out in section 1 of that act certain goals you wanted them to focus on: reliability, resiliency, customer service. And so PURA is now working to develop what the metrics will be to hold us accountable, to ensure that if we don't do well, we will have financial consequences. What I would also point out is that in order to address the concerns that you and your constituents have about the distribution rate, we agree that there should be rate reviews at least every 4 years. We propose no change to that existing statute. We think it works well. All we're saying is that settlements can be effective. It's not just Eversource saying that, but many other stakeholders have said that. We think that they should be allowed to be submitted to PURA and let PURA take the evidence and then make an informed decision to either say, yes, we approve the settlement, or no, we reject it, or go back to the table and make additional changes to strike the right balance between the interest of consumers and also the utility companies. I hope that responded to your question, Representative Messers.
More or less. I think the outstanding issue becomes my distribution rates in Connecticut versus the contiguous states and versus the rest of the country. And we have to hold them up to the right light to make sure that what we're paying for as ratepayers gives us the distribution network we want. So whether we're overpaying for a great one or underpaying, I don't think I'll find many arguments that people on any part of the aisle think we're underpaying our distribution rate. So I'm encouraged by PURA's engagement. I know it'll be a rough ride, and I thank you for the conversation.
Thank you, Representative. And I'm sure we're going to be having a further conversation about the entire distribution side of the equation. Yes, Representative.
Thank you, Mr. Chairman. Thank you for coming. Appreciate it. We had a bill in the last public hearing, I believe. I looked it up quick, maybe 966. It was section 1 of that bill preserve the decoupling mandate, if you will. And this one seems to change the shall to a may. Can you help me out with that confusion that I'm having with these two bills?
Sure. Thank you very much for the very good question. And so in general, what our goal would be that we would encourage you to respectfully consider mandating that decoupling do exist. And right now, the current statute states that decoupling shall be required, then directs PURA on how to implement that. For Eversource, we implemented a very limited form of revenue decoupling back in our 2007 rate case. But it was not until 2014 we implemented full revenue decoupling. We would respectfully submit that in the roughly 9 years since that was implemented, it has helped consumers. All that revenue decoupling guarantees is that if PURA approves a certain dollar level, the company can recover in rates. We would get that if sales decline due to customers engaging in demand response or energy efficiency measures. But if we have very hot weather and sales go up, we're not allowed to keep any excess revenues. And for example, I have here in my notes some of the benefits of revenue decoupling. I'll just cite 2 examples. For Eversource's gas affiliate, Yankee Gas, we filed for the period November 15, 2018 through December 31st, 2019, at docket number 180510, a credit to customers of over $500,000. That was because in that year, we actually sold more gas than we expected. And so revenue decoupling said the credit of $500,000 goes back to customers. Another example would be for our electric affiliate from July 1st of 2019 to June 30th, 2020, and docket 171046, we returned a credit of $2.3 million to customers. That was because during that time period, sales of electricity were higher than what we projected. We could not keep the excess, and so that credit was given back to customers. And so we think it's a fair balance, revenue decoupling, between the interest of customers and also the interest of the utility companies. And we respectfully suggest that you keep the current language that says there shall be revenue decoupling, but we think it's fair to say to PURA, we will empower you to actually implement how that should be balanced between the utility company and also by customers. But we suggest you put guardrails to ensure Peoria has clear direction in terms of what your goals are for revenue decoupling. We'd be happy to submit some language for you to consider on that topic. I hope that responds to your question.
Absolutely does. And thank you. Looking forward to that language. Thank you, Mr. Chairman.
Thank you, Representative. Any other questions or comments? If not, thank you for your testimony today, and we look forward to further conversations on this difficult subject. Next up, we have Senator Berthel, followed by Dan Bosley from the Northeast Clean Energy Council.
Chairman Needleman, Chairman Steinberg, Ranking Member Fazio, Ranking Member Buckby, and distinguished members of the Energy and Technology Committee. I am State Senator Eric Berthel. I'm here to testify in support of Senate Bill 123. A constituent emailed me earlier this month after opening his electric bill and said, I was shocked by what I saw. My bill went from $255 to $372, $122 increase in a month. It will be even worse in the summer when it gets hot and I need the air conditioner to be on. In 1 year, I will be on a fixed income. Who knows if I will be able to pay this bill then with all my other bills. This is one of the reasons why people are leaving this state and are going to where it is much more cheaper to live. I hope something can be done to stop this. As the constituent noted, family budgets are breaking. I'm certain that you all hear similar stories from your constituents every day. Connecticut is one of the most unaffordable states to live in, with the highest energy cost in the continental United States. Wherever you go in our state, everyone is talking about how expensive their electricity bill is, and people are hurting. As lawmakers, we must listen to the families we represent and work to solve the problems they face. Connecticut can and must do more, much more, both in the short term and the long term, to provide families with relief. It is past time for us to take action to make energy more affordable and reliable. There is a better way to achieve energy affordability, and SB 123 represents several of the Senate and House Republican solutions aimed at reducing energy costs for Connecticut families, lowering rates both in the medium and long term, protecting ratepayers, and improving reliability for everyone. Some of those highlights, as you already know, include bringing all clean energy sources into the state's green energy strategy by adding nuclear power, all sources of hydropower, and trash to energy to the state's renewable portfolio standard program. Improving the standard service procurement process by eliminating the different ways Connecticut's large utilities, small municipality-owned utilities, and other states procure power. Giving PURA more discretion and flexibility in decoupling to protect ratepayers, and establishing utility rate case oversight to ensure that resolution of rate cases and settlements are made in the best interest of ratepayers and not for other political considerations. In conclusion, Connecticut's electricity costs have been far too high for far too long. Individuals are facing unbelievable choices in their life because they can't afford a basic necessity in this state. We can do better. We can meet the challenge, but we have to look at both short-term and long-term solutions. Senate Bill 123 is an earnest attempt to actually reduce people's costs and make Connecticut more affordable for everybody. It is not a political statement. It isn't pointing fingers or playing the blame game. It's a solution. It's a thoughtful plan, and it represents a significant portion of the ideas that we put forth in a better way to energy affordability. Good ideas find friends, and we believe those good ideas in Senate Bill 123 merit your support. Thank you, Mr. Chairman.
Thank you, Senator. I'm sure we all concur with you that anything we can do to reduce rates should be considered, and we appreciate the concepts expressed in Senate Bill 123. We're all trying to figure out what, if anything, we can do to have an immediate benefit beyond that, which you've already done for low-income households, in the context of the longer struggle we'll have in this transition away from fossil fuels. So we appreciate it. As you say, and any good thoughts at this point are open for consideration. Representative Buckby.
Thank you, Mr. Chair. Good to see you, Mr. Senator. Good to have you.
Likewise,
see you once in a
Thank
while. You don't get to see you as often these days. I want to thank you for not only the support and then well-worded statements, but on what I feel is a strong bill, but that's a whole other story. I appreciate how you opened that up too, because I don't think there's anyone here who hasn't received that letter or that phone call or that message or that text message or whatever it may be from our constituents. It's impactful that you bring that to the table for us too, because that's what we hear repeatedly over and over again. I think the voice of the people is being heard well, and I appreciate the fact that you brought that to the table. Is there anything you would add to this that isn't thought through in 1, 2, 3?
So, I think that we're not only dealing with residential consumers. We also hear, throughout our small towns and big cities across Connecticut, the effect of these energy prices on running small businesses, where now that has become a much larger part of the budget. When you're trying to stay affordable and profitable running your small business in Main Street, Connecticut. And now you've got energy costs that have gone up, it seems, looks like it's exponentially. It's not, but it's gone up substantially. And now you have to try and balance that along with many of the other things that we've done over the last few years that have impacted small business in terms of other mandates, not related to energy, but to providing, employment and some of the other things that are necessary. So it's not just residential consumers. I think it affects everyone, and even the largest consumers of electricity are feeling the bite of this change.
I think that's critical to keep in mind as well as we look at that impact on trickles down, right? Everything trickles down. So every consumer is still the one who's paying for that at their home, and now every place they go to shop as well. So it is tough on the homeowner, and certainly tough on those trying to support local business and all business, really. I appreciate it. Again, thank you so much for coming on. Thank you for the time, Mr. Chair.
Thank you, Representative. Are there any other questions or comments? If not, Senator, thank you for your time and for your comments. We appreciate it.
Thank you to the committee. Thank you, Mr. Chairman.
Next up, we have Dan Bosley from the Northeast Clean Energy Council, followed by Senator Summers. Apparently not. If he reappears, we'll consider going back to him. Oh, he's there? Okay. I don't see him. Okay, all right.
Thank you, Mr. Chairman. I apologize for I had to rejoin as a panelist. Thank you, Mr. Chairman, and through you to the members of the committee. For the record, my name is Dan Bosley. I represent the Northeast Clean Energy Council, and I'd like to address a couple of things in Senate 123 today. It's important that as we make changes, I agree with the last speaker. The senator said it's important to have long and short-term plans, and I think this is one of the problems that that we urge you to move with caution on this bill. First of all, changes shouldn't negatively impact programs that are working. Taking money out of the RPS to rebate to customers would do that. So we would urge you to be very cautious about doing that. And then secondly, small changes in Class 1 send tremors through the system. What this bill purports to do is make a large change by putting in nuclear and hydro into Class 1. That will have a very dampening effect on new renewables. And new renewables in the long term are the way that you're going to get lower bills, and you're going to get an energy system that actually works, that is that's distributed generation, that's closer to home, that creates jobs in Connecticut. So we hope that you would be very cautious about that. We do support the task force and look forward to the deliberations on the task force. And then finally, I just wanted to leave you with a story. I saw in the bill that you're actually splitting the bill out so that people understand what they're paying for supply, for distribution, for generation. And I think that's a good thing. In 1997, when I was the principal author of the bill in Massachusetts, I did the same thing. However, 2 years later, My sainted mother, God rest her soul, came up to me and said, I can't believe that you did this to our bill. I used to just pay for electricity. Now I'm paying for all this other stuff. So I think it's a good thing. I just think you need to be careful of what you wish for. Thank you, Mr. Chairman. I'm certainly willing to take any questions you may have.
Well, thank you very much, Dan. I think we take your point that it's not simply a matter of having a more transparent bill. It's educating and explaining it to people so that they understand what they've got. Since you are very much aware of really the sort of the whole New England situation, has any other state around us come up with a program that has had some sort of significant impact in the near term on rates, or are we pretty much all in the same boat?
We're pretty much all in the same boat. I mean, you know, there were programs where costs are going down, and there were people that are trying to figure out how to do this. I was just in Maine last week, and they've got a heat pump program where they've put in over 150,000 heat pumps. That has helped to drive the cost of energy down. However, the electricity for these things is still under a fossil fuel system. So I think as people begin to unplug from the fossil fuel systems, they are starting to lower costs, but it's slow, and it's kind of disjointed. Everybody's in a different position throughout all of New England.
Thank you for that. I don't see any other questions or comments, but we look forward to continuing to talk with you about both the short term and the long term. Thank you.
Thank you, Mr. Chair.
Next up is Senator Summers, followed by Francis Pallaro from Renew Northeast. All right. We will then go to Representative Porter, followed by Francis Pallaro. Except I don't see Representative Porter either. Why don't we go with Francis Pallaro?
Senators, Princess like
Oh, okay.
Pallaro. I'm the executive director of Renew Northeast. It's a pleasure to be back with you at the committee. I'm here to testify in opposition to two bills. Senate Bill 123. I echo the comments that were made by DEEP in response to the increasing the eligibility in the renewable portfolio standard to other resources. We oppose that. I think if the intent is to ensure that the price for renewable energy certificates is as low as it could be, the solution there, as I mentioned at the informational forum, is to ensure an adequate supply of new renewable energy resources that come on over the years ahead. And the best way to do that is for DEEP to actually use the renewable energy procurement authority that you've given it multiple times over the last 10 years. And that was what the point of that procurement authority was, to ensure adequate supply. So if you have adequate supply, you're going to have lower renewable energy certificate prices. The other bill that we're opposed to is House Bill 5223. This seems like a concept bill at this point. It's hard to really evaluate what the intent is, because the bill is basically just the statement of purpose, although Renew doesn't see any need, can't envision any possible need coming from this bill. And again, we would echo the comments that DEEP made in opposition to this bill as well. Specific to the mitigation fund, DEEP is working with, I believe, 9 other states to have a regional fund. And so it's not really clear what the purpose of this bill would be. So again, we oppose. And with that, I'm happy to take any questions.
Thank you for your testimony. On this last point, what would be wrong with Connecticut having somewhat different expectations and standards for offshore wind than other states in New England?
Well, I'm not sure what if the bill is proposing standards, is just proposing a fund. It's pretty vague on anything, but I know that DEEP is working with the other states on standards and a compensation fund. So again, I'm not really sure what the purpose of the bill would be, whether it's even needed. I've glanced at some of the testimony in support of the bill, that the testimony seems to be suggesting a whole host of other things that aren't even captured really in the statement of purpose. So, and I know there seems to be some pairing with some of the other offshore bills, which we also oppose as well.
Thank you. Senator Fazio.
Thank you for your testimony, sir. You said on renewable portfolio standard proposed changes, you said you echo the testimony of Deep as well as Mr. Bosley, but you also then said that you thought that this wouldn't reduce the price of credits, that the procurement process is a better way to lower prices, so lower prices of credits. So, but they seem to think that this would lower the cost of credits. So I'm trying to square the two interpretations.
So Senate Bill 123, as it's written, could absolutely lower rec prices. It could bring them to zero. You could just repeal I think the easiest thing would be to just repeal the RPS rather than have sort of a fiction of flooding it with other resources to essentially drive the price down to zero. By including these resources, you're essentially saying that you don't want the RPS, because the purpose of the RPS was to get new renewable resources built, class 1. Other classes were designed as a maintenance tier, if you will, for some of the hydro and the trashed energy. So if the intent is to use the class 1 of the RPS to incentivize new resources to be built, then the existing resources should be kept out. If the intent is to have the lowest rec price be zero, then you should just repeal the RPS.
I actually respectfully, I strongly disagree, because you want clean energy, you want more clean energy, and that doesn't mean that the prices are going to be high or low necessarily. It's dependent on supply and demand. But I think that also implies that you don't necessarily, if the energy is clean, that's what's important. And you should give reasonably equal weighting to all different types of the clean energy. But theoretically, you would want a world in which you're meeting that what's going up to a 48% requirement. That's pretty substantial. A 48% requirement, I think we can all agree, is substantial. That's where it's going. So that's positive if you can meet 48% with low prices. I think that's actually the best all outcomes. But it's not just about bringing on new energy. It is about bringing on new development. No, it's not only, because it's also
actually is. Class 1 is actually only about bringing in new energy.
It's also about keeping, the entire regime's also about keeping on clean energy, because it's an open question whether some assets get retired or not.
Right.
And, especially in a world where in the Northeast, we've retired 3 nuclear plants in recent history. And, we had the first reactor at Millstone go off, a generation ago. And then looking at what's happening in Europe and in Germany in particular, this is about adding clean capacity, about maximizing clean, reliable sources of energy. That both includes bringing stuff on, but also valuing existing. And you don't have these assets that have been brought on in the past 5 or 10 years suddenly no longer generating renewable credits. They're still generating credits under the program. The program could be designed that it sunsets for those assets, but it's not. So I think
I'd be happy to answer your question I don't know if it's just a comment, but I'm happy to address your question. I think the legislature has made wise decisions over the last number of years to keep the RPS class 1 separate from what the efforts that it did with contracting for Millstone and for Seabrook. And other resources. Massachusetts is looking at the same. So not disagreeing that the state wisely again decided to keep Millstone. There are some other assets in the region like small hydropower that are potentially in jeopardy that would benefit from Deep using the contracting authority. But I think the legislature again was smart to preserve existing clean energy assets using the contracting method. And I think the department explained this in its testimony, and to keep class 1 prices for new renewable energy resources.
Thank you for your time and testimony.
Yeah, thank you.
Thank you, Senator. Francis, is it correct to state that if the state had not contracted with Millstone for this long contract, the concept that they're presenting might make more sense, because we would not have eaten up so much just on the nuclear side?
Well, I think it would, and I think Deep got into this as well. I think it wouldn't make sense, again, to put it into the class one. If you look at Massachusetts, they've come up with, again, different tiers or classes, if you want. They have a clean energy standard that where nuclear is a part of that. So again, that state recognized, I think, what you're going through in this discussion right now, but they've kept the two separate. So just because new resources that are looking to get built don't benefit from a really low or zero price signal.
Thank you. Are there any other questions or comments? If not, thank you for your testimony. We'll look at your written testimony very closely.
Thank you. I appreciate the time.
All right, Senator Summers is up, followed by Liam Enia from Yukon Clean Energy Society.
I'm not sure who this is. I'm just move that over there. Is it still morning? Good morning. Representative Steinberg, Senator Fazio, Representative Buckby, and other distinguished members of the Energy and Technology Committee. I am here in lending support for HB 5223, which is an act requiring offshore wind developers to establish a compensation fund. I happen to represent Stonington Borough, which is the home to the last commercial fishing fleet in Connecticut. Years ago, the dock was filled with over 100 boats, and now only a handful survive. Commercial fishermen and the extensive supply chain that depend on them is vital to the New England economy. And I know members of this committee support commercial fishing as well as want to protect this historic industry and their livelihoods. We all understand that the offshore wind industry is an important part of a diverse energy portfolio and that we would like to see it grow while protecting our fishermen, the ocean, the animals that live and depend on the ocean and our coastline. This is why I urge support of HB 5223, which addresses bipartisan concerns about the unknown impact of offshore wind development that will have on our commercial fishing fleet and the environment. This legislation would set aside funds for protection of if our fishermen are displaced or if species experience jeopardy or harm, such as whales, migratory birds, and their migratory pathways. Money should be set aside for these scenarios that will most undoubtedly occur as we industrialize our ocean bed. Other states have done this. Funds could be used to create new habitats or nesting areas for birds, or if a commercial fishing fleet can no longer fish, which is a true and real possibility, they would be compensated for their loss of livelihood. The other thing that happens quite often is a loss of gear that gets caught up or damaged. They could be reimbursed quickly and efficiently. The former chair of this committee noted that 70% of the insurance claims being paid in the European countries are due to damage attributed to offshore wind-related underwater transmission cables. We know underwater cable technology is evolving and studies continue to better understand the impact on the marine animals and the underwater noise generated by the wind farms. Lastly, as part of the offshore wind RFP process, the state of Connecticut convened a commission on environmental standards to provide input on best practices to avoid minimizing and mitigating any impacts to wildlife, natural resources, ecosystems, and traditional or existing water-dependent uses such as fishing. I actually sit on that commission. The commission met for a month over 4th of July, I think it was 2018, and provided recommendations to DEEP to put out as far as environmental standards for their first RFP, with a mitigation fund being a top priority. Unfortunately, this recommendation was ignored by DEEP and it was not included in the RFP. You will hear that the DEEP is working with 9 other states, that BOEM is working on a compensation or mitigation fund, establishing one, but it is woefully inadequate. I ask you to think about our fishermen, our environment, and pass this common sense approach here in Connecticut. Thank you. I'm happy to answer any questions.
Thank you, Senator. This seems to be another instance where we have the tension between two good things, in this case, acquiring offshore wind and taking care of the environment. And we're struggling with finding the right balance on this. We appreciate your testimony. Yes, it does seem to come down to whether or not we as a state, which does not contract directly with the developers of the wind projects, are in a position to be dictating anything. So that's something we need to resolve. Senator Fazio.
Thank you, Senator Summers, for your testimony. Just two quick questions. To what extent do you think the commercial fishing industry in Connecticut could be displaced by the development?
Thank you for that question. You know, it's hard to say for sure, but I will tell you where the wind farms are going is one of the last places that our commercial fishing can fish. And having a house in Block Island, I can tell you, I know personally fishermen that have had their nets caught up on the cable that continually rises from the sea floor. It is not quick to have their gear be compensated. And if you lose netting, you can no longer fish. The fishermen in Stonington, which again is the last commercial fishing fleet really in the state of Connecticut, are concerned that we as a state are putting one industry against another without providing the adequate insurance that they need. We could absolutely put commercial fishing out of business completely with the wind farms. There's not enough room to maneuver between the spacing of the wind farms. There's other hazards besides just the wind farms that are out there on the ocean. And I think that establishing this type of fund would provide the insurance that this industry needs. Many of these individuals that fish so that we can all enjoy fresh fish or seafood here in the state of Connecticut, they're older. All they have as an investment is their boat and their license. So if we put them out of business completely, they have no value left in their boat or their license. That's usually what they use to be able to retire. And it's a strong and real concern. Look at what happens to fishing in the Scandinavian countries. As for
and last question, is there anyone currently working on a mitigation strategy, BOEM, anyone else?
Yes, I've actually sat on all of the BOEM informational hearings or input that they have gotten concerning establishing a mitigation fund on a federal level. The issue is that BOEM is following oil and gas, and what they do in oil and gas is, if you can imagine, you're fishing along the ocean floor, and if you happen to come upon a hazard as a fishing boat that has been become a hazard because of oil or gas, that area is then marked off as no-go. So you can't, one person gets a claim. If another fishing boat comes along and has a problem, that area of the ocean has been marked as you can't fish there. So what's happened is, if you look at the map, you'll see vast miles of the ocean are off limits for fishing, because if you happen to fish there and something happens, you're on your own. That's the model that they're looking to implement here for the wind farms, which is woefully inadequate for our fishermen.
Thank you, Senator. I don't see any further questions or comments. Thank you for your testimony. Back to public health for you. Next up, we have Liam Enia, followed by Representative Porter for the second time. Okay, doke. How about Nancy Chaffetz from Sea Power Energy?
Hi, can you hear me?
We can hear you.
Okay, great. Well, thank you for giving me the opportunity to testify on Senate Bill 123. I am Nancy Chaffetz from Sea Power, and Sea Power is a demand response and distributed energy resource service provider. So we help customers save money and support the grid by curtailing their electricity during periods of peak energy usage and system stress. We fully support Senate Bill 123's mission to reduce costs to consumers, but we're missing something. An amendment could help save ratepayers even more. And that change is requiring utilities in Connecticut to assign ICAP tags based on interval meter data for customers with interval meters. So what does that mean? An ICAP tag is the amount of the system's annual peak electricity consumption that is a customer. So there's a single hour each year where electricity consumption peaks, and each customer is assigned a share of this based on their consumption. And the reason for this is that is the basis for how ISO New England allocates out a big bucket of cost called capacity. And if you're not familiar with ISO New England, they administer the wholesale electricity market. To give you some idea of the cost we're talking about, the most recent capacity auction, the estimated total price tag for that is a little over $1 billion. So that's a billion with a B. So it's a lot of money we're talking about. Now, to our knowledge, every large utility in New England, which is really just Eversource and United Illuminating, or UI, those two, with the exception of UI, calculates ICAP tags based on interval meter data where that's available. So Eversource does calculate ICAP tags based on interval meter data. UI doesn't. Every other utility in New England, as far as we know, uses the data where it's available. What UI does is they calculate ICAP tags based on an estimation method called profiling. So they do this even for customers that have the meter data. They have the interval meters, and you can see exactly what they used in the peak hour. They use an estimation method instead. What this means is that customers in the UI territory don't have the ability to reduce their allocation of capacity costs by curtailing their consumption during periods of high electricity usage. So this removes a really powerful incentive for these customers to curtail electricity on those hot summer days when the system's peaking and the grid's experiencing stress. Why this matters is not just because these customers can't reduce their costs, but when customers curtail consumption in Connecticut, it reduces everybody's capacity bill in Connecticut, not just those customers, because it reduces the collective peak demand in the state, and thus that capacity zone that the state is in gets allocated less of the total capacity bill. But also, I think obviously those kind of reductions reduce carbon emissions also by reducing the need for fossil generation. And they also help the grid to operate reliably when electricity demand is high. So C-Power is proposing that Senate Bill 123 be amended to require all electric distribution companies in the state to assign ICAP tags based on meter data for interval meter customers. If you have an interval meter, then your ICAP tag is calculated based on your meter data. This only affects UI. Eversource already does this. This change will deliver cost savings to all customers in Connecticut. It will reduce carbon emissions, and it will contribute to improved reliability. So we did propose specific language, and it's in the testimony that we submitted on Monday. So I hope you'll take a look at that. And I'm available if you have questions.
Thank you for that. You've introduced a new idea that we had not heard about before. Do I take your statement to suggest that the state of Connecticut can unilaterally make such a decision without the collaboration of surrounding states or ISO New England's permission?
Yes, this is something actually that's on a utility by utility basis. So you can do it however you like.
Are any other states currently using that standard?
I don't know of any utility that doesn't use that standard besides UI in New England.
All right, we'll look into this. Representative Metzger is followed by Representative Greshko.
Thank you very much for your testimony. I want to go back to it and understand it in more profoundly.
Okay.
Are you telling me that there's 1 hour a month in peak demand that designates roughly $1 billion of cost in distribution?
It's 1 hour a year. So it's the peak hour in the year prior, is what ISO New England uses to allocate out capacity costs to individual capacity zones.
So the real issue is how we can reduce that peak demand.
Right.
Such a state that we save $1 billion.
You won't save $1 billion. Well, $1 billion gets allocated.
That's what I understood. So you go ahead.
You'll reduce the amount of the $1 billion that gets allocated to Connecticut.
So some percentage of the peak demand will go to Connecticut, regardless of where my demand is at that point in time. So I don't know if you can do that, but that's going to be the question that
I didn't understand the last part of your question.
So what I understand is some of the peak charge of $1 billion, we can reduce the percentage that's allocated to Connecticut.
Yes. And I just want to be very precise, is you can reduce the percentage that's allocated to the capacity zone that Connecticut is in, and Connecticut is in rest of pool, which is usually lumped in with West Central Mass too. But nevertheless, you can reduce the amount of dollars by reducing your contribution to the peak hour.
So the peak hour costs the whole grid $1 billion of ISO New England. And the question is the allocation of the billion. So I guess at the margin, that's my question, is the reduction in the zone I'm in for reducing that demand is going to turn into a 50, 100, 200, what's the materiality of the reduction in peak that we're striving for financially?
You know what? That's a really good question. I haven't crunched those numbers, and that is something I can take back and sort of say, if you could reduce this much, this is how much you could save. So can I take that back as homework?
Well, I'm glad one of us is taking it back. And frankly, I think you're more capable than I. So I would appreciate that.
I will take that
because
back.
If the question of the saving is going to drive the policy. If the saving isn't material, then the effort isn't worth the effort. If the savings material, then it's worth the effort.
Yeah, I agree with you. I do want to just say that in every other state in New England, you will find everybody is chasing the peak because they are real savings. And to the extent we're not doing it in Connecticut, we're getting cost shifted to us.
Yeah, and I understand conceptually peak demand requires us to maintain excess generation capacity, which we turn on for a week or the hour or the month, and we turn it on, we pay for it for 12 months because we have to guarantee the investors a rate of return to have that peak demand available.
Right.
So I am interested in reducing peak, but specifically on if I'm shooting for the hour, I want to know what it's worth.
Okay, I'm going to get back to you on that with some numbers.
I appreciate it. Thank you much. No more further questions. Thank you, Mr. Chair.
Representative Greshko, followed by Senator Fazio.
Thank you, Mr. Chair. Representative Meskers asked my homework question, but I'm going to follow up on that. This is a comparison question. You said United Illuminating is currently doing this. Has Eversource or another ED done this in the past and then decided not to do it? And then how much money savings are we talking about? Did the state of Connecticut realize from that?
That is a really good question. I don't know the history on whether Eversource ever used profiling for interval meter customers. I can take that one back as homework. I don't know if I'll find the answer, but I will try. So I'm going to add that to my list. And then I think your other question is how much can we save? And I think that's also on my list.
Okay, homework assignment number 2. Thank you.
Thank you, Representative. Senator Fazio.
Thank you for your testimony. It was informative. I read it yesterday, and you know, it definitely requires us to learn more. Just to clarify, the $1 billion is in capacity payments. It's not in the cost of generation.
It's capacity payments.
So there's more savings there than
that's right.
Than would even lead on, you know, if you think about generation. So that's significant. And you know, I guess the other thing I think about is okay, if you have one utility doing it and one not, it should be a little bit easier to understand what the savings are potentially to costs and consumers. So this is certainly the start of a conversation, and I appreciate your testimony.
Thank you.
Thank you. We were hoping that we'd come up with some ideas that nobody else had thought of. So this is very intriguing to all of us. Thank you. And we will definitely explore this with you further and see if we can integrate that into legislation if it makes sense. I don't see any other questions or comments. Thank you for your testimony today. We will be in touch.
All right. Thank you so much.
Representative Porter, who I don't think is here, or Representative Hughes or Representative Chalesky. Chalesky's here. Excuse me. I didn't see you in the corner. Welcome. Followed by Christopher Bachant from NASRCC.
Good afternoon, Chairman Needleman, Steinberg, ranking members Fazio and Buckby, and distinguished members of the committee. I am State Representative Rachel Chalesky of the 138th District, a large piece of Danbury. And in my city and across the state, there are many family-owned and operated fuel delivery companies who are small businesses providing a service to our community and working to support themselves. I want to thank you for raising HB 6056, an act concerning payment to vendors participating in the Low Income Home Energy Assistance Program, or LAHEAP. When it concerns these vendors' participation in the program, there seems to be several issues, but essentially they are losing money as a result of their participation in the program due to a formula that fails to adequately reimburse them. There are many variables impacting the cost of doing business in this volatile market. The DSS calculation does not take into account supply that may already be in their possession or on their delivery trucks, the constant rotation in order to keep supply fresh, varying differentials across counties if purchased in one county and delivered to another, and posted prices that will be paid for delivery are not posted until after 3 p.m. that day. This bill would provide a greater reimbursement to fuel vendors in times when delivery costs are especially high due to the cost of fuel. And it's my understanding that in other states, the fixed margin for their programs are set at 75 cents per gallon, while the fixed rate for Connecticut's is currently 50 cents per gallon. The LAHEAP program is a valuable resource for households in need. However, we must also recognize the difficult economic times that these businesses are also facing. Again, they are small businesses owned by families, deeply rooted in our communities, humbly living in our neighborhoods, and employing other residents. Ultimately, these businesses will not turn away current clientele that fall into the program just out of a moral obligation. But there's no incentive to add new clients from within the program. So I urge this committee to vote in support of this bill, helping our small heating fuel companies and the many LAHEAP participants who depend on them. Thank you very much.
Thank you for your testimony. One of the suggestions in that bill would to reduce the period of time in which they're compensated from 30 days to 5 days. Is 5 days really practical for turning around those payments?
That I'm not sure. I know that the president of SEMA also provided testimony in which he describes, how other states handle that. And I have it right here. New York, Rhode Island, and Vermont are all prepaid deliveries. Maine has 10-day payment terms. Mass and New Jersey also have 30-day terms. There are also other asks in his testimony, such as EFT payments. I don't think that's an unreasonable ask, especially in today's world. It might be more efficient and cost saving as well there.
Thank you. We do appreciate the fact that a lot of these mom and pop oil companies struggle when their compensation does not keep up with their outlays, and we feel for the dislocations that creates for a lot of companies. We've talked about this for a number of years. Any other questions or comments? Yes, Representative Buckby.
Thank you, Mr. Chair, and thank you for your testimony. We covered this. I also sit on the Human Services Committee, and this is a topic that's come up there as well, as they're finding fewer and fewer delivery people that want to participate in the program simply because it's costing them money to participate in the program. So it makes it more and more difficult for especially the smaller companies that you mentioned to step in and do so. So I think it's an important piece that you put forward that we can try to address from both sides. I don't believe the Human Services Committee is maintaining this piece of this legislation. I could be wrong. I think they felt it fell more under our bailiwick than theirs. So something for us to definitely take a deeper look at. I'm curious to see how many others put forth legislation on this, but I did hear from local people in my community as well. Fuel oil companies are having trouble with this as well. And I think what you mentioned with EFTs is probably the smartest way to go about this. And I think it's time we kind of step forward and catch up with the times on trying to be able to help out these families the right way. And I think that's probably the best way to do it, make sure that all are fairly compensated. So I just want to thank you for providing the testimony. I think it's really important that we take a deep dive in this. Thank you, Mr. Chair.
Thank you, Representative. Any other questions or comments? If not, Representative, thank you very much for your testimony today. We appreciate it.
Thank you.
Turns out number 18, Liam Enia is available. So we'll hear from Liam next, followed by Representative Michelle, unless any of the other representatives who showed up.
Thank you, everyone. I apologize for my tardiness. I was racing from stores. Honorable Co-Chair Senator Needleman and Representative Steinberg, Vice Chair Senator McCrory and Representative Foster, Ranking Member Senator Fazio and Representative Buckby, and distinguished members of the Energy and Technology Committee. My name is Liam Ania. I'm a Brookfield resident and an economics major at the University of Connecticut, speaking here as a private citizen. I ask you to support SB 123 with a small amendment. I believe SB 123 is a rational step towards lower electricity costs by providing PURA with greater independence, oversight, and power and revenue decoupling. It helps keep our vital and reliable nuclear and hydropower resources online. And it also establishes a task force to study various power procurement methods and the adequacy of the natural gas pipeline network. I would like to propose amending Part 5 of the task force's charge to include, and I also included in my written testimony, studying the effects of a natural gas capacity market on electric generation rates and identifying best practices to minimize the effects of gas price volatility on electric generation procurement. I believe Connecticut's and New England's winter energy woes take root in a disconnect between the gas and electric industries. Gas transmission owners will only expand their capacity on the basis of firm, long-term revenue streams from residential and commercial customers, which is why so much pipeline development happened in the 50s and in the 90s. And this is despite the paramount needs of over half the grid's generation fleet. This conclusion that I found evolved from FERC's Winter Gas Electric Forum that was held last September in Burlington, Vermont. So though this winter has been unseasonably warm, during cold snaps and blizzards, vital gas-fired generators may not have ample fuel supplies due to residential heating demand, meaning they can't satisfy all dispatch orders. As a result, some dual fuel capable gas plants have to burn oil. Coal and oil peaker plants, often located in historically marginalized communities, ramp up. Wholesale electricity prices rise, and the grid operator has less flexibility to meet loads, raising the risk of blackouts. The energy cost burden hurts at-risk residents the most. Last November, I wrote an op-ed in the Hartford Courant proposing a solution, a natural gas capacity market. Its incentive structure would give more gas-fired generators the wherewithal to procure fuel in the long run based on the supply obligations awarded to them through New England's analogous electric capacity auctions. The goal is to tame regional pipeline gas prices and lock in gas supplies so that the wholesale electricity markets can function as engineered. I believe this would enhance grid reliability, lower rates, allow coal and oil peaker plants to retire safely and responsibly, and fortify Connecticut's carbon reduction goals, whose projections rely on the assumption of a half gas-fueled grid today. It has never been tried before, but I believe Connecticut, facing among the nation's greatest energy challenges, should consider exploring the idea of a natural gas capacity market through this task force as part of its charge, and seek public policy avenues if deemed viable. So thank you for your time, and I hope you'll consider this amendment to SB 123 and supporting the bill with that amendment. Thank you. And I can take any questions that you have.
Thank you for your testimony, and we're glad that you safely raced here from Stores to join us today. Senator Needleman.
Thank you, Liam. I'm not sure racing is the appropriate word. You're a student, you get pulled over. We don't want to be responsible for that. Anyway, I saw your editorial and I thought your idea was interesting. And you've clearly, I'm impressed that you've demonstrated a real understanding of the pitfalls in the market. The idea of a capacity market for natural gas is good. I'm not sure we would control that as much as ISO would control that and whether FERC would allow it. But the issue comes down with natural gas, it's the storage. Where do you put it? If you create a capacity market, you got to have a place to put the natural gas, and natural gas more than any other fuel really is just in time. That's, I think, a big part of the problem. And this is an interesting proposed solution that may allow the generators to build capacity on site for storage. Again, the pipeline is not fully utilized during the summer. It may get to be more utilized during the summer as we increase demand for electricity unless renewables come on much faster. So this may work. I think there's a limit to the amount of storage that you could put, for natural gas, not the most desirable thing to have in your community next to your power plant. But it's a great idea. And what I really wanted to say is I'm incredibly impressed at how much time and effort and understanding you have in the market. And you should run for office and come here and get on the energy committee like as soon as possible.
Thank you, sir.
When are you graduating?
Next year.
He's from Brookfield.
Next year, right next door.
Yeah, that's right. You're gonna come together. Anyway, thank you again. I really, warms my heart to see young people really diving into the details of an enormously complicated issue. So thank you.
Thank you.
Thank you, Senator. Representative Foster.
I am just going to quickly second Senator Needleman. You'd be amongst many BHS graduates at the Capitol, including Senator Harding and myself. So you should consider bringing your expertise our way. So thank you so much for your testimony today.
You representative.
Senator Fazio.
Thank you for your testimony. And obviously you've been inspired by what you see as a success. One of the successes, not everything is successful that they do, but of ISO New England's capacity market to ensure that there's adequate supply during times of peak demand. But I think it's very important that part of your goal is to reduce burning of oil, which is far dirtier than natural gas during times of peak demand. And those are the two, marginal fuels that are dispatchable. So I appreciate not only that you want to reduce costs, but also that you have this strong environmental interest in your proposal as well. And just finally, I want to second what my colleague said, that, it just goes to show that anyone can step up and provide good ideas. And, this is not something we thought of originally, but because of your consideration, it's now something that makes a lot of sense to include, in my opinion, at least. So thank you for engaging us in your testimony.
Thank you, Senator.
Representative Greshko, followed by Representative Meskers. Everybody wants to talk with you now.
Thank you, Mr. Chair. Liam, I've long been interested in the natural gas capacity market. So I did get a chance to read your op-ed, but in a practical sense, let's say that the natural gas capacity market existed here in the state of Connecticut. Run through a quick scenario of how it would function and the goals that it would attain here in the state of Connecticut. Kind of take it off of the 30,000 foot level and how would the boots hit the ground? How would it work?
Well, I do think part of the issue is that this, by the nature of our grid, has to be a regional effort. Because if there was only a capacity market in Connecticut, clearing prices are still going to be set by other marginal factors that from power plants that might not even be in Connecticut. So I think at a minimum, from a conceptual standpoint, it would create a system of incentives that would allow the pipeline system to either expand to the needs of the current installed generators at all times, or provide some storage capabilities. And I know when it comes to storage, we have our own, LNG issues with the Everett terminal, not being the most viable option in the long term from a reliability standpoint. So, it would just, if I was to run through a basic scenario, let's say it's a cold winter day and there's tons of demand on the grid. The idea would be, if you're a gas generator, you will already have that capacity locked up in some form, and it would take more than a few years for this all to work. It's just by the nature of capacity and using incentive payments and getting projects through. It would take a few years, but the hope would be, if you have a gas plant and you need to operate at a crucial reliability hour, they can, and they don't have to worry about switching to oil, a day before and creating all this mess in the energy markets. And any questions, by the way, specific to ISO New England would have to be referred to Eric Johnson, who's the Director of External Affairs.
Thank you, Mr. Chair.
Thank you, Representative Meskers.
Yeah, thank you very much. I thought your proposal was very interesting. In pragmatic terms, what we're talking about are two things: either an assessment under your plan, either an assessment to build more permanent infrastructure in a gas pipeline to expand the supply year-round of natural gas, or the other alternative is the potential to find some kind of an assessment within the grouping of ISO New England to build liquid natural gas storage. That's basically what we're working out to in your proposal, right? Okay.
To that extent.
Because, I think installed capacity, given our goals on decarbonization, might be an issue. And the issue of liquid natural gas, there's always the possibility that liquid natural gas at some point, depending on when we get to green hydrogen, that liquid storage could be reverted to another storage of a cleaner energy. So I would be probably less opposed in theory to natural gas storage. But those are the two suggestions of the resolution to the issue, right? I just want to make sure our listeners, because it was very technical and I had to boil it down for myself, and I thought I'd boil it down for our listeners. So I thank you very much.
Thank you, Representative.
We always appreciate your efforts to make it accessible for everybody. Representative Buckby.
Thank you, Mr. Chair, and I apologize. I stepped out to grab some snacks to bring back in to get me through what's been a crazy morning already. So I apologize for missing your initial piece, but I've been reading through your testimony here as well and listening to you speak. I appreciate, first off, making it in here. I heard there was a rush to get in, and while I don't always support a Bobcat when you're a Green Wave guy, that's a whole other ballgame. So
we don't go there.
But I don't think we're facing each other on the football field either. So I think we're okay. I wanted to point out, I enjoy the ideas. I like the concepts. I love that you're engaged and want to be a part of this. I think that's critical. We mentioned with, I think it's tough, aside from maybe Senator Fazio, how many people are within a 10 to 15 year market of your life. Nothing personal. It's, we're close. Mentally, you're older. That's all. I'm trying to dig my shovel back out. Anyway, I think the critical piece of your testimony, I want to thank you for, though, is toward the end. There's a big piece of this, especially when it comes down to Connecticut and energy. There's a lot of concern. There's a lot of people who are very upset who've been talking to us. You'll get over it. You'll be okay. Look, I'm wearing your daughter's bracelet. I'm happy with it. So what I want to say is, in there you put, I believe in Connecticut. That's a critical thing for us to hear. We hear a lot of negativity all day, every day, from a lot of people, a lot of constituents who are rightfully upset. But I can't tell you how encouraging it is to have someone come in here to say, I have ideas. I still believe I want to be a part of the solution. And again, not to offend anyone else in the room, because I'm good at that today, but someone who's not a lobbyist, someone who's not directly involved on that side, someone who is not from one of the utilities, coming in here and saying, look, I believe and I want to do this, and someone who takes the time to do that deserves a lot of credit for stepping up here and doing so. So thank you for doing that.
Thank you.
Even though you are a Bobcat, we're good with that. Thank you, Mr. Chair.
Thank you, I think, Representative. I'll just end by stating that it's wonderful to see somebody who's chosen to become involved, but to choose this subject area is way above and beyond the call, because most legislators don't want to know about this. So we really do appreciate it. And seeing no further questions, thank you. Please take a safe, more relaxed trip back to stores, but we will take your thoughts very much under consideration.
Thank you, members.
All right, next up, we have the last of our elected officials, David Michelle, followed by Christopher Basham.
Thank you, distinguished members of the committee, distinguished chairs, vice chairs, ranking members, for giving the opportunity to speak on some bills. I'm here today testifying in favor of proposed House Bill 5223. I'm also asking to change the language if possible and to add the intents of 5221 and 5222. And I'll go into a little bit more details. 5222 is in regards to the Commission for Environmental Standards, of which I'm a member of. Currently, the language seems to allude to for each procurement, there will be a offshore wind commission. It doesn't make much sense. And we're asking for just simplifying the language that came out of energy in 2019. Now, in regards to 5221, 5221 would basically bring environmental standards and labor creation standards in the bidding process. And also another part would bring in noise limits in statutes. Now, why am I pushing for this, and why that? In 2019, when we passed the second procurement of offshore wind, it seemed that we were doing this without any standards, and there are other countries in the world that are using standards. Offshore wind has been going on for over 30 years in Europe, and specific countries have started updating their standards, environmental standard and labor creation standards, to ensure environmental stewardship and also to gain the best. If we think about it, we are going to be paying for energy where we could actually benefit from constructing the infrastructure for creating that energy. We have, I believe, this is one way of doing it. Countries, again, other people from the industry have commented that we didn't have standards here. And I think that we should stand up for our state, stand up for our labor, stand up for our environment, and putting some standards like other places have done it. This will also help, of course, with protecting biodiversity and also with vulnerable and valuable marine species. If we were to do this or something like this, we would become probably the leader in North America in innovation in renewable infrastructure. And I think it's an opportunity we should really grab. And that's it. I think that's it.
Thank you, Representative. You alluded to a couple of bills that are not currently before the committee, but we would like to at least discuss more broadly the opportunity that offshore wind offers Connecticut and the New England states, and yet be very sensitive to the environmental impacts. We've heard it said that the state of Connecticut does not contract directly with the developers of these offshore projects, and therefore we're not in a position to independently of other states or those who are involved for setting terms, so to speak. What's your response to that?
Well, you can hear my accent. So I'm often in communications with the industry and also the industry in Europe. And I know that, again, some developers have been bragging the fact that we didn't have standards, and this was making it much easier for them here. I think it's a game of poker, to be very frank and honest. And I don't see why the developers would not build something they've already built in Europe, such as, for example, concrete gravity base. They've done it over there. Why not here? And why not build our job, bring the manufacturing home and build our own infrastructure rather than bringing in steel from Europe? And I used to sell steel for Sheffield Forge Masters, which is the biggest forge in the UK. And I represented them and sold their steel to Patriot Forge in Canada, as well as Liberty Forge in Texas and other forges and distributors. And I can tell you that steel will never be made here. That steel is not going to come from the US. So putting standards certainly will help us with bringing the manufacturing home and protecting the environment. And the same standards are being used in Europe have not turned down the developers from bidding. I don't see why they would refuse or abandon or not go for a bid when they're going to make billions of dollars.
So I'm not an expert on steel production, but I would assume that the developers have significant investment in assets in Europe to produce the steel there. And the US steel industry has gone through some real changes. Is it realistic to assume that we could be doing that production here in the States?
No way. This kind of steel is not going to be manufactured here. I used to sell ingots, the primary steel, ingots of steel from the forges in Europe, from France, from not only Sheffield Forge Masters. And I can assure you that steel is not going to be made here. When you hear about manufacturing steel here, and I'll let the experts, there's experts coming up soon, actually next, and they can talk more to it. But when we're talking about factories here in the US, we're talking about bringing steel from Europe, not manufacturing the steel here, and using automated machinery to put the pieces together or to roll it. And I don't see much for us. Again, we're going to be paying for that electricity. So we should be gaining from the production of that energy if we can. And I think we can, and it's right in front of us. And I think we have a shot at it and we should take it.
So just for clarification purposes, you're proposing that we do not take advantage of European steel. What would we replace that with?
Well, we have concrete manufacturers in Connecticut, for example. I'm sure they'd be happy to take the jobs. We're talking about literally creating jobs here, not in Europe, not participating in the European economy. And I know it sounds funny to hear this from a French guy with a thick French accent who used to sell European steel. But again, we have manufacturers here of concrete, low carbon concrete. There's ingenious ideas out there. We can use the unrecyclable glass and use it in that concrete. We could become the hub, really a very serious hub. And there's interest out there for other applications for us, Connecticut, to build concrete gravity base.
How do you respond to the contention that shouldn't the developers know best what technology they'd want to use in any specific location?
Well, they certainly know best when we see that the developers have been using this various techniques in Europe. Why not here? It seems the focus here is only to bring European steel. I've been sitting, I've sat at, I don't know how many presentations from the offshore wind industry in the last 4 years since 2019 stat procurement, and you barely or rarely ever see the drawings of another type of footing like the concrete gravity base. It's all towards steel. It's again, I think it's a game of poker. I think we don't have to play poker. We can just do what is right and do what we need to do for our state in the production of energy and make sure we gain the benefits from it and not end up with, very few jobs or et cetera.
Thank you. Senator Needleman.
Thank you, Representative Michelle. I appreciate all of what you're saying. And obviously, I don't think there's anybody in this room that if all things were equal, we would want to have the most local jobs and the most local manufacturing for the product that we want to install. But we also understand that there are cost implications, there's topography implications, and I'm not sure how, although I did have a good meeting yesterday, how we actually prescribe how to do it. I mean, that's DEEP's responsibility in terms of we did the procurement and they're working on the method. But I do think that it's important that we remember that cost matters here. And I think that we need to make sure that we have the most cost efficient way to put the wind energy out there, because ultimately, if we prescribe methods that end up being either inappropriate for the topography or more expensive, the ratepayers will pay the price.
Thank you, Senator Needleman. For cost efficiency, I mean, let's bring it to the table. The most we're talking at the beginning of production, a difference in cost of 3%. And I'm not talking about the benefits we get from that, from using that technique. The benefits to the state for the 30 times the amount of jobs as it's showing in the tough study. That's revenue for the state. That's a lot of revenue for the state, as a matter of fact. And in terms of cost efficiency, would we rather pay for electricity? Let's talking about cost. Would we rather pay for electricity where we gain absolutely no benefits? The difference in cost of 3% that I mentioned would dramatically drop very soon after, because that cost is really invoking the building of the infrastructure needed for the manufacturing chain. And so that cost will drop.
Well, I don't
quickly.
I don't proclaim to be an expert in the cost analysis here, because I haven't done that study, and I know you feel comfortable in your numbers. But I would think that the legislature itself, just as a matter of principle, may not be the best ones to assess that. There should be studies done. We should, like I said, all things being equal, we want the best and most environmentally sound product, and we want the most cost efficient process, and we want one that works for the topography of the offshore areas off of the East Coast, which is different than it might be on the West Coast, different in parts of Europe, different off of the United Kingdom. So I'm just not sure that we have the expertise to put our finger on the scale of that decision making, but you certainly bring up interesting points, and I thank you for all the hard work you've done on this.
Thank you, Senator Needleman. If I may, I was just going to say, we have to think that this is probably not an opportunity that will last for a long time. And others are looking at what we're talking about. This has been done legislatively in other countries. Because it's new here and it's been done for 30 years in Europe, that's where we need to look. And we need to look well, because they have their own issues with developers making grand offers, guaranteeing jobs and protection of marine life. And it really wasn't the end result. And that's why now some of those countries have standards. And that's why we should really look and consider what other countries, other places that are familiar with this are doing. That's where the expertise is. Thank you.
Thank you, Representative. Representative Mashinsky.
Thank you, Mr. Chairman. I wanted to ask you, David, the decisions in Europe, were they driven by the topography of the ocean bottom or noise concerns for the cetaceans, or both?
Thank you, Rep. Mashinsky. Nice to see you. I guess the best answer I think I should give you is that right now there's more and more concrete gravity bays being built. Right now, for example, in the southwest of France, in Fécamp, also in Scotland, countries are just, I think until a few months, or maybe I think it was about 10% of all offshore wind farms that were built on concrete, but I think most other facilities in the ocean are built on concrete. So I think the driver here is the jobs and the environment. There is right now something, if you think about pile driving, that noise level that will be done here in our side of the Atlantic, because Germany put a noise threshold limit, but that's to protect porpoises, harbor porpoises. We have North Atlantic right well, sea turtles, lobster. We have a huge biodiversity, much bigger and much more sensitive than Germany. So knowing that was their response, for example, to put a noise threshold, and then there are labor standards also, for example, in Scotland. I think it's fascinating, and I think that we should not miss the opportunity to do what's right.
Okay, so you're saying that both those factors entered into the decision by European countries to head toward the gravity-based rather than the other version, right?
Correct.
Okay, thank you.
Representative Buckby.
Thank you, Mr. Chair. I have to say, Representative, I've said this before. I think you've lobbied for your bill more than most lobbyists lobby for theirs. The amount of, I'm just concerned the amount of paper that you put forward, how environmental that may be. But I do appreciate, I think you put some great ideas forward for us that we should be taking a look at. It is a truly, I think the good chair would agree with me. It's a multi-purpose effect. No, you don't agree? Okay.
Ooh, that's good.
But that one stings a little bit. Trying to wake up the crowd a little bit. It's been a long morning already. So no, I just want to say thank you because you've given a lot of good information, and I think it's truly is hitting on economic issues, environmental issues. I think it's sound solutions across the board. Notice I did say sound in the sound. No, nothing on that one. Okay. No, there's no limit.
Noise limit.
There's never a limit, right?
We're at it.
Wow, she's just wailing away on me. Okay, thank you very much. I appreciate it. Thanks again for coming in and for all the,
I
all
can
the
add,
information you provided.
but Bugby, I can talk a lot about whales if you want, but I'll spare you. I think you've said it.
You know, I used to think that we needed a hook for some people who are testifying. We may need one for members of the committee. Okay. Thank you, Representative, for your testimony, and we will now segue to a continuing conversation.
Thank you, Mr.
As
Chair.
we have Christopher Bichant up there, and I was wrong. We do have some legislators who have yet to testify. So next up would be Representative McGorty after Christopher.
Well, good, this thing's on. I didn't know how to turn it on. First, I want to say thank you to Honorables Steinberg, Needleman, Buckby, Fazio, all of the members. I actually am a little upset because after hearing Liam speak, I'd rather have him up here than me because that kid is damn good. That kid's got a future. I'm here to talk. My name is Chris Bichant, and I am the business representative for North Atlantic State Regional Council of Carpenters. I represent 31,000 carpenters and pile drivers in New England, specifically 3,000 here in Connecticut. I come before this committee to support of the proposed House Bill 523. It requires offshore wind developers to establish a compensation fund. Furthermore, I'm asking to expand the language to adding the intents of proposed House Bill 5221. My specific part on this really because is labor. I'm a unique anomaly, I guess, because I believe labor and environment in this particular issue, maybe in a lot more issues, work together. I want you to think about the size of this next pile that's coming. The mono pile, you can put this room in. It's 32 feet in diameter. I just got a picture of the newest one from Germany. Germany's bragging that it's the first of many that they're selling to the United States. It's 1,880 tons of cold rolled steel. That creates no jobs for us. Right now, as we sit, and I want to get into a couple of things, but as we sit here right now with Revolution Wind, I'll use Revolution Wind because that's Connecticut, Connecticut and Rhode Island. We in the building trades were really anxious. We in the United States were anxious. We saw the possibility, the potential of a lot of jobs in construction. It starts out with, if you look at a website, the Connecticut State Pier, of which I oversee all the pile drivers on that job. We were under the impression, and it's in the website, that there were going to be 465 jobs. At peak time on the Connecticut State Pier, we had 150. At one time, if you add in engineers and all that, maybe it reached 200. Fell short of the 465. In addition, it says at the State Pier, for the erection of the towers, of assembling the towers, it was going to make approximately 1,200 jobs. We had a meeting 2 weeks ago of which 5 trades, mine included, are signing a 5-trade agreement. We got 40. That's a hell of a lot shorter than 1,200. I don't mean to sound upset, but I am. I serve this country. I represent workforce in this country. And I think this is our house. I think we should have a say in procurement on how and what we want built. I was the general foreman for the 34 flyover bridge in New Haven. I started as the general foreman for the Q Bridge, and then I got moved on to a different job. I've worked a lot of jobs in the state of Connecticut, a lot of bridges. I've done a lot of pile driving. I've done a lot of bridge building. The state has always told us what they want on that bridge, the materials, etc. They control how many people we put on it. That's all part of the procurement. That's what we do. I don't understand why this should be any different. There are a lot of different, and I'm not here to talk about technologies. I'm not that kind of person. But there are a lot of different types of technologies that would allow future and further job development. We just have to ask. We have to dig into that, and we have to decide what is it that we want. Right now, we're investing billions of dollars into towers that in 25 years are discarded. That makes no sense to me. That's like saying we're going to build a Q bridge and we're going to use these particular materials, and 25 years from now, we're tearing it out. That just doesn't make sense. There are other alternatives where we could have wind towers that we continue to use the foundations. And I think that it's really important that everybody understands when you're building a wind farm, a wind tower, there's basically only a few components. You have a foundation, you have a transmission line, and then you have the tower, the turbine, and the blades. From the surface of the water, regardless of the foundation type, from the surface of the water up, those are fixed jobs. It doesn't matter what the foundation is. The tower is the tower, the turbine's the turbine, the blades are the blades. There is no opportunity to change any jobs in that part of the construction. Leaves us only one other place, foundation. To me, again, we're new to this. It's a new and budding industry. We're learning every day. We can't change what's already been procured. But I think if we add some things and incorporate this bill into the procurement process, that allows us to put some contingencies in there that do benefit the workforce here in Connecticut. And I think that a lot of states, I've been involved in offshore wind for 5 years now. I've been to Europe several times. I've met with Europe labor. I've met with UK leadership. I've learned that in the UK, where they have a vast amount of offshore wind, what I was told by multiple people, it's taken them 15 years to undo what they failed to do in the beginning. And that was set standards for labor, for local workforce, local content, local supply chain, of which right now we have none. Everything is coming from Europe, everything. And my question is, what are we going to do about it? We have a chance to do something about it. You folks have a chance, and what you guys do, I applaud. How you do what you do every day, how you can sit in one of these things all day long is beyond me, let alone anything else. But the fact is, you are our leaders. That's what we elected you for, to help us. And you have a chance, regardless of what your decision is going forward after today, one way or the other, it's going to be an infamy. Whatever decisions we make. But to me, the world is really made up of two people, leaders and followers. And Connecticut has a chance to lead. All the states, 4.5 years ago, we were in this room and we were talking about some of this stuff. And we had New York, New Jersey, and Massachusetts were watching us like a hawk to see what we were going to do. And everybody was hoping that we were going to go a certain way. We got part way, but we stumbled a bit. We have a chance to take that to that next level. And I really, truly hope that that's exactly what we do. And I'll end at that.
Thank you. I think we as legislators all recognize at some point or another that ultimately we are simply never going to be as expert as we'd like to be on a whole variety of subjects. We're all effectively dilettantes doing the best we can with the resources that we have. So this is, confusing for us. We may not understand the ramifications of using one technology versus another, its appropriateness, the evolution of the entire offshore wind industry and the increasing size of turbines and what they've learned in a variety of contexts. So you can understand our hesitance for throwing ourselves into the middle of this to some degree. But for example, why would the developer, an Ørsted or someone, choose to use a technology that would require them to replace it out within, say, 25 years? Is that economically viable, or is that a reflection of the fact that they've already made investments in those assets?
I think it's a great question, and I can speculate because I'm not them. I think it's been the standard. That's how they've been doing it. If I had to take a guess, and I don't mean to offend anybody, they're developers. They're in it to make money. It's, once they build it, they're gone. They're building it. They're going to sell it to whomever. They're in it to build it, make money, and go. And to me, they're doing it at our expense. We gave tax credits. We're going to use taxpayers to buy power. We don't get any jobs in return. To me, that's just not a balance. I've listened all morning to people trying to recoup monies. I'm trying to recoup jobs.
So obviously, yes, one of our concerns, and it's not just for the developer, but for other parties who have been involved with the offshore wind business, getting out of that business and taking their profits with them. That's a separate subject we have to address ourselves. But getting back to the jobs conversation that you raised, when you quoted the figures as to the projected jobs that we thought we'd be generating, were those put into contracts? What assurances do we have that those jobs were to be generated, and what are the ramifications
I think
for
that's
their failure to have done so?
I think that's a great question. And I honestly, I'd be lying if I told you I knew what the contract was, because I do not. But I think that goes to the purpose of the bill, is because that should be part of the procurement. There should be, in my opinion, there should be some rules in place that safeguard that through the procurement, because then it makes it transparent. If the numbers that I got for you came off of the website for Revolution Wind, that's where they came from. I'm not saying, me personally would rather have somebody tell me we're going to create 100 jobs and create 120 than tell me we're going to create 1,200 and create 40. And there's nothing in place, there's no teeth in place, for lack of a better word, to hold anybody's feet to the fire for that. And I think that is the purpose, one of the purposes of these bills, is to try to add some language that gives us that leverage, those teeth. I just, because I think it's unfair. I think we all thought, all of us thought, there were going to be a hell of a lot of jobs in this. And there are going to be a lot of jobs down the road. There are. But we're here now. There's a lot of there'll be a lot of jobs once these are up and running. Maintenance. There's going to be a lot of jobs in that. It's going to require all kinds of training. But there's opportunity and it doesn't matter to me what the technology is that they use. For me, I think Senator Needleman asked a great question earlier about the ocean surface. I think right now geotechnical studies are being done, and all that information's coming back and it's redacted. That should be public information. We should know what the bottom of the ocean looks like. And why do I say that? Because I believe, just myself believe, that part of the language for a procurement should state, if the geotechnical study comes back and states or shows that all different technologies will work, then the foundation type that creates the most US jobs and creates the strongest local supply chain should be the foundation of choice. Now, there may be 3 or 4 different types of foundation that fit that criteria, but I think that should be part of the criteria. But that's me. I'm not a lawyer. I'm just the person that represents construction workers. I've been doing this for 40 years. I just, to me, that's important. But we'll never have that if we don't know what's on the bottom of the ocean. So what are we doing? We're taking the word of a developer. They're in it to make money.
So I'm not a lawyer either, though I've been accused of that and
I
worse.
thought you were.
But you mentioned procurement, and this seems to really be the nub of the issue. Procurement is a contract in which the terms are defined. In that we already have such a procurement in place, hasn't the cow already left the barn? How can we retroactively be imposing terms at this juncture? Or are you talking about some future contract?
Future. I'm talking about future. We can't change what's already been done. That, yes, that cow has left the barn, but we can learn from that and change it for future. I mean, I'm sure that there are talks of another future procurement. Who knows where this industry is going? So that's, yes, it's for the future, not for, we can't go backwards.
Thank you for that clarification.
Thank you.
Senator Needham.
Thank you, Chris, for your passionate plea. I appreciate it. It was good spending time yesterday.
It was, thank you.
I enjoyed it. Something good came out of canceling everything yesterday. Yes, there is about 1,200 megawatts worth of additional procurements out there. And I am disappointed that as of this moment for the deployment, there are only 40 jobs, that have been committed to for the trades. We did think that there would be more. We did think that there would be jobs for the longshoremen when we closed the pier down, and all of that is disappointing. All that said, again, somewhere in the mix here, long-term cost has to be part of the equation. And, Representative Michelle alluded to the environmental impact of doing the monopile versus the other types of the gravity-based or the kind we discussed, which I had never heard of, the 4-pronged.
The jackets. Yep.
There are ways to do it. And again, I think that there's a newfound sense of buy American and trying to be independent in this country as much as we can be, where we should be. In this case, because of the nature of renewable energy and the base cost of gas-fired power, the incentive to move to renewables has to keep in mind cost to some extent. So all things being equal, I go back to what I said to Representative Michelle, which was environmental impact, employment, supply chain, and cost are all the critical factors here that make this viable. We know that costs are going up. One of the major, the people who got the first 850 megawatt procurement authority have already come back to the table and said they can't meet the price because costs have gone up for all the component parts. So being one of the people who pushed through the 2,000 megawatt procurement, still the only leader left on this committee that did that. I want to make sure we do that in the most viable, economically viable way. And also our commitment, through project labor agreements was all there. I think we all need to look a little more into what's happening on the job front. And I think your plea matters here. So
Thank
I
you.
just wanted you to know that. Thank you.
Thank you. Thank you, Senator.
Senator. Representative Buckby.
Thank you, Mr. Chair, and thank you for your testimony. I have to speak up not only on the topic, but somebody who shares the same barber as me. We have to have good taste with that. I think to touch on what the good chair said earlier, that's critical is that we aren't experts, right? And the fact that we you do know what you're talking about. You do know your market better than we're ever gonna. And I think that's the biggest piece of how things should work. As you mentioned earlier, this should be the house of the people. This should be the voice of the people that are coming to us. So without your testimony on this, we don't know enough well to fix it. We sit in, I spent the last couple of years in 6 years in commerce where we talk about learn here, live here programs and trying to get people to stay here, trying to promote workforce and pieces of the workforce. But this is that step we're missing. So I think at this point, we really need to step up and make sure that those jobs that we're putting jobs out there, we're actually creating jobs. And the fact that we're following up with 40 isn't exactly getting the job done. So I appreciate your honesty and coming forward with that. And I'd say thank you. I appreciate it. Thank you, Mr. Chair.
Thank you.
Thank you, Representative. Representative Mashinsky.
Thanks, Mr. Chairman. I wanted to ask you, because I thought the 1,200 was real too.
Yes.
You know, I was telling my district that there were going to be 1,200 jobs connected to this project. Where did it break down? Where did the pledge of 1,200 break down and disappear?
Well, I think, I mean, that's a great question. And I'm trying to, I think a lot of us are trying to figure that out. And I think that we're right at the beginning stage of this. So the way it's going to work as of right now at the state pier, tower sections are coming in. And basically all we're doing is assembling them. So they're coming in, it takes 4 sections of pipe, for lack of a better word, 4 sections of pipe to build this tower. Take one section, put it on top of the other. That's part A. Do the same thing for part B. They go on the ship, out they go, and then they get installed out on the ocean. That's what we're going to be doing in New London as of right now. Because of that, it just doesn't take a large workforce. These are all built in Europe. They're coming built. There'll be a little bit of modification. There'll be some painting maybe done where something got dinged up, but for the most part, that will happen out on the water.
I get the technical
So,
part. I'm asking you, how did
where-
it get from the pledge of 1,200 jobs to suddenly
Can I be blunt?
everything's coming from Europe? No, I'm asking the question.
Okay,
I
good.
need an honest answer.
I'll tell you the same thing I told Rosa DeLaura when I met with her 2 months ago. In my opinion, the United States got sold a red car and we bought it. That's what I think happened. They are in the business to make money. Right now, this is a gold mine. This is a new industry. They're banking on we don't know anything. And quite frankly, we don't. We're learning. And if you look at what developers, and I'm not singling out any developer, but if you look at what developers have said up and down the coast, it's almost the same numbers all the time. We're going to create 1,200 jobs here. We're going to create 1,400 jobs there. We're going to do that. We're just assembling. That's all we're doing. It takes 18 hours from the time that thing hits the water. It takes 18 hours to erect that tower, install the turbine, and put the blades on it. 18 hours, and 2 days later, they have power. There just aren't jobs in the way it's set up. The only way that I believe we will set up jobs, and this is an opportunity for Connecticut, if we can look at some of the alternative foundations and bring Connecticut back to the roots of Connecticut and make us a manufacturing state again. We could have an opportunity, and that would create, we have buzzwords that go around all the time, right? You hear it all the time. Let's have social and economic justice. And that's a wonderful thing, but it doesn't happen. If we create it, let's use a gravity-based foundation. Let's just use that. You can use a jacket, but let's use a gravity-based foundation. There was a report done by Tufts University. Professor Hines is over here. He'll be talking afterwards. The ratio of jobs is 30-1. Okay, so if we did something like that, there are places in Connecticut where we can build those. We can build those. You bring them out on a barge, the barge sinks, the thing starts to float, you hook it up with tugs, you bring it out to where it has to go, fill it with ballast, down it goes. Then you erect a tower. Those jobs would be in somewhere like, say, Bridgeport. Okay, let's use Bridgeport as an example. There are people that are socially and economically deprived. They can't get to the jobs. I do this for a living. we've been trying to reach out to inner city people to join the unions all over the state. The issue is they don't have the means to buy a car. They don't even have driver's licenses. This is an opportunity to change. And I don't want to use the word jobs because we have a chance to make careers. We have a chance to change lives for generations of people. And we could bring the industry to them. Now, the next thing you know, they can buy a car. They can buy a home. We've changed lives.
Okay,
So
I
to
get-
answer your question,
I
I
get
don't
that.
know. I mean, at the end of the day, it's all being made in Europe. There are no jobs.
No,
They gave us
I
a line
get
of
what- I
BS.
get your explanation and the rationale why we want to bring the jobs to the city. I get that. What I'm trying to figure out is, was it a bait and switch where
I think so.
they described something and then switched what they were going to do after they described it and we bought it? Is that what happened?
That's what I think happened.
Okay, so we have to be more specific and explicit when we're writing the
Which brings
standards
us-
for,
Which brings us to,
which brings us to the bill. Okay.
which brings us.
So we just have to spell it out better because we can't rely on what they're telling us because it may not be true.
Exactly.
Okay, I got it.
And again, that's my opinion, but it looks pretty strong.
Thank you.
You're welcome.
Thank you. I don't see any other questions, but we will look at your testimony with great interest, particularly the written testimony that might give us suggestions on how we could further enhance this legislation to address the issues.
And I'd be more than happy to come up anytime to
I think
share
you've
with
already
whatever I know.
indicated that. Good.
More than happy.
Very good. Thank you.
Thank you.
Next up is Representative McGorty, followed by Rob LaFrance.
Good afternoon. Co-chairs Needleman and Steinberg, ranking members Fazio and Buckby, and the members of the Energy Technology Committee. I would like to thank you for inviting me to this hearing today and for this bill 5640, the concerning removal of service cables. In my town and many towns around the state, such as yours, these cable communication companies have not been held accountable for maintaining their infrastructure. As technology changes at a rapid pace, the copper lines and coax of our past are being replaced with fiber. But the copper and coax are remaining on people's homes, and these wires get caught up in vehicles passing as they sag as time goes on. They fall down. The fire department, the police departments have to respond. There's numerous wires that are left year after year that you see in my testimony with the stuff I put online. There's photos in here that are over 2 years old with snow on the ground, and these boxes remain. These wires are a hazard. They're eye pollution, and they need to be cleaned up. I understand that, you know, some of the people in my district, they change service competitions out there. You go from one company to another, and they don't clean up the old wires that are on your house, and they stay there in hopes that you'll come back to them again. But as you can see in some of the photos, I have multi-families here in my town. I have a 3-family with 11 service cables going to it. There's another 2-family with 9 wires going to it. Every time a customer comes in, they put up a new line. The tenants move in, tenants move out. They go with different people. And these wires, they just become a hazard and a just pollution. And I like to see these cable companies be held responsible for cleaning up their infrastructure. And this is just for the outside, not inside of your business or your home. This is just, you know, cable, they're running to your house that do not do anything anymore. The customer's gone. They're not coming back. If they do, you're going to give them a fiber line, and the coax just sits there and it rots until it falls off of your home. Not asking for the hardware to be removed off the homes, just the wires. The wires are the problem. I know a lot of service boxes are mounted to homes, and it's unacceptable that this stuff is left up on these poles year after year, and the fire department gets called out numerous times, and it comes to a cost of the fire department. It's about $400 every time an apparatus responds to wires down, and these wires could be down for months or years, and somebody sees it, they call 911, and then we go out there, we secure it with some yellow tape, and it just sits there. And it's just, we shouldn't be the one that's policing, the fire department police shouldn't be policing your poor infrastructure with these cable wires that are hanging down. I want to thank you again for this hearing. I expect the committee action favorable on this bill, and I welcome any questions from the committee.
Thank you, Representative. Thank you for bringing forward an issue which I think we all share, which is you drive around any neighborhood, you see these wires hanging down, and you're sure as hell hoping that they're not electric wires that are alive. And we often hear that those are just telecom wires and don't worry about them. It's not simply a matter of sort of a visual blight. There's actually ongoing concern as to whether we're safe, not knowing as to the nature of these wires. We have heard the industry say that this might be prohibitive for them to be pulling down wires every time they change over from one subscriber to another. But I will tell you that we are considering holding the industry accountable as we do the electric suppliers in a similar fashion. That's one of the elements we're looking at in one of the bills that relates to Pura. And we will certainly take into consideration the suggestions you made in this case. It's certainly in our interest to make sure that everybody's not only safe, but that our neighborhoods are not unsightly, and everybody who has assets on these poles should be taking responsibility for them.
Yeah,
Representative Buckby.
Thank you, Mr. Chair, and thank you. Look at you taking time with the real job to give us a shout here. We appreciate that.
Well, I missed you yesterday. I was looking forward to being up there with you guys, but I had to go to work today.
We missed it too. That's the shame yesterday. So you mentioned briefly the cost on it too. You were saying it's about $400 every time a truck rolls out of the bay.
Yeah.
Just trying to put in perspective in your community, we're talking, you said several times a month. So ballpark it in your community. How many times a month are you guys getting called out? And then how much money is that then that's going to be billed back to the municipality?
Well, so you can have a nice sunny day. Like last week, I think we had 2 wire calls. Beautiful sunny day. These things just, the hangers get loose, they rust, they rot, the wires come down. And then we have the ones where there's storms and the wind bring them down. And, we're just chasing them and chasing them. And then we tie them up to the side of the road on the poles. And, the cable companies and telephone companies, they drive by every day. They see the mess there. I used to work for SNET back in the day, and that was old craftsmanship. They would never leave the infrastructure the way it is now. They did a nice job. They took pride in their work, and they were the only game in town. But now you have so many different cable companies coming up and down the road. There's, I don't want to insult anybody, but they're like, gypsies in the night. They just come up, run fiber. They work for somebody. They're a subcontractor. It's not the old company that it used to be. And competition's good, but we still got to hold them to the standard of the craftsmanship of back in the day.
I don't disagree with that. I appreciate you bringing this forward for us to know about it. I think that was the problem that we first saw and didn't know which it was. And there had been concern about if it was interior. This is strictly from pole to home or
Pole to home, correct. Not interior at all. Whatever inside your house you own anyhow, you own the drop to the loop, and that's what you need to take care of the outside. That's all owned by these utility companies. And I understand it comes at a cost, but you got paid to install the line. You got paid when the person had service. Well, now it's time to clean up. You just can't abandon your stuff, I feel.
Be like going to a fire scene and leaving the hose laying out for somebody that might need it next time.
Exactly. Yeah.
Thank you very much. Appreciate the testimony. Thank you, Mr. Chair.
Thank you.
Thank you, Representative. Representative Greshko.
Thank you, Mr. Chair. So, Lieutenant, the pushback on this is that, well, those wires are up there for the next person that's going to occupy that house or dwelling. But you're telling me there's a difference between the coaxial and fiber.
Joe, most of the cables that are in my testimony are homes in your district. And you can see that, if you have a 2-family house, there should only be 2 service cables coming in. We got them with 6 and 9 and one with 11 going to it. It's each company, each tenant, they change over. They're not using the cables over again. They're running new cables because they're doing different speed internet. You can't take a chance with a connection that's been up there for years with a little corrosion in it. That doesn't make for good business. So it's cheaper and easier for them to run a new line than to chase trouble calls all the time because you get a little bit of static or you lose your internet. They're running new lines all the time. They're just not removing the old ones.
So the second pushback is that, your bill's gonna go up because now we have to have people chasing all of these cables, and we don't want to have that.
Well, if they cleaned it up as they went along, I've even tried to have wires removed off my house. They don't come out. They won't do it. They feel you're not a customer anymore. We don't care. Well, it's sad, but somebody's got to hold them accountable, and you just can't leave it there and have somebody else go clean it up, like the fire department, police department closing roads for these wires that just come down.
Thank you, Mr. Chair. I'm glad to hear that Representative McGorty is a fan of the extended product responsibility.
You got it.
Noted for the record. That'll come up later, I'm sure. Are there any other questions or comments? If not, Representative, thank you for taking time today. Sorry that you had to wait a day to testify, but
no problem. Just
we
appreciate the opportunity.
there you go. All
Thank
right. Thank you. Next up, we have Rob LaFrance, followed by the last of our legislators, Representative Mara.
Good afternoon, everyone. Thank you so much. Thank you to Chairs Needleman and Steinberg and Ranking Members Fazio and Buckby. Ranking Member Buckby, I have to say I do enjoy your humor. You made me laugh a number of times, so thanks for keeping it light here. I'm here today to talk in favor of an act requiring offshore wind developers to establish a compensation fund. For the record, my name is Robert LaFrance, and I am the Policy Director for the National Audubon Society's Connecticut office, Audubon, Connecticut. I also want to thank Senators Summers and Michelle for bringing this bringing their testimony on this bill to the committee today. In my written testimony, I provided a letter or a quote from a letter from 9 states who wrote to President Biden about the offshore wind issue. Those 9 states included Connecticut and a number of other Northeast states. And in their letter, they said that the reason that they were writing this letter was they want to provide support for other marine industries and users to advance offshore wind energy development in an environmentally responsible way that ensures renewable energy coexists with natural resources, ocean users, communities, including fishermen, and tribes. And we urge the federal government to provide leadership on regional natural resource impact assessment. And this is the key from my perspective, and mitigation frameworks for demonstrated negative impacts on marine resources, fisheries, and local cultures. Fortunately, when the Public Act 1971 was put into place, there was created in that something called the Commission on Environmental Standards. The Commission on Environmental Standards met very quickly for a number of months after the bill had passed to put together a report that went to the commissioner. In that report, the commission recommended that the commission advises that the developer commit some amount of money upfront to a mitigation fund. This fund should be a separate fund to the funding source to use to support activities pursuant to the adaptive operational plan, which is also discussed in the report. The mitigation fund should be used to offset economic losses and burdens to the commercial fishing industry and elements of the environment. And it's important to understand that the commitment here that the CES was talking about was elements of the environment, the negative impacts potentially to marine mammals, sea turtles, birds and bats, invertebrates, habitats, a whole host of other things that live in animals and other life that is in the oceans. We offer some suggested language for this bill. We ask that the committee require that the commissioner basically kind of make certain that the Commission on Environmental Standards is meets more frequently and isn't just there for procurement. We ask that the CES be given the responsibility to take the lead on a compensatory mitigation fund that would also address, and this is not really being addressed, I don't believe, at the federal level, impacts on wildlife, natural resources, ecosystems, and traditional or existing water-dependent uses. I think the focus of that particular group, the 9 states, and some of the other work that's been happening has been on the marine fishing industry, which makes sense and needs to happen.
Please summarize.
Thank you very much. And lastly, I'll just say we are hopeful that the CES can also make recommendations on the ecological costs and benefits of a shared offshore transmission line. We think that's something else that we could look at as well. So I provided extensive written testimony. I'm happy to answer any questions. Thank you so much.
Thank you, Rob, for your testimony. We've heard that, BOEM is on this, that we've got this whole regional collaborative in developing offshore wind. Why shouldn't we just trust them to look out for our interests? Aren't they basically looking to protect us in the same way, whether it's off Connecticut shoreline or anywhere else?
I guess I'd say the following. I think this is true all the time. States are basically places where we experiment with different policies. Connecticut may be unique in the sense that it wants perhaps greener energy than, say, Virginia may want. The fact that they're looking at the impacts and looking at a compensation funds that's going to compensate marine fisheries isn't necessarily the same thing as making certain that whatever impacts happen to wildlife and the environment are also being protected and compensated for. So, for example, if there is some impact on a bird species or some impact on a turtle species, how do we know that there's some dollars available to help offset that? We need to take a look at that at the state level and provide input and expertise to the regional BOEM approach so that we can add our voice to what we think should happen there. I think some of the work that's happening at the United States makes sense in the sense that they're looking to try and come up with an administrator who can deal with these issues. But each state is going to be responsible for saying what it wants to see in terms of that mitigation. And that's why I think we need to look at this more closely, specifically with regard to some of the impacts that we could see happening on birds and bats that may be migrating through, but also to the extent that some of these are resources that Connecticut ratepayers are effectively spending their dollars on and making certain that they want to make certain that that is, in fact, green.
Thank you for that. But you've also heard us, some of us have commented on the fact that, at what price? We heard Representative Michelle say that the difference in the use of a technology would have an impact of only 3% on costs. I don't know how that translates to the average ratepayer. Once again, we find ourselves trying to balance two competing elements, protecting the environment, but also protecting ratepayers. It's much easier for us to put our faith in regional collaboratives rather than taking on ourselves. But I ultimately take your point, which is each state's circumstances are unique unto themselves based upon the topography, the flora and fauna that are involved in these cases. So I think there's a lot of interest in understanding how we can strike an effective balance. And we look forward to your input on that as we go forward. Representative Buck.
Thank you, Mr. Chair, and thank you for the wonderful compliment, Robert. Appreciate that. Thank you. When you started things off, I just have, since you're from the Audubon Society, I figured I might feather in a comment here.
Sorry, you're good today. You're on a roll. Keep it going.
I just want to ask the impact of that. I know when we first started talking about wind, and we're talking about the birds we were losing in there. Has that gotten better? Have the birds gotten smarter? It's honestly my concern. We talk about the marine life as one thing, but have the birds gotten better at avoiding these giant fans at this point?
That's a fantastic question. And we are doing more work and better understanding. We're doing MODIS towers, and we're trying to do a better job at understanding how birds migrate and where they migrate. But because of the history of our oceans, a lot of the data we have historically has been from people on the ground looking at birds and identifying them and then sort of putting together the pieces as to where they go. For example, in the Midwest, there still is an issue, right? There was in my testimony, I cite to a couple of issues having to do with Migratory Bird Treaty Act, where the birds were not fortunate enough to miss the wind turbines and in fact have died. And there was a penalty paid as a result of that. Our point is we want to try and work with the industry to avoid. That's the first thing you want to do, minimize. These are all standards that exist in the statute that we passed, and then finally mitigate. And the final point of this is to mitigate to the extent that we have some impact on birds, to the extent that certain portions of a population die. We ought to think about how we can do a better job of improving other habitat for them so that they can, as you indicated, hopefully learn and not go to that area. They basically look at that as the notion that you're disturbing. There's a disturbance issue in terms of how they fly, but some of these birds are amazing in terms of how they do fly and the amount of energy they use in their migratory path. So I guess the short answer to your question is the birds are still going to have an issue, and we're going to have more wind in their way. So we need to work to help them in other ways to make certain that their habitats are protected and we can protect both their breeding grounds and their overwintering grounds.
Thank you for that. I think that's that was the number one concern I got back when we first got into this was the impact of the birds, the impact of the shellfish and the sound. So I think it's critical that we gather as much of that data as we can going forward on this. And you seem to be by title, if nothing else, the one we would go to on that. So I thank you for that. And Mr. Chair, I will just nest over here before I lay another egg.
You got to keep that rolling. Makes the day go a lot quicker. Thank you.
Suggest your nest is already quite full.
This one.
Thank you, Rob. I don't see any further questions. We appreciate your testimony and your ongoing participation in us trying to do right by the environment and do right by the state. Thank you.
Thank you all, and thank this committee for the hard work that they do. I know you guys all care about this issue, and I'm happy to be a resource to the extent that I can. Thank you so much.
Again, thank you. I saw Representative Porter here very briefly. She left again. All right. If you could find her, that'd be great. Otherwise, I don't see Representative Mara. She's right there. Okay, I should see Representative Mara. Why don't you come on up? Thank you. I have to learn how to recognize you to know that you're here. Okay.
So thank you very much for allowing me to give testimony today. I'm really happy to be here and really happy to support Bill HB 5108. It's got a really long name, but basically we're looking at the appeal process for vegetation management across the state by utility companies. So in my neck of the woods, Lower Fairfield County, we are seeing quite a bit of vast cutting of our trees. I know it's happening across the state, and I know it's for very good reason, and so do all of my constituents. We understand that we need power resiliency. We need to have our electrical lines protected, and we're very aware of that. But my concern is that in the haste of making sure we have resilient power lines, we have not taken into we don't have a balanced approach with our environment and our trees. So my proposal today is to take a look at some of the issues with the vegetation management and the appeal process. Today, you're going to hear from a lot of my constituents, particularly on Little Brook Road, and on this particular road, there's probably Department of Transportation land. And then it's Department of Transportation land, it's town land, and then across the street are a bunch of houses. So one of the issues is that when you cut trees down, you have to allow the abutting property. No, in that scenario, there's only one house that had abutting property, whereas that whole street, every house on that street is vastly affected by the clear cutting that went on. So that would be the first proposal that I would make, is that we increase the definition of abutting to be something like many of the planning and zoning areas use, in that it's a radius or maybe a foot distance, but not just touching. The second one would be looking at the amount of time that some of these notices are given. Right now, it's just 10 days, and that's kind of a lot to get everything together. I mean, I know I found out about this, and given my background is not with trees or energy, so but I had lawyers that could help, and it still took me some time to research all this. So what are we expecting really of our constituents that have never dealt with dealing with how to deal with utility companies? I also expect that the owners of property, the utility companies or ConnDOT, I expect them to be good stewards of their land in these neighborhoods. And when I say that, if you could just walk down Littlebrook Lane, you would understand that it is now mud. So I expect that people that own land in these towns are just good stewards of their land, because what happens on that land is going to affect that whole neighborhood. We know that things like flooding is not something that just happens to an abutting property. So if you've all of a sudden taken down vast amounts of vegetation and vast amounts of trees, and you're creating some sort of flooding effect, are we really at the cost benefit of taking those trees down?
Please summarize. Your 3 minutes is up.
Sure. I mean, let's see if I've got any. I think that summarizes what I want to say, but I know that I do have several constituents here, and would really ask that you take a look at their testimonies and their pictures. Thank you so much. I'll take any questions.
Representative, for bringing forward an issue which I think many of us can relate to. I also hail from Lower Fairfield County, and this has been a huge issue over the past several years, whether it's DOT or Eversource. There seems to have been a disconnect between their intention and their communication to neighbors, and we will consider what you've put forward in ways to make that easier. I will say, though, I have some sympathy for them as well. We can sometimes be perfect hypocrites saying that we want to have reliability and resilience, and yet not our tree. And, I've seen in my neighborhood just recently, they took down 4 or 5 large trees that were right in the right of way. And I feel safer that my electricity will remain on knowing those trees are now gone because they were oversized to start with. So, I understand how the utilities will struggle in striking the right balance and moving forward, because we now, because of our performance-based legislation, we're holding them accountable in a lot of ways. So we appreciate the testimony. We'll try to see if we can strike the right balance. But we certainly need more engagement between those who want to take the trees down and those who own them. Representative Meskers.
I want to thank you for your testimony. Certainly it was into my 2nd or 3rd year of service in the House that Metro North came through, and then Eversource. Metro North cleared out all of the trees abutting a local school in my district, or abutting my district in Riverside. And I think the 2 issues, vegetation management shouldn't be vegetation elimination. And so there should be looked at what might be looked at. I think there's a difference between aggressive trimming and aggressive removal. So as you advocate, I think the questions may be what the policies are in vegetation management, because removal is not management, removal is elimination. And so we have to look at a balanced policy between bushes, trees, evergreen, slower growing plants versus just taking everything down to the base. And that may be part of the dialogue we should have with them.
Thank you. I appreciate that comment and totally agree. And looking too on what goes into that space after it is removal. Because there's a difference between then having invasive species put in versus real trees that are actually going to thrive versus saplings that are going to be eaten by local critters. So yes, thank you.
Thank you, Representative. Any other further questions? Apparently not. Representative
so
Morrow,
much.
thank you for testifying today. We appreciate your patience.
Yeah.
And we all care about this.
Yes. Thank you so much. Appreciate it.
We are now up to Lori Brown, Connecticut League of Conservation Voters, followed by, I believe, Representative Hughes is here. Okay.
Yes, good afternoon. Can you hear me?
You can hear you just fine. Please.
Yes, thank you. Hi, good afternoon, Senator Needleman, Representative Steinberg, Vice Chairs, Ranking Members, and all the members of the Energy and Technology Committee. My name is Lori Brown, and I'm the Executive Director of the Connecticut League of Conservation Voters, and I'm here to testify on 2 bills on your agenda today. House Bill 5223 regarding offshore wind that you've been talking about quite a bit. I'm happy to have heard all of that. And also Senate Bill 123, which does seek to reclassify all hydropower and waste to energy facilities as Class 1 renewables. So the League works very closely with many of the environmental organizations that are testifying later today. And I think with respect to 123, I think you'll see there's fairly strong unanimity among the groups in opposition to unconditionally redefining certain energy sources as Class 1 renewables. This is a particular problem for hydropower, and the committee's proposed language to simply cut out the definition of environmentally responsible hydropower is really what I'd like to address. This definition was hammered out over many years as a middle ground that was set up to encourage both small hydropower, the development of hydropower, and includes protections for our rivers and streams, such as fish passages and adequate river flow that sustains life and protects the rivers. If you delete the language in this section, you'll be rolling back an important environmental law. Hydropower is already in Class 1, but with the guardrails that are outlined in terms of what makes it clean energy and sustainable. So SB 123 is also of great concern to citizens working to reduce pollution from trash to energy incinerators. Reclassifying these facilities as Class 1 clean energy does raise a whole host of issues. And but there are other testifiers today that have much more specific information on that subject. The other legislation I want to highlight is HB 5223 regarding the offshore wind. CTLCV does support this bill, but we respectfully ask, as have others before me, that you take the opportunity to include some protections, additional protections for our marine ecosystems. I'm referring to the language that is contained in HB 5221. That intent, as you know, this added language is really to establish noise limits for offshore wind facilities and to require strong environmental standards in the bidding process for wind energy. So we do understand and we acknowledge that our state is in a really difficult position and trying to reduce our high energy costs, but that situation should not require sacrificing our environment, our land, our air, and our water and wildlife. That's equally important to our state's long-term well-being. So to recap, we oppose the section of SB 123 that redefines clean energy and tinkers with the RPS. And we support HB 5223 with the addition of environmental standards in the procurement of offshore wind. But I just also wanted to throw in my 2 cents in support of the 5108 tree cutting legislation. The written testimony on that will follow. My written testimony for the first 2 bills, I think, was just posted a few minutes ago. I'll stop there.
Well, thank you, Lori, for testifying on all 3 of those bills. Yeah, I think we all agree that Senate Bill 123 is well-intentioned because we have a crisis right now with regard to rates. And we want to encourage all sorts of thoughts as to how we might accomplish that. But we also appreciate that that does seem to be bumping up against our well-regarded environmental objectives, and I'm not sure there's a pathway to accommodate both quite precisely on that, but perhaps others will help us find a way. With regard to your support of the vegetation legislation, is there anything you choose to add about that?
No, there are several bills this session in different committees that are dealing with really the mass clear cutting. We're really facing a problem with that. If it's not DOT, it's Eversource. If it's not Eversource, there's even problems with the way DEP is managing for us. There's a lot of legislation out there. I think a lot of people are trying to find solutions to this. And I would just say, Eversource is one of the most obvious, I think, aggressively cutting, with instead of surgically cutting, and just wildly over cutting and doing a bad job in general across the state. And I've seen testimony, I've seen the pictures that I think the representative just before me was talking about. It's heart-wrenching, and we've got to do something because our natural resources are absolutely part of solving our climate problem. I mean, destroying forests is really tying our hands in terms of how we get to the zero carbon output. And I just would say that there's, many committees that have an opportunity to try to help this right now, and I hope they'll be supportive in this committee as well.
Thank you. Maybe we can come up with a performance-based metric for how you cut down a tree. Senator Fazio.
Thank you for your testimony. And I certainly take it to heart. I guess there's a lot of other regulatory bodies and rules that are governing, that are also governing hydroelectric power from siting and other environmental standards as well. Can you kind of go into what those existing ones are and what you think they should be, irrespective? Obviously, it's not the RPS that's governing those general environmental rules related to hydropower.
So hydro, and obviously there are really strong experts. In fact, that the person right after me or soon after me is Alicia Sherman of Rivers Alliance of Connecticut, and she has been doing a lot of work and can really outline the specifics. But the language that's being proposed to be cut, that I've identified, in my written testimony, the exact lines, is putting what would be considered sustainable hydropower, which is what allows it to be class 1. If you take out the definitions of all the things that were considered a compromise and middle ground and really forged out over almost 20 years to get that done, just kind of whacking it out like that, all kinds of unintended consequences, I'm sure you would find. It means any hydro, anywhere, with no restrictions, no criteria for what makes it clean energy and sustainable for the environment. So I would just say that, certainly leave that definition of hydro in, which keeps it in class 1. I think if you take that out, maybe it's an effort to really, the RPS, I think, as it was discussed earlier, is for the purpose of clean energy and sustainable environmental energy. And if you start removing the criteria and reducing, basically you're calling for the elimination of class 2, which, right, everything goes up into class 1. And so that's going to really disrupt a lot. So I would, again, for very specifics of what makes clean hydro, there's a whole list of things. There's new technologies, run of the river, there's fish passages, there's allowing enough flow so that you don't damage, downstream, there's migrations of fish. There's just a lot that these protections are necessary.
Yeah. And I totally appreciate what you're saying. And it's very similar to the wind conversations we're having with the fund, that we also want to consider the environmental, the externalities, we shall say, to habitats, and try to internalize at least some of those costs. I view the RPS as more of a carbon reduction tool. The idea that our grid writ large wants to be lower carbon while still being reliable and affordable. And I view that there's a lot of other regulatory tools in our toolkit that aim to protect many of the other environmental concerns we have. And that's where you get so many of the other rules governing hydro and other forms of power, whether it's the Siting Council and others that have to take those into consideration. But I also, listen, your points are well taken, and they should certainly be considered by me and other proponents of the bill, and I can assure you that they will. But the intention is that keep other environmental guardrails in place that are in effect in order to protect numerous environmental concerns, while also reducing carbon emissions and building a more reliable grid. So that's our intention, and details certainly need to be hammered out.
Yes, and I appreciate your comment earlier about, the goal being clean and affordable, but I would add sustainable and long-term. I think that is also the goal here, is if you remove the guardrails in one place, you are opening the door for a lot of, I don't see any advantages to removing the environmental protections that already exist for hydro. I don't think anybody quite understands what the benefits of that are.
Yeah, I don't want to monopolize time, but I'm saying that the other existing environmental guardrails for hydro exist outside of the RPS. The RPS is not primarily a tool for regulating hydropower and all the environmental consequences of that. It's primarily to ensure that we have cleaner, lower emissions power generation in the region and in the state. And so I view that the tools for protecting those other environmental considerations exist and should still exist in state law and through our regulatory bodies, but that the RPS is primarily a tool for reducing emissions while maintaining a sturdy grid. And so that's where I'm kind of compartmentalizing those costs and considerations. Again, I don't want to monopolize time, but that's how I think through these things.
Thank you, Senator. Representative Mashinsky.
Thanks, Mr. Chairman. You still with us, Lori?
I am. Can you hear me?
Now I can see you too. That's even better.
Oh, okay.
You had recommended, and some of the other witnesses had recommended we add the text of 5221 to this bill to set standards for both the environment and job creation. And 5221, if you look it up, it has, it's vague. It doesn't say specifically what the standard should be. So where do we get these? Do we get them from Europe, from Germany, from UK? Where do we get these?
Well, again, I would definitely point back to Representative Michelle. He really knows all of the background and the details. And Mr. Bishant also, I think they would be better positioned to answer that. I think just in general, we really want to see green jobs, I mean, Representative Mr. Bishant's appeal for that just is so common sense. And there really is an opportunity right now to do that, to create those jobs and to create green jobs that are long enduring jobs. So I'm no expert at that to answer that question. I would have to defer to others on that.
Okay.
Representative Mashinsky, speaking of experts, if you'll humor us, the next person we're going to have testify might be able to answer your questions. And seeing now no further questions, the chair is going to use his prerogative and bring up Eric Hines, who was traveled down from Boston and probably has to go back there again. So welcome.
Now, can you hear me? Thank you so much for welcoming me here today from a fellow New England state. I believe we're all in this together, and I'm very excited about some of the things that are going on in Connecticut, and you'll hear more about this. Honorable Senator Needleman, Representative Steinberg, Ranking Member Senator Fazio, Representative Buckby, Vice Chair Senator McCrory, Representative Foster, and members of the committee. Thank you for the opportunity to speak to you today. I'm Eric Hines. I direct the Offshore Wind Graduate Program at Tufts University in Medford, Massachusetts, and I'm here to speak to you regarding the proposed House Bill 5223, an act requiring offshore wind developers to establish a compensation fund. I'm here to encourage you to support both the development of the proposed House bill, which is really just an intent at this point, and its incorporation of the proposed House Bill 5221. Together, these proposed bills could enact nation-leading environmental standards and job creation requirements for Connecticut's future offshore wind procurements. A little bit of background about me. I've spent most of my career practicing as a structural engineer. I was the lead designer of the Wind Technology Testing Center, the facility that tests the wind turbine blades in Charlestown, just north of Boston. At the time that facility was completed, it was the largest of its kind in the world. We had done everything we could to learn as much as we could from Europe along the way, and we had to go further. We had to advance the technology, we had to advance the state of the art, and we had to do things on our own terms with American engineering creativity in order to accomplish that feat of engineering. Similarly, shortly thereafter, I became the owner's engineer for the New Bedford Marine Commerce Terminal in New Bedford, Massachusetts, and worked for several years further with MassCEC, the Massachusetts Clean Energy Center, to design the terminal, to set the standards. There were no standards for how such a terminal should be created. And as we're talking about standards today, this is something I'm very familiar with. And this is something that, again, we learned as much as we could from Europe. And then we realized, because we were in New Bedford, because of our geography, our history, our culture, our politics, things are different here in the United States. And we cannot just copy and paste these massive, massive investments from one part of the world to another. Very similar to our bridges, our tunnels, our airports, all of our physical infrastructure, we design them to their location. And this is essential. And I think this is what Mr. Béchant was talking about and what the other representatives are talking about today. So as state decision makers, you stand at a critical juncture in our history. You have passed Public Act 22-5. Your state is a leader in the New England States Transmission Initiative. We are very excited about that. And we are very excited about the collaboration between the New England states right now. This is something that is path breaking and is going to make a huge impact on the U.S. energy transition. The diversification of organized labor, the work that Mr. Béchant has done. And if you look at the executive board of the Carpenters Local 326 and what they've accomplished in the last few years, it is nothing short of amazing and is taking organized labor into a brand new era. That leadership. You are leaders in the national discussion on reducing construction noise to protect endangered species. These are the reasons I am down here today talking with you, because I'm very excited about the leadership that Connecticut is demonstrating. Now, just one more sort of set of ideas. As an engineer, I spend a lot of my time helping people think through numbers in different ways. And the numbers can be incredibly enlightening, and they can also be confusing. So I'm just going to try something out on you, a little thought experiment, and stop me and, you know, tell me to do something differently if it's not making sense. But I'm going to bring up 5 points. In 2021, Connecticut saw 28 terawatt hours of retail electricity sales in 2021. That's about 0.7% of the United States. So electricity in Connecticut is a little bit less than 1% of retail sales for the entire United States. Connecticut could generate this, that sounds small, but you could generate this much energy with 426 offshore wind turbines worth about $22 billion. So you have a small number that is also a large number at the exact same time. And I think this sense of scale and order of magnitude is critical as we think about these opportunities. Last month, I brought my bill with me. I paid $327 a megawatt hour for my electricity. So I'm glad to hear everybody talking about the high rates. This is actually a $40 a megawatt hour more. It's a $40 hike for what I paid in November of just last year. So let's hold on to that number, $40 a megawatt hour. Last year, a colleague of mine and I at Tufts did a study of contract prices for 9 offshore wind projects in the US, finding for Massachusetts, New Jersey, that the prices range from $73 a megawatt hour to $114, a 56% difference. In other words, we don't really have a market right now. We have a lot of different states doing a lot of different things with a very wide range in prices. The difference is about $40 a megawatt hour, it turns out. So I got curious about that $40 a megawatt hour. And I said, what if I had a 1,000 megawatt wind farm for 25 years, 50% capacity factor, and I'm going to do something with that $40. Once I do that over the life of the wind farm and I convert it back to 2022 dollars, I have $2 billion to work with. Not $5 million, not $10 million, not these sort of amounts of money that sound like a lot of money when we're talking about supporting workforce. $2 billion is the cost between the least expensive and the most expensive US offshore wind farm. That would be what we would call an inefficiency in economics. And it's the kind of inefficiency that I think sets the order of magnitude of what decision makers such as yourselves can play with as we are thinking about charting the course for the future. $2 billion could support 2,000 Connecticut families for 10 years at a living wage. That's a living wage in Fairfield County is around $85,000 to $100,000. And in our work, we have found that for less than a tenth of this $40 a megawatt hour rate hike, or inefficiency, or whatever you want to call it, innovations in offshore wind farm design could increase jobs by a factor of 30. The same innovations could also drastically reduce construction noise and address current global supply chain shortages. There are global supply chain shortages that bear directly on the ability of the US to reach its goals to get to 2030. And we just put out a report with the National Renewable Energy Laboratory in January 23rd of this year, saying that the United States is going to need to invest about $7 billion to reach this goal. And so I urge you to look at that report. So I believe that you stand at a critical juncture in our history. No matter what bill you and your colleagues support or do not support, you are de facto setting policy that will determine Connecticut's environmental and economic future for decades to come. And we are deeply grateful for your commitment to this, for your leadership, and for all the work that you've done. Strong leadership really matters because the impact of Public Act 22-5 is closely tied to the other 99.3% of US electricity emissions. And as you set your state on a course to meet its emissions targets, now is also the time to enable your citizens to thrive in our nation's new energy economy. Thank you.
Thank you for your testimony, and you bring forward data, which is always appreciated when we try to struggle with decision making. When you refer to the $40 number, how much of that is accounted for by timing of projects, size of projects, and the like? Do we have any real sense that that maybe that $40 is just the variability depending upon when a project is priced out and implemented?
So our report was written based on publicly available information, and the analysis we conducted ourselves, and we did it on Sunday afternoons without any external funding. So I'm going to share my opinions with you about what that amounts to. Massachusetts went after rock bottom prices with the price cap. I'm sure you're familiar with that. And so Massachusetts and Connecticut, although the Park City wind numbers were redacted in the public record, so we don't know those prices in the public record, but in terms of the Massachusetts projects, Vineyard Wind and Mayflower Wind, those were the lowest prices. The New York projects, Sunrise Wind and Empire Wind, were the highest prices. And the difference between the low and the high price includes certain amount of money for the forward capacity market, which could range from about $4 a megawatt hour to $11 a megawatt hour, based on how one tends to look at it. And then there are also, and then what's interesting is that in the New York contracts, the forward capacity market payments are guaranteed to the developers whether or not they receive those capacity payments. So there are subtleties that can be understood relatively quickly to make sense out of these numbers. And then finally, New York was famous for being a leader in attracting economic development to the state. And so both Ørsted and Equinor made significant economic development commitments to the state. And I would encourage Connecticut and other states to look at the manner in which those commitments were made, and to look at all of this with a critical eye, to bring back to the point that Mr. Béchant made, which is that how do you know when you make these commitments that you're going to get what you're asking for? And this is something that Connecticut and other states do very well and have a very long tradition of doing when it comes to building your bridges and your buildings and the rest of our infrastructure. And so I think the key is to understand this as these are infrastructure investments.
Thank you. I wish we had as much confidence in our ability to price out offshore wind projects as we do with bridges, with which we have much more experience. Does Tufts or anybody have a think tank on how one should be viewing these contracts? Is there a place where we can find best practices?
I would refer you to our report, which is footnoted in my testimony, and that's accessible via a series of offshore power research and education reports on our website, our digital library, which we've written in answer to questions that have emerged from decision makers over the last several years. I am of the opinion that folks in your position, and then also together with other state decision makers, staff members, and developers, everybody would benefit from putting offshore wind pricing on a consistent footing so that people can compare apples to apples across states and across projects. I think at this point, everybody we've talked to, that's something that people would be interested in. And I think that all sides suffer in different ways from the fact that we don't have a common language. So I agree with you, and I'm hoping that community will emerge that can figure out how to do this. I think that I think it could happen relatively quickly if the right people were brought together, under the right authority to do so.
Well, that does sound like marching orders for us. I would suggest that given how desperate we are for renewable energy to supplement our existing capacity market. We have a lot of incentive to find a way to do this well going forward and be more discerning as we add more projects into the mix. So your input is very valuable, and I nominate you for taking the lead on building this consortium. Representative Mashinsky.
Thanks, Mr. Chairman. Are you able to answer the noise standards question? Is it in your report?
We have a section on noise standards in our report. And I will share with you, this is not my area, but I will share with you what I've learned from fellow experts. The questions about noise standards are a question about at what level of a threshold noise can you tolerate? And some of these standards are actually being set at the level of physical damage, let's say to the hearing or, or to the bodies of these marine mammals, North Atlantic right whales. There are other noise standards, though. For instance, if you were below that threshold, but let's say that you disturb the mating characteristics or the feeding or the migration patterns of these animals, you may do as much damage to the population as by literally physically hurting them. And so what is needed now is an understanding and a consensus of appropriate noise standards and appropriate methods for meeting these. So numbers such as 160 decibels, get talked about a lot. There are arguments out there why it should be lower than that. And I think the question is as well, can you meet those standards? And so this is a coupled conversation, and I'm here to encourage everyone to talk about the noise standards and about the options for meeting them in the same conversation. And this necessarily brings up two different communities. And I think this is one of the compelling things about the offshore wind industry is it's bringing together literally dozens of different communities that are trying to figure out how to talk to one another so we can do the right thing.
Okay, thank you.
Thank you, Representative. Representative Foster.
Thank you very much for being with us today. I'm sorry that I missed some of your testimony, but I have to say I have a lot of respect for the policy advocates at Tufts. Their nutrition and food science policy department does a lot of great work in line with my own. So I am curious about the field of research that you're in and how that might mesh with state and, just for my consideration why we're here, sort of federal partnership and research funding. How well are, as you come here to testify before these two bills today, how strong is the research funding for you to answer the research questions we need answered to inform the policies we're talking about? Do you feel like the state of the science is strong?
Mr. Speaker, that's reflected in the hearings I'm supposed to have.
Do you think the state of the science is strong enough that you've been able to answer research questions adequately to inform the policy juncture we're at now and what comes next?
Thank you for that question, Representative Foster. I think it's a very timely question. The short answer is that we have not made adequate and appropriate investments in research yet as a country, but there is a lot of very strong momentum moving in that direction, and we are very grateful to several of the federal delegations from New England being on top of this issue, going back to Cape Wind days, understanding that we were going to have to create our own industry. And how would we do that? We've always accepted that the first tranche would be built primarily by European expertise and European labor, but how do we can own our own destiny? And so there's been a lot of work over the last 7 or 8 years to convene universities across New England. We're having conversations with the University of Connecticut later on this week. We have relationships with the University of Rhode Island. I work with URI to monitor the Block Island turbines and also the CVOW turbines down in Virginia. So there's a lot of very valuable ongoing work, number one, that needs to be looked at and used. And number two, a lot of the way that we have funded this work in the past has been focused on technology. Oh, if we just come up with the right technology, somehow we'll magically solve the problem. We're in an area now where the scale is large enough that there is no such thing as technology that is uncoupled from society or economics or culture or history or any of the environment, any of these other things. And it's the bringing together of the sciences, the engineering and the humanities and the social sciences that needs to happen. And quite frankly, our funding mechanisms in this country are not geared toward that kind of integrated research. And so we believe that there are cutting edge initiatives to do this, but we would very much appreciate leaders such as yourselves considering that, thinking about that to bring together the right community, because we have to bring the community together to work together on this.
I appreciate that answer. In my field, I see a lot of RFPs that come out that like favor multidisciplinary or interdisciplinary research, but it ends up tending to be someone who's like trained in another field, but is in the same department now as someone else. And so it's not really pushing the envelope on interdisciplinary practice. And I'm not an engineer. And so that wouldn't, in your field, I'm curious about what that is. So if you were to give us marching orders, you've given us 2 bill numbers to support an integration. Are there research questions you have left? You recommended a consortium to work on answering some of these research questions. Are there types of expertise we should be considering in that room if we were able to consider a group like this? And then have you thought about how it would be funded to have a consortium of like that work?
Absolutely. So I would say for us, the 3 big items are infrastructure, supply chain, and transmission. These are 3 things that do not figure themselves out in the market by themselves. They need help, and you need the public sector and the private sector working together to figure out these large scale, both from a economic, spatial, and temporal scale, these very large scale items. So from an infrastructure point of view, in my opinion, we need to figure out how to make our foundations and our transmission system last for 100 years. I have no idea why we're planning to build these things and then make them last for 25 years. Are we going to meet the energy transition in 2050 and then tear it all out and build it over again? The Hoover Dam is over 90 years old. We're not going to tear out the Big Dig anytime soon that I know of and try to rebuild that. And most of our bridges, and I spent a lot of my career renovating buildings, and we tend to try to hold on to our buildings as long as we possibly can. So we have got to be thinking in these timeframes. Coincident with that is then how do we think about long-term leases, long-term financing? These haven't even been issues on the table yet because we haven't put them on the table. So thinking long-term, I think that's number 1. Number 2, something that the state of Connecticut, we are extremely proud of in New England, the leadership that Connecticut has shown, specifically deep in the work on integrated transmission and in thinking about the offshore transmission grid. This is going to need a lot of work. A lot of that work has been funded already in some of the recent bills, the IRA and the IIJA, and understanding how that grid is going to be constructed, the technology, and then how it's going to be managed and built, and the role of the DOE and the role of the states. This is a really big picture issue. And then finally, the supply chain. People want the offshore wind. In my experience, decision makers want the offshore wind because we're going to get the jobs. And as you heard Mr. Béchamp talk about, we're not getting the jobs right now. So how do we design for our part of the world? For our part of the world, part of it is let's design it correctly for the environment and let's design it correctly for our people. How do we do that? There are choices available to us, and there are innovations, and there are ways that the United States can take control of its own destiny with help from Europe. This isn't about kicking our European friends and colleagues out the door. They're actually, most of our colleagues are quite eager to help us figure this out and are very excited about the United States basically we're starting by building the largest offshore wind farms in the world. We have some of the most ambitious goals in the world, and we know we're going to need help to do that, but we're going to have to think about it as a system. So.
Last quick question. Sorry. One of the things that I noticed that we do when we're as the legislature, we ask our state agencies to monitor efficacy of programs and projects that they're piloting or launching. And oftentimes the metrics that they're using to evaluate success are metrics that are great from a programmatic standpoint, but in like my field of health sciences, they're outputs, not outcomes. Are there things that we should be monitoring from an outcome standpoint that we're not considering in looking at the success of the wind projects that we have currently?
I appreciate that question. And I think the DOE just put out an RFI for a centers of excellence on infrastructure, supply chain, and transmission. And it is my opinion that a center of excellence like this that convened, supported throughout New England with matching funding, that New England comes and competes for this center and asks DOE, because we're the center of the offshore wind industry, a center of excellence like that could begin to work on these kind of things together, not alone in the ivory tower, but together with decision makers, together with the New England states, and with the developers and with industry stakeholders to start to think about these things. And so we believe that there's a third estate. You have the public sector, the private sector, and the academic sector is is another estate that can bring expertise, impartiality, and sort of a long-term view while you all are doing the hard work of figuring out the day-to-day. And we'd like to figure out how to mesh those together.
Thank you, Representative. We really appreciate your bearing with us all this time. It sounds like we want to talk with you again. Really like the idea. We do have one more question from Senator Needleman.
Thank you so much for coming and staying and being patient today. We are sort of rushing towards a short recess here to work on our agenda for tomorrow, but a couple of comments first. One is I do appreciate your acknowledging the work that Governor Lamont and Commissioner Dykes are doing in trying to forge a regional approach to this. I think that when it comes to transmission, if I've learned anything in this world, transmission is sort of the name of the game here. Spot isolated, the world of spot isolated power plants in the world of renewables is probably obsolete. And we did build a grid that lasted 100 years. We now need to build a grid nationally that lasts another 100 years. And I think that we're all trying to figure that out. This is one of those cases where one could argue that the 50-state model may not be the ideal way to approach this, where each state is sort of doing its own thing and we're running in a million different directions. We're not thinking holistically because it's not what we do. And I encourage that we do that. And hopefully we get some strong leadership out of Washington that is consistent from administration to administration, that acknowledges the need to find the best path forward. And if you don't build a transmission network that's almost coast to coast, north to south, that includes Canada, that includes Mexico, we're not going to get our solutions to this. The East Coast of the United States offers a unique location for the placement of offshore wind energy, which, you know, is one of the potential great salvations in this if we can get it right. So I wanted to say that one other point that that you made, which, you know, I'm a mathematician by trade, so I'm not, I pick up on numbers. You said that Connecticut uses 0.7% of the total energy generated in the United States, and we represent 1% of the population at a very high level. That number probably reflects all of our efforts at energy efficiency to drive down the per capita use of energy per household, per family, per business. So public policy here, although it isn't free, it has actually driven a below average need for energy in this area. And it's actually a material driving down of the usage, which reinforces not that it helps anybody when they open their bill, you know, on the 10th of the month or whenever people get their bills in the state, but that we have worked hard acknowledging where we are on the pipeline, where we are as in terms of a grid to actually try to drive down the cost per capita of electricity, or at least keep it on par with other states, even though our per kilowatt hour price may be a little higher because of some of our public policy stuff. So I don't really have anything else. I want to reiterate what Rep. Steinberg said about the bidding that's going on right now, and the range in bids for offshore wind, the way procurements are being done state by state, and anxiously awaiting for New York's most recent round of procurements, because the pricing could be quite different based on the supply chain problems. And I think that when baseload natural gas fired energy is 2.5 cents a kilowatt hour, everything else is going to be hard to sell to the public. And we're looking to do that. I mean, this state has an enormous commitment of 2,000 megawatts, 1,000 megawatts of battery storage. Were all critical pieces of legislation that we did, and we want to continue on that path. But the three legs of the stool of reliability, cost, and climate change mitigation or environmental impact are the three legs that we need to be looking at. No one is weighted more than the other. And while we're doing that, every kilowatt hour that we don't use is a kilowatt hour that we save. So thank you for your time. I appreciate your coming today.
Thank you, Senator Needleman. Chairman Steinberg, if I may, just one comment. As a fellow New Englander, I am excited about New England's opportunity to lead. And I am excited about watching New England come together. 10 years ago, it was very clear that no one was really talking to anybody about a lot of this stuff. And I have specific memories of times when it was, very difficult to be thinking about the states talking to one another at the level that they're talking now. So the work that's actually happening in transmission, the talk about regional procurements, this is very, very exciting. And it's heartening to see that come together in such a short period of time, quite frankly. So I think that the opportunity, and the reason I mentioned the 0.7%, Connecticut's opportunity is to, in addressing its own needs, develop the experience and the expertise that it can use to help the rest of the country and the rest of the world. That's going to benefit your workers. That's going to benefit the rest of the world. That's going to benefit New England. And I think what I would urge everyone to do is let's zoom out far enough that we're actually looking at where are we going in 2050. And let's think about this in economic terms and how do we work together to really make the most of this, because we have a lot of work to do. And once we're done decarbonizing Connecticut and the rest of New England, we'll have a lot more work to do after that. And that'll be good for the people who need jobs, I think.
And I do appreciate that. And all I want to say is that I'm not sure that was driven by a conscious thought process as much as necessity being the mother of invention. We're facing a crisis. We know that. ISO has hammered home the idea that we have a major winter reliability problem. And I think finally that has gotten into our heads that we really need to do something collaboratively. So thank you.
Thank you, Senator. And as you aptly put, we have a lot of work to do, and we're eager to have your input as we go forward. We're going to take a break, which has been caused by yesterday's dislocation. View this as sort of an intermission in today's public hearing. We will recess for half an hour until 3:45 so that the leadership of the committee can consider our agenda for tomorrow's committee meeting. We will see you at 3:45. We're in recess.
I want to thank everybody for their forbearance as we held a recess for a half hour, which lasted 35 minutes. Just pulling back up to the list. We're reconvening the Energy and Technology Public Hearing. Next on our agenda is what do we have?
Why don't we go with
No,
Representative Hughes?
Representative Hughes. I'm just like,
Well, thank
sorry
you
for
so
being brain dead.
Thank you so much, Chairman and esteemed colleagues on the Energy and Technology Committee. I'm so pleased to go kind of after some of the expertise that just testified before the break, because I think Connecticut gets one shot at making a historic transition to offshore wind and with the least harm to our fragile marine ecosystem. Our marine ecosystem, we already know, is in danger of collapsing in this near future. And this shot lies within our state, creating ethical, environmental, and labor standards that offshore wind developers must adhere to, and that we have some metrics for accountability to that. We get to set the bar in Connecticut, not just for a state or even the whole Northeast, but for the country. And as you've heard, the train is leaving the station, and I so want Connecticut to be on this train. Not only do we have one chance to create an accountability metric with the mitigation fund, HB 5223, but we can also include some of the language around environmental standards and local labor standards. We also want to update the language that is proposed in 5222, which refers to the 2019 procurement for offshore wind, HB 7156. We want to update the language to keep this Environmental Standards Commission current with all procurement and not restart it every time we procure a new procurement of offshore wind. It's really important that we learn from our first procurement, we learn from the procurement around it, like you heard from the testimony, and we apply that learning and research to best practices, evidence-based research, how best to mitigate harm by preventing harm. As best we can, and also really starting this exciting labor green economy, which we already have some infrastructure federal dollars to train this workforce. We already have that in the pipeline. Let's use it to train this offshore wind development workforce. We have this one opportunity in front of you to strengthen the impact and economic viability to the Connecticut workforce, and also to strengthen our standing as a climate and coastal leader using independent evidence-based research to fortify those standards. You know, we can create a standard based on the best practices that we have now, but also what you heard before, thinking ahead, thinking big, thinking long term. We only get one shot as these procurements and industry accelerate. All of this is accelerating in our backyard. Let's be ahead of the game. Let's collaborate with our other partners in the states around us, or we'll be behind the 8 ball. We'll be behind New York once again. Let's raise the bar in this climate crisis, protect our marine ecosystem, create mitigation and accountability safety measures, and demonstrate a responsible transition of our economic and our energy to renewable energy now. I mean, you heard also earlier today that New London Pier didn't produce the jobs that they said they were going to. What did we learn from that? How are we going to build that in to our labor standards? To, you know, if you say you're going to produce this many jobs, how can we create a standard that says if you don't, then we charge you, the developer, the lost revenue, at least the lost tax revenue from those jobs that you committed to. On behalf of Connecticut species, I thank you for taking these standards to heart and raising the bar.
Thank you, Representative Hughes. I appreciate your passion on this issue. We're learning a lot, and I'm hopeful that we can get to some resolution that manages this environmental issue, this workforce issue, as well as managing it against the cost, which is sort of a critical
long term. Yeah.
So anybody? Yeah, sure. Chair Steinberg.
Yes, thank you for your testimony. I mean, I took your point that we only get one shot at this, but actually I'm wondering, it's all the more important that we have some sort of think tank on these issues, because the technology is evolving so quickly that by the time when procurement expires, the world is entirely different. So I think what we need is more than just looking at the snapshot, our ability to be nimble enough to take advantages of evolutions in technology. Again, we're going to have the same issue, which is the newest technology tends to be the most expensive, and that has the impact on the ratepayer. But I'm thinking that we need something for the long term, so that as this industry matures in the United States, as it has in Europe, we can take full advantage. So,
Yeah, and thank you, Chairman, because you speak to, that's why we can't prescribe what those technologies should be, but have some standards on both least harm to both and safety to our marine ecosystem and our migratory birds, but also our human labor system. And that's why maybe looking at it as an integrated standards approach is really helpful, and engaging our research partners. We've got flagship research here in UConn and other universities, and they're already designating certain ecosystems around the Stratford wetlands and down in Norwalk and up in Stony Point. We need to integrate that research that's going on into climate change, rising sea levels, warming seas, and how this is impacting our species extinction and that kind of thing. I'm very
I
excited.
don't know if we're
about
going to
it.
take on species extinction.
Well,
this
okay.
session.
But I'm excited about integrating them, and we have some meetings with them to look at, because that's their goal too, is to educate students for the climate future.
Thank you, Mr. Chair.
Thank you, Mr. Chairman. Any other questions? There being none, Carrie Lynch from the Nature Conservancy is up next.
Hello, good afternoon, honored chairs, Senator Needleman and Representative Steinberg, and distinguished members of the Energy and Technology Committee. I'm Carrie Lynch, Climate and Energy Policy Manager at the Nature Conservancy. Thank you for the opportunity to present testimony today on behalf of the Nature Conservancy on two bills, Senate Bill 997 and Senate Bill 123. The Nature Conservancy supports Senate Bill 997. We believe that this bill will help PURA facilitate procurement procedures for renewable and clean energy. Such procurement modifications will help Connecticut achieve its clean energy targets in an efficient and timely manner, and we support these efforts. The Nature Conservancy opposes Senate Bill 123 as written. The purpose of this bill is to address specific measures in Connecticut utility laws to reduce costs for ratepayers. And while we agree that the recent increase in electricity rates is an issue that should be addressed, it is not clear that this bill will help Connecticut ratepayers in the long term. There are sections of this bill we do support, but there are also sections we do not. We support Section 1, which gives PURA flexibility to decouple distribution revenues from the volume of natural gas and electricity sales. We believe that this is an important action that should be immediately addressed, particularly because the state is highly reliant upon natural gas for electric generation and heating. We also support Section 8, which increases the RPS requirements. The Nature Conservancy believes that the RPS can be used as a tool to support and drive investment in qualifying renewable energy technologies. We do not support Section 2, which allows a quicker resolution to settlements in contested cases and proceedings. There are advantages to settling complex cases with minimal public participation and transparency, but the use of settlements by the utilities are overused and may not be in the best interest of ratepayers due to transparency and reduced settlement amounts. We do not support Section 3, which calls for a redesign of the electric billing format. We believe that this is not necessary given the recent final decision in PURA docket number 14-07-19 RE06, which intended to redesign residential customer bills and their respective websites. We do not support Section 15, which establishes a task force to examine the EDC's procurement of electric generation services for standard service. The establishment of such a task force presumes that the state can effectively reduce electric rates through generation costs outside of energy markets. The Nature Conservancy has long been advocating for regional energy market reform and have supported efforts from NESCO and the New England Energy Vision. Additionally, the task force gives a lot of power to the EDCs who have not been incentivized to reduce consumer costs as is evident from their third consecutive year of reported revenues of more than 1.2 billion. And finally, we object to any section redefining or using trash to energy to fulfill Class 1 RPS requirements. Incineration is extremely hazardous to the environment through the release of air pollutants, and these incinerators are often located in or near environmental justice communities. We think that Senate Bill 966, which this committee has already reviewed, which also attempts to address electric rates, is better suited to increase customer bill transparency, reduce rates in the long term, and increase stakeholder involvement. We would recommend that multiple sections of Senate Bill 966 be incorporated into Senate Bill 123 if it is to move forward. And with that, thank you for the opportunity to present testimony on this very long day.
Thank you, Carrie. Do you have any questions? Sure, Senator Fazio.
Thank you, Ms. Lynch, for your testimony. I read it yesterday. I thought it was very nuanced and interesting, and I agreed with some parts. I disagreed with others, but I thought it was thoughtful, and it was a bit heterodox because it was different than the other testimony, which was submitted on 123. So I thought it was also interesting from that standpoint. While there is some differences, I certainly appreciate the contribution and think that they should be taken into account across the board. So thank you for your time.
Thank you.
Thank you, Senator Fazio. I don't see anybody else. Thank you so much for your testimony. Representative Porter. Welcome.
Thank you. And good afternoon, everyone. Happy to be here, and I won't be long because I think you guys have heard plenty about House Bill 5223. But good afternoon, co-chairs, Representative Steinberg and Senator Needleman, ranking members Representative Buckby and Senator Fazio, and distinguished members of the Energy and Technology Committee. My name is Robin Porter. I represent the House 94th District for Hampden and New Haven, and I am here just to express my staunch support for House Bill 5223, which is an act requiring offshore wind developers to create a compensation fund. And as the bill stands, it will require offshore wind energy developers to create a fund that will compensate for negative impacts to fisheries and the environment, as well as compensate for not creating the number of jobs agreed to in their contracts. And we heard about what happened in New England, so I feel that that is really important. But then there is the fact that President Biden's administration is looking at ways to ensure that our commercial fishing industry is paid for any losses it experiences, right, from the expansion of offshore wind power. This new effort was initiated in part, which I found interesting, by a June 4th, 2022 letter to the president signed by governors of 9 coastal states with sizable fisheries, Connecticut being one, New York, Massachusetts, Rhode Island, New Jersey, Maryland, New Hampshire, Maine, and Virginia being the others. So I don't believe that Connecticut can afford to wait. We must act now and lead the way to provide fishing fleets with the standards necessary for accountable environmental stewardship. Furthermore, we know that commercial fishing fleets have staunchly opposed offshore wind projects due to their significant threat to the critical catches of their market, including clams, lobsters, scallops, and squid. It is also important to note that the U.S. government researchers estimate that offshore wind projects could displace some commercial fisheries by as much as 25%. The National Environmental Policy Act requires projects on federal property to avoid, minimize, or compensate for their impacts, and it only makes sense that Connecticut should follow suit and put in place the same protections for our state. In closing, I am requesting that this committee consider amending the bill with the concepts outlined in HB 5221, which is an act concerning noise limits on offshore wind facilities and environmental and job creation factors in the procurement of wind energy. This addition would bring the objectives of the bill before us full circle. Our marine species are already experiencing stresses associated with underwater noise pollution and climate change. Therefore, it is critical that we do all we can to reduce the additional impact of noise generated by pile driving and/or allow methods that avoid pile driving altogether, such as gravity-based foundations. There is no doubt about it, Connecticut has a leading opportunity to advance environmental solutions that would create US-based jobs and deem us a national and global leader on environmentally sound offshore wind development. And as the former labor chair, I have to stress what I know you guys have already heard, the fact that gravity-based foundations would bring 30 times more jobs than our monopiles, and it would help to expand what we're currently doing, not to mention that we already have union staff and members here that could easily be trained for these jobs. Concrete is one of the three things that the Carpenters Union trains on, and we do have the workforce. And it would also allow us the opportunity to put folks to work that need to be working right now in this industry. So we're not just talking jobs, we're talking careers. And I thank you all for your attention.
Thank you so much, Representative Porter. There seems to be a lot of forces sort of aligning with the wind. I'm going to do one of Representative Buckby's. I'm not as good. I'm nowhere close to.
I hate to say it, but you're not.
No, I'm. And I thought you liked me.
I love you. I love you, but the truth is the truth.
No, I know. And the truth hurts sometimes. Oh, does anybody have any questions for the representative?
I think you guys have asked all the questions that could be asked on this, but thank you again for your attention and for considering this piece of legislation.
Thank you.
You're welcome.
I'm sorry. Next up is Thomas Schacht. No.
Yes, thank you. Thank you very much, members of the committee, for giving me this opportunity. I'm here to testify in support of House Bill 5361, which relates to the resolution of disputes involving interlocal water agreements. I received this morning a copy of some testimony in opposition from the Connecticut Water Works Association, and I'd like to address what I think are some misunderstandings there right out of the gate. First of all, CWWA describes this bill as subjecting municipal water companies to unnecessary oversight. That's not accurate. The purpose of the bill is not to subject anybody to any type of oversight. The purpose of the bill is to provide a service to municipalities that need assistance in resolving disputes. Secondly, CWWA says it's unclear as to the nature of the dispute the bill is seeking to authorize PURA to adjudicate. I agree that the text of the bill is unclear with respect to that, but as you will hear from what I'm about to say next, this is to use the expertise of PURA in resolving disputes that are within its scope of expertise. And the regulations of DPH and DEEP that are cited by CWWA are simply irrelevant. Connecticut does not regulate the operation of the business aspects of municipal utilities when they operate within their own boundaries. It also does not really regulate the operations when they cross boundaries. But that is important because our faith in the system of political accountability falls apart when the customers for a utility don't get to vote in the elections of the municipality that is providing the service. So in the absence of that check and balance, House Bill 5163 would be a positive step in the direction of restoring some capacity to resolve disputes. I would also point out that in 2011, the legislature repealed Section 7339F that required that interlocal agreements include a mechanism for dispute resolution. There is now no requirement for that. Here are some examples of the kinds of disputes that have existed. Every example I'm going to give you is something from Connecticut's history that PURA could assist municipalities with. And this would not be oversight. This would be at the request of one of the parties in the dispute. First of all, in interlocal agreements, it's entirely possible to have water rates that are completely unhinged from any connection to the cost of services. In the extreme, I'm aware of a situation in which there was a dispute over contract terms between two municipalities. One municipality imposed 100% surcharge on the other municipality, and internal documents indicated that the sole purpose of the surcharge was not to compensate for cost of service, but to punish the other municipality and to force them to capitulate to the terms of the selling company. A second kind of thing involves disputes over access to or shared use of essential infrastructure. It doesn't make sense to duplicate a lot of water infrastructure. Sharing is necessary. There was a situation in which two municipalities had to cooperate in providing water to a third. One of the municipalities needed to use the pipes of a second, but did not want to pay anything for that. The result was an expensive lawsuit that was ultimately settled for an amount less than $20. A third concern involves leverage and control over water to gain unrelated economic advantage. In one instance, a municipality sold water to another municipality on condition that the customer municipality refrain from using any of that water for commercial enterprises. It was only to be used for residential consumption, not any kind of economic.
Excuse me, Tom, our timekeeper is not here right now, but I'd like to remind you that it's 3 minutes.
All
So
right.
wrap it up. I'd appreciate it.
Okay, I will do that. So basically, what can happen between municipalities is you can end up with scorched earth negotiation tactics that would never be tolerated from a regulated private utility. In the extreme, there have been cases where one municipality literally turned off the tap and refused to sign up any new customers, shutting off economic development in a neighbor. There are existing contracts that have arbitration clauses. Pura could provide arbitrators that have expertise specific to utilities and could provide a service there. Likewise, future agreements, to the extent that they include provisions for conflict resolution, could turn to Pura for this service as well. So based on those kinds of concerns, I'm speaking in favor of House Bill 5163. Thank you for your time, and I'm open to any questions.
Thank you so much for your testimony. Does anybody have any questions? Representative Steinberg.
Thank you for your testimony. If I understand you correctly, the way that these disputes are being resolved at this point is either through a court of law or through aggressive use of leverage. Is that a fair statement?
Yes, or sometimes there's just been stalemate. There have been negotiations that went on for more than half a decade without resolution.
So you're proposing that Pura becomes the referee in this?
Well, so to give a little more context, in the state water plan, there was a proposal that the State Water Planning Council provide this kind of arbitration service. There's been at least one request for them to do that, to my knowledge, but they declined to participate due to concerns about conflict of interest. And as a practical matter, that body lacks the independence that Pura would have, although they probably have the same expertise. So the involvement of Pura would bring both independence and expertise to conflict resolution when the parties need arbitration.
Given the fact that Pura has a pretty full plate these days and is under-resourced in general, it's important for us to understand how many of these kind of disputes would you imagine would happen in any given year?
I have no idea, but when they happen, they're very important to the participants.
We have to figure out.
I would expect that they would be infrequent because these interlocal contracts tend to be relatively long-term. And so the issues usually come up around contract renewal or contract modification. And that's something that happens, on a time frame measured sometimes in decades.
I happen to notice that as of this date, Pura has yet to comment on the legislation. Have you had any conversations with them?
No, I've only had conversations with the legislator who has proposed the bill, Representative McCarty.
Thank you, Mr. Chair.
Thank you, Mr. Chairman. Appreciate your testimony. James Williams.
Thank you.
James Williams is up next.
Hello,
There you go. How are you, James?
how you doing? Oh, so hey, cause you can hear me?
Can hear you fine. Thank you.
Good. So I was well, basically I want to testify on a bill to basically to pass a law to what is it? I think it's like I guess like energy customers who have a hardship basically to use third party energy energy suppliers. So basically I want to testify on this bill because I personally use like direct energy. It's an energy supplier. I think it's like out of Ohio, and just 3 other energy suppliers that supply energy for the state of Connecticut. So because there's already companies doing that in the state of Connecticut, I look at that proposal and I'm thinking, you know, probably the committee could change it around to basically to enlighten the residents of the state of Connecticut of their options to switch energy suppliers, because it's already there's already energy suppliers that's already supplying energy. Third party suppliers already supply energy in the state of Connecticut. So I will just I just want to testify on that. One of the companies is Direct Energy, another one is Spark Energy, another one called Consolidation. I have used all 3. So I also wanted to enlighten my fellow residents that these companies are out here and they charge between 10 to 15 cents per kilowatt, which is way more cheaper than whatever source in UI is charging. Well, I guess the minimum minimum right now is like about 21 cents per kilowatt. So I basically wanted just to testify on that bill, and I approve of that proposal, but it needs to be tweaked into more so enlighten residents that these options are available, and for everybody, not just for people who are low income or just like people who have hardship. It's for everybody. I'm pretty sure everybody want to save $1, and when companies compete, consumers win.
Thank you so much, James. So the market is open right now. This is just allowing people to access the market that are considered hardship customers. Right now, they're not allowed to access the market for energy. They have to buy from Eversource. And I think that I appreciate your testimony. Anybody have any questions? Thank you so much.
Thank
you. Next up is Diane Hoffman.
Thank you. Dear honorable members of the Energy and Technology Committee, my name is Diane Hoffman. Thank you for this opportunity to speak on behalf of HAFT, Hamden Alliance for Trees. We strongly support HB 5108. We also believe that more changes are needed to make a fairer and more effective bill. We have recommendations regarding more time to object and ways to streamline the objection process in our written testimony that I will not go over now in the interest of time. We strongly believe this bill should include all residents. Residents should not have to be property owners to have a say in how our trees are treated, since we all rely on the essential benefits trees provide. Trees are a community asset. Utilities should have to post all trees planned for pruning and removal so everyone in the neighborhood can see what is happening and appeal if they choose. Our written testimony has recommendations regarding trees on private property, including not allowing the removal of healthy trees by the utilities. Such removals would actively work against achieving our climate goals. This is not in the interest of resilience. It only serves the utilities' bottom line. It is also imperative that the legislature address many weaknesses in section 16-234, which we detail in our written testimony, including imposition of fines not recoverable from ratepayers for breaches of 16-234. If clear cutting is planned, an environmental impact statement should be required to better evaluate the plans. Our underserved communities are the most negatively impacted by inappropriate pruning and tree removal by utilities. The removal of trees contributes to the creation of heat islands and increased air pollution, resulting in increased medical costs and in physical and emotional pain. This is a public health issue and an environmental justice issue. It is also a financial issue. The U.S. Forest Service's free program, iTree, provides information on the savings trees provide in communities throughout the United States. Our written testimony has a link to iTree. Current utility company practices work against the governor's executive orders, the work of the GC3 and the regional COG hazard mitigation plans, as well as local plans of conservation and development. Utility practices must be better controlled. We call on our legislators to look at the full cost of tree removals by the utilities, environmental, economic, medical, and social, and require proof that their process is reducing the threat or danger of severe weather and making us more resilient. Lastly, much of this conversation would be unnecessary if we were pursuing undergrounding in our state. Undergrounding of utilities is now recognized by FEMA as an important and legitimate use of tax dollars. Undergrounding is improving resiliency in communities around the country.
Summarize, Diane.
Yes, and it's existed in Europe and New York City for decades. So the utility companies must participate in the 21st century and address their role in contributing to the climate crisis we are experiencing. They can afford to follow the law and do their job in an environmentally responsible manner. Thank you very much for your attention and serious consideration of our requests.
Thank you so much for your testimony, Diane. Does anyone have any comments or questions? There being none, really appreciate you taking the time and being patient today.
Thank you.
Ms. Emily Gunther.
Hello, can you see me?
We can, yes. How are you?
Hello, I'm good. The other Emily Gunther on is my husband, Aaron. Hello, representatives and members of the Energy and Technology Committee. My name is Emily Gunther, and I'm speaking today in support of proposed bill HB 5108. As Tracy mentioned earlier, I'm here to tell you about our personal experience with Eversource and their clear-cutting practices around transmission lines. My husband and I are first-time homeowners and closed on our house on Littlebrook Road in Darien in mid-December 2022. And upon closing, the settlement agreement between Eversource and Darien was brought to our attention. We were shown a map of Littlebrook Road where marked, so we were led to believe that we would not be impacted.
I think you froze for about 5 seconds there, right after you moved to Darien.
Oh, sorry. Can you hear me?
We can now.
Oh, sorry. Okay. So we were shown a map of the trees that were going to be cut down in March 2023, and not any of them were on our property. So we proceeded with the closing of our house. And after moving into our house in mid-December, I received a courtesy notification voicemail on January 4th, informing us that Eversource would be doing tree work on Littlebrook Road on the DOT and Eversource property only, which was not part of the town tree work taking place after March 1st that we had been notified about during our house closing. This was something completely separate that had never once been brought to our attention. Being brand new to the town and not yet knowing our neighbors, we had absolutely no idea what to do. We reached out to Town Hall and Eversource, who ping-ponged us to each other and gave us no options to stop it or negotiate re-landscaping prior to the tree removal. Our lawyer, seller, and realtor also claimed they were unaware. The week of January 9th, they informed us that they would be clear cutting everything beyond our property line on their property line, removing all screening of our house has from the train tracks. We were about to leave for vacation, and my husband and I pleaded with them to wait until we could get some more information, but they said no. And then the seemingly hundreds of healthy trees were completely clear cut by the time we got home on January 22nd. There are absolutely no plans to replant anything on Eversource and CT Dot's property adjacent to ours, which is extremely concerning. The list of concerns is in fact seemingly endless, but to name a few: public safety, particularly of children, pets, and wildlife. Our street butts up into the Selleck's Nature Preserve, which is a public park. Mental health, property values, carbon footprint, wildlife preservation, and unexpected additional expenses.
May you please?
I'm sorry. So the lack of transparency is completely unacceptable. And had we known that our property and adjacent properties would what it would look like now, we would absolutely not have purchased our home. And we would just want to be able to move forward, and we need a remediation plan that's appropriate for our community and our neighborhood. So and Eversource has left a wake of environmental devastation in what was a record-setting year for them in terms of revenue and profitability, and we should put those dollars to good use.
Thank you so much, Emily. I'm really sorry that you had that experience, and I don't know why it wasn't disclosed to you, but I think we need to look at that aspect of it, because the disclosure is really important to know when you live next to transmission lines, what can happen. So I'm really, I apologize for the fact that it happened, and we'll take a look at that aspect of it. And maybe we can talk to our friends at Eversource about doing some kind of remediation of your property in that area. I'm looking at one of your friends from Eversource right now. But you know, I think Senator Duff is your senator, and I think that would be a conversation with his office, and certainly feel free to reach out to my office, and we'll have a discussion about what can be done that's suitable for around transmission lines. Thank you.
Thank you.
Anybody have any questions? Representative Meskers.
Yeah, I just wanted to let you know you were heard today. You're not the first person to come to me with this kind of commentary. And I think it's reflective of our utilities and our Department of Transportation. And their effort to remediate concerns of either safety or transportation security and or transmission lines usually ends with a ground level assault on plant life. So I think what you're asking for is, one, a better consideration, better notification, and remediation. And I think those are the issues we need to talk about and consider. Some of that will be outside our purview because it's the DOT and that's on the Transportation Committee. Some of it's within our purview, but I think the issue of the trees you enjoy versus empty ground is probably something worth considering. So thank you.
Thank you.
Representative Meskers. Anyone else? No. Again, sorry and thank you, and hopefully we can try to help you in this specific situation. Alicia,
thank you so much.
From the Rivers Alliance of Connecticut. Is Alicia there?
Yes, I'm right here. Thank you to the chairs and the rest of the committee. I'm here before you today to testify on SB 123, and specifically now, I'm not opposed to the entire bill, but I'm specifically opposed to the removal of the guardrails around hydropower that have been in existence for 20 years in our statute. So there seemed to be a misunderstanding at the beginning of the hearing that Class 1 hydro was being introduced in this bill. Class 1 hydro, or that hydro was being introduced to Class 1 in this bill, but it was actually been in existence as a Class 1 source since 2003. And since 2003, there has been at least a stipulation that hydro be run of river to be considered Class 1. That was expanded in 2013. And I very much appreciate Senator Fazio's optimism that other regulations that apply are so evenly applied across the board, because looking at the list of certified projects, there are several that are not FERC regulated and they're in other states. So we rely on the, first of all, how even-handed or protective FERC will be And second of all, the regulations within the states that surround us that we procure hydro from and their protective standards. And as far as FERC goes, licenses last from 30 to 50 years. And just in Connecticut, we have 16 dams that are FERC regulated. 6 of those dams are up for relicensing before 2030. So if anyone had an issue with the environmental compliance of a dam, they wouldn't have the opportunity to do that for sometimes 20 to 25 years. So I'm happy to answer any questions that you have about this particular part of the bill. And thank you for listening today.
Thank you, Alicia. Does anybody have any comments, questions? Oh, appreciate your patience and staying around today. Thank you so much.
Thank you.
Jamie LaForge from Mystique Oil. Okay, Jamie is not on. Tammy, and I'm not going to get this one right, from McGuire's Oil. That's Tammy on. Right. And I apologize, Tammy.
That's okay. It's a common
How do
thing.
you pronounce that, Tammy?
It's Wazenowitz.
Say that again.
Wazenowitz.
Oh, okay, great.
Yes,
then
my Polish ancestors were very proud of that. They kept it as it was.
That's got a pun out of that one.
Yeah.
Well, thank you, and it's your turn, Hop. Thank you.
So I thank you for the opportunity today to speak with you all. I am here in support of HB 6056, an act concerning payment to vendors participating in the low-income home energy assistance program. My name is Tammy Wazenowitz. I am the operations manager for McGuire's Oil, located in Preston, Connecticut. We are a first-generation oil company, and we're in our 6th year of operation. Our service area is New London County. We have been a vendor for the Connecticut Energy Assistance Program since 2017. I'd like to speak today regarding our experience with the program. In the past year, we have experienced unprecedented market volatility. In March and April of 2022, we were receiving midday price increases from our suppliers ranging from 30 to 60 cents. These midday price increases were not reflected in the daily rate that is posted by the Department of Social Services. At times, the amount we were allowed to charge by DSS was less than what we could purchase the oil for. Numerous times, we had to hold off on oil deliveries until the DSS pricing would catch up, and even then, it was substantially lower than where it should be. Current DSS pricing is based on the New Haven terminal. The main terminal we use is located in Groton, which can be anywhere from 7 to 25 cents higher than the New Haven pricing. Last year, towards the end of the season, some vendors dropped out of the program before the May 2nd end date, and additional vendors exited when the program was extended to May 25th. We, along with other vendors who remained in the program, were asked to take on new customers to help fill the voids left by these vendors. At the beginning of this heating season, we had to really think about our participation in the program, and it was not an easy decision to make due to the volatility, but we did end up participating. The volatility still exists today. Just yesterday, we received a midday price increase of 7 cents from 2 of our inland suppliers. I will let you know that one of the factors we did not have to take into consideration when making the decision to participate was the payment by the agency that covers New London County, which is TVCCA. Since we've been participating in the program, we have always been paid by EFT, and payment is always made within 5 to 7 days of dropping our tickets off. This year, we were given the option to email the tickets to make things easier and quicker. Heating oil is the only product that the Department of Social Services dictates the price that can be charged. Kerosene and propane are both sold at retail pricing under the program. This is an outdated and unfair situation for oil vendors who participate in the program each year, and it needs to be changed. Market
summarize.
volatility is only one
summarize.
aspect of why this needs to change. In addition to the volatility, we are also dealing with increased operating costs, which
Tammy, please
include
summarize.
but
It's
are
been
not
3 minutes.
limited to insurance, repairs, repairs and maintenance, payroll, and the cost of diesel fuel. And that's all I have today, but I thank you very much for the opportunity.
Thank you, Tammy. And we understand that this is a very challenging market situation for you guys. And we've been looking at each other, wondering if it's us, DSS, or who should actually try to fix this. But I know that the oil dealers are up against it, and it was particularly bad last November because the pricing was really out of whack. So I'm not sure what the answer is, but I know that we're thinking about trying to fix this situation.
Thank you.
Representative Meskers.
Yeah, it's getting late in the day, so I don't want to keep our committee too long, but you waited for us. You made your testimony. We heard you. We think it's rational, or I think at least that it's rational that, and I just need to review the counter proposals if it's within our purview of the compensation. I understand you need to make money delivering oil, and I realize we're trying to do our best for the residents of Connecticut. So I appreciate you standing up and asking for our assistance in this. And to the extent we can, I will do my best. And I think the committee is genuinely interested.
Thank you very much.
Thank you, Representative. Peter Corral from Sea Tower.
Good afternoon, dear honorable co-chairs, Senator Needleman and Representative Steinberg, ranking member Senator Fazio and Representative Buckby, vice chairs Senator McCrory and Representative Foster, and members of the Committee on Energy and Technology. I would like to thank you for the privilege of participating in these workings of democracy, which world events remind us that we should not take for granted. And I do so in support of HB 5223, with the addition of the intents of the proposed HB 5221 regarding noise limits and job creation criteria for offshore wind. I am Peter Corral. I'm the CEO of Sea Tower. We are a company that design gravity bases for foundations for offshore wind. Our company is deeply value-driven. We go to work to fight for the climate, for biodiversity, and for good green jobs. And in my testimony today, the starting point is that there are no scientifically established safe levels of exposure of marine mammals to underwater noise. I therefore want to highlight the feasibility and the commercial viability of constructing offshore wind farms while adhering to strict noise limits. Noise limits, however stringent, will not prevent a healthy competition of foundation technologies. There are numerous types of offshore wind foundations that are effectively silent in construction, i.e. the noise levels don't exceed the background noise created by, for instance, ships. And examples of such technologies include monobucket foundations, gravity bases such as the ones we design, and suction bucket jackets. Those technologies are well established in the market. To illustrate this fact, I will quote from the website of the developer Ørsted, and I quote, "Where site conditions do not allow for an efficient or practical monopile design, a number of alternative foundation solutions are available, including the suction bucket jacket, piled jacket, gravity base, or even floating solution. The suction bucket jacket is one of a range of alternative foundation solutions to more commonly used monopile foundation solutions for locations where monopile solution is not appropriate. All of the above listed foundation solutions have been successfully used to support offshore wind turbine generators, with the choice of foundation solution often dependent on site-specific conditions such as water depth, ground conditions, and country-specific requirements." End quote. Our company, Sea Tower, has recently done 2 benchmarking studies in Europe, one in partnership with a major developer and one in partnership with a major wind turbine manufacturer. Both those studies showed the same thing. The gravity-based foundations based on European cost levels are at cost parity with monopile foundations. And as turbines grow bigger, the parity will change to a cost advantage for gravity-based foundations. I cannot speak with authority on the economics of other silent foundation types, only note that they have also been selected for commercial wind farm projects. In fact, CTOwer is currently involved in a competitive process where our client is pitting our gravity bases against suction bucket jackets. So the market for these silent foundations is vibrant. In conclusion, without strict noise limits, we are unnecessarily playing Russian roulette with the marine environment and thereby with the political support for offshore wind. Setting noise limits will neither prevent healthy competition among technologies nor make offshore wind prohibitively expensive. Thank you for your time, and I'm open to any questions.
Thank you, Peter. Anybody have any questions? We really appreciate your testimony. There being no other comments, Natalie Tallis is up next. Natalie's not on. Chris Herb from SEMA. I have Chris Herb is here. Yes, hi, Chris. There
Hard
he
to miss
is.
a 300-pound guy.
He's not on, he's here. He's in.
Good afternoon. My name is Chris Herb. I'm the president of the Connecticut Energy Marketers Association. We represent 600 family-owned heating oil dealers and propane dealers in Connecticut that are in their third, fourth, and even fifth generation. We're here in support of House Bill 6056 with some additional changes. I submitted testimony, so I'll depart from it because there were some comments made that I want to address. Number one, this program is discriminatory. It's discriminatory under the law compared to any other state. I'm going to give you two examples. The first example is that utilities like Eversource, who you talked a lot about today, are paid their full price for electricity when they're selling to low-income energy assistance eligible customers. Natural gas utilities are getting paid the full freight for natural gas that they sell to low-income energy assistance. It was mentioned that propane gets paid their full price, which we represent those guys, and I love that. Kerosene gets paid their full price, but since the 90s, heating oil, because it is the largest fuel sold to heat homes, for some reason fell under this margin over rack program. The margin over rack program does exist in some other states. It has gone away in many cases, but those states are much more fair. They prepay dealers so that there aren't cash credit line issues when they're squeezed and they don't get paid. The 30-day terms that worked when the program was established in the early 80s no longer works when you have to pay your wholesaler either at the moment that you pick up the fuel or within 5 days. So those 30-day payment terms that are established under law need to be changed. Specific to Senator Needleman's comments, we come to the August hearing every year and we talk about, well, we're gonna have to deal with it during the legislative session. This is the session that needs to be dealt with. The changing market dynamics have put such immense pressure on these family-owned businesses that they're getting cut off. I spoke to an oil dealer just hours ago who told me that New Opportunities owes them $150,000, small family-owned company, couple of trucks, that they've been cut off by their wholesaler. The reason why New Opportunities cannot pay them is because DSS has not forwarded the money to the agency to pay them. These issues continue to reoccur. So if we don't structurally change the way the statute dictates to DSS to stop being discriminatory, to be able to construct payment terms that make sense for all of the stakeholders, the community action agencies, the fuel vendors, and the state, then we're going to continue to see people leave the program. Now, we don't want to be in a position where we're running to you saying there is not ample participation to serve all of your constituents who are in need and are eligible for these benefits, but we are getting dangerously close there, and we are moving there every year closer and closer to that cliff. In my testimony, I specifically talk about those 30-day terms, the way that the lines of credit get squeezed, even other programs that DSS administers, like the SNAP program, pays Stop and Shop, a Scandinavian-based company, full rate. If you walk in with your SNAP benefits and you buy a gallon of milk, you get Stop and Shop get paid for what that gallon of milk is. Yet that family-owned company right here in your districts are not getting paid that. So we think it's discriminatory. We think that the system that it is based on in the 80s is out of touch, and we have a number of recommendations to address that.
Thank you, Chris. And first of all, I want to thank you personally for staying in touch during November and December when we were dealing with the weird price inversion. And then with the, nothing made me more comfortable than when you said the power generators were drawing oil in December around Christmas Eve, and that it was orderly. That's all I needed to hear, was that it was orderly, because this was, I hesitate to think that had the market conditions been what they were in November, when we got to Christmas Eve, what would have happened? I don't think anybody really wanted to contemplate that. I'm anxious to know what you think the fixes are here, because some of this is federal and most of it is federal. And I don't know what we can and can't do. Like I said before, we've been debating which committee this really belongs and how do we fix this. I firmly believe that although it can't be any price, any time, there should be a cost plus strategy here, that when the dealers buy oil, they need to buy it when they need to buy it. They need to commit to it when they need to commit to it. And they need to make a reasonable profit that includes covering at least the cost of delivery and a small percentage over that. These are hardship customers, but you're right. It seems like it's an inequitable system right now.
So I never want to have that conversation. I think for the 2 hours that we were on the phone on Christmas Eve, I was watching what was happening, and thank God it did work out the way it did. I would say in a century, our industry has never failed to meet its obligations, but it was a very trying year. With that being said, in my 22 years of working for the association and representing them, I think this might be the first or only second time that this bill has come up in energy. It typically is a human service committee bill. They're having a hearing on Tuesday on something similar. It's not exactly worded the same way this one. So there is 2 bills that will get 2 hearings. With that being said, frankly, the way that the federal government allows the states to administer these programs is unique to each state. Connecticut has made these decisions. If you look at our counterparts, some of them do pay full price for the fuel, like they pay their utilities to their oil vendors. Some of them require discounts off of retail, whatever your cash price is to your customers, that's more market based, so that these midday price changes that Tammy talked about previous to my testimony is compensated for. So there are other states in the Northeast under the same federal LIHEAP grant that administer it immensely different than Connecticut does. And that's why we're saying that if you don't make these changes, DSS refused to meet with me, refused to talk to me about our changes. And we talked about that in August. We talked about it again back in December when I was contacting legislators and having our members reach out to you. DSS would not meet with us, would not talk on the phone. They told us they would come up with a solution and give it to us. Well, again, I'm glad we got through the season with everyone being served, but I don't know how long we can hold on to that.
So I have another question. There, at least what I remember hearing, is there are fewer dealers who want to participate in that program. Is that the case?
It is. Now, again, there was enough to cover everybody this year, so I don't want to say that the sky is falling, but we know that there are more and more that drop out every year. Smaller companies like Tammy's have picked up more customers to compensate for the exit of other companies that can no longer afford to participate under these circumstances and just the basic economics of the program. Timeliness of payment is huge because those wholesalers are EFTing out of their accounts either the day they pick up or within 5 days. If that cash isn't in their accounts, they can't serve their regular customers. And that's what's happened to that dealer that I talked to a couple of hours ago. They can't make deliveries to their normal customers because they're not getting paid because DSS hasn't sent the money to no opportunities.
Well, I think that one of the 2 committees, I lean in the direction of believing that this is a human services issue because they're doing the paying. It's less of an energy issue, except that it's oil. But some solution needs to come out of this, and maybe we should be planning on reaching out to Human Services and seeing what they're coming up with. I know Senator Moore chairs that, and I'm hoping she's working on this aggressively right now. I will talk to her.
Thank you, and we're willing to work with anyone at any time.
Yeah. Anybody else?
I'll be quick because we've spoken extensively about it. I have 3 of these local companies who reached out, 2 more that we reached out to after we connected earlier this year. And I'm noticing, we've had conversations about where this goes in human services, but I think part of the barrier for folks is this isn't really run like an entitlement program. It's a block grant, and the block grant terms are administered by Human Services or the Department of Social Services. And so I'm optimistic I haven't seen the language for human services bill next year, but it seems like we need to change those terms for you all to see the resolution that you'd like. I lost one of my local companies did drop out of the program this year. And it was hardship for their customers who also followed up reaching out to me saying that they had, in this time of incredible stress, when they knew they weren't able to afford their heat, that having this program and the company that they had worked with for a long time helped them. And starting with a new company was upsetting to them throughout this process, and that there might not be another local company to do that work. So I just want you to know that, we've sort of said this before, but I'm hearing this and I think I understand mechanistically the challenge. And my bill that I introduced that went to human services was pretty specific on the block grant terms. So I'm hopeful that that helps. And we'll see what that language looks like next week. So thank you very much. And know that as a member of this committee, I plan to advocate to that committee as well. So thank you.
Thank you, Representative Foster. Representative Fazio.
Thank you for your testimony. And
Senator Fazio.
I'm just happy to be here. Yeah, that's funny. So margin over rack, you're getting paid in terms of delivery to a person's home, right? So 45 cents margin over rack is averaged out over some homes cost more to deliver, some cost less, and 45, whatever your average is, you're up against the 45 basis plus 45 basis, whatever you want to call it.
That's correct. The Oil Price Information Service does an average of all the wholesalers who report their price in New Haven. And what the testimony previous to this, and you may hear in the subsequent testimony, is that what's happened is that in 1990, that index worked. The differential in prices from the New Haven rack average to if you buy in Canton or if you buy in Groton or you pick your terminal was only maybe a penny or two.
Mhm.
Now it's 40, 50, 60, and sometimes more than that cents. And that's why dealers are saying that the New Haven rack average margin over rack pricing is a fictitious price to their reality of where they're purchasing. And that's why we want to get rid of that margin over rack. And we think a discount off a retailer following the model of those other states would get us away from that and plug into more of a reality of what they're dealing with in their individual unique markets throughout the state.
Yep. Simple. Makes sense. Thank you.
Thank you so much, Senator. Anyone else? No? Thank you, Chris, as always. You're a great advocate for the guys. John Staffstrom, Springbrook Ice and Fuel Service. Is John there?
Yep. Hey, can everyone hear me?
Yes, can.
Hey, can everyone hear me?
We can. Yes, thank you.
All right. Hi, my name is John Staffstrom. I am the dispatch manager at Springbrook Ice and Fuel in New Britain. Our business is located in New Britain, and we service many low-eligible, low-income fuel oil clients in the Human Resource Agency, HRA, New Opportunities of Greater Meriden, NOGM, and the Community Renewal Team, CRT. I am currently the fourth generation management of the business. I am here in support of HB 6056, an act concerning payment to vendors participating in low-income energy assistance program. The company I represent was founded in 1918. Much of the successes of our firm's longevity has been based on supporting the community that has patronized our business for so many years. One of the primary reasons Springbrook participates in the Connecticut Energy Assistance Program and LIHEAP program each year is just like we make many contributions of our resources and time to the community. There is great need to service LIHEAP customers with timely oil deliveries and service. As a vendor in the Connecticut Energy Assistance Program, I am here today to express my concerns about the way that it operates. My dad and many other fuel oil dealers have continued to voice our concern to the Department of Social Services and other powers that change needs to be considered for Springbrook and other dealers who continue to participate in the program. Since the Russian-Ukraine war, market conditions have seen unprecedented changes in the market. For us to properly serve our customers, changes need to be made to the program. Daily price volatility is making this very difficult, if not impossible, for our company to participate in the program. The new Haven rack average pricing that the program is based on no longer reflects the cost of fuel where many dealers purchase it. If a dealer doesn't load their truck in New Haven, the price differential can be dramatic, which significantly erodes the margin that is set by the state. Due to volatility, midday price increases that are prevalent this heating season. We just experienced this yesterday following the markets being closed over the President's Day holiday. It's pretty difficult to deliver fuel oil to LIHEAP customers or any customers when the wholesale price to load our trucks changes so dramatically and on and off less than a few hours notice. The LIHEAP program pays Eversource the full price for electricity, natural gas, propane, and kerosene sales. Oil dealers continue to be paid at a fixed margin price. Dealers have restriction on the price that they can charge, and this is simply not fair. Connecticut's program is out of line when compared to other states in the region. New Jersey, Maine, Pennsylvania pay the full retail price. Massachusetts and Vermont have a 75-cent margin over rack, and Rhode Island pays the cash price to vendors and LIHEAP customers. While I support the language in HB 6056, we ask that language be added to do the following. Confirm that the language is clear that whenever the wholesale price of diesel fuel is not less than $3 a gallon, the Commissioner of Social Services and all agencies administering the program shall pay the fixed margin price of 75 cents per gallon. Base the price of fuel oil on the day of delivery. Treat oil vendors the same as electric and natural gas utilities that are paid the full price for their product. Have Connecticut's program catch up to other states in the region that have fair reimbursement for LIHEAP vendors. Addressing these issues will help remove some of the price volatility risks. Springbrook wants to continue our legacy of supporting the community and especially the LIHEAP programs. I asked today to make the necessary changes to Springbrook and other CT oil dealers to continue to participate in this critical basic needs program. Thank you for your support and time.
Thank you, John. Anyone have any questions or comments? There being none. Shirley McCarthy.
Hi, my name's Dr. Shirley McCarthy. I'm a retired professor from the Yale School of Medicine, and I'm here to support HB 5108, an act concerning the process for objecting to actions taken by utility companies. Let me give you some background data that you may not know. The more trees lost in a neighborhood, the sooner people die. The more trees planted in a neighborhood, the longer people live, according to studies led by the U.S. Forest Service. In one study, they found that neighborhoods where a nonprofit planted more trees, fewer people died. The health benefits of living near these trees increased as the trees grew. As the trees got older and bigger, the mortality rates among people nearby decreased. Mortality reduction associated with trees 11 to 15 years after planting was twice as large as mortality reduction associated with trees 1 to 5 years after planting. Mortality rates increase in areas that lose tree cover. In an earlier study, an increase in deaths related to cardiovascular and respiratory tract disease due to tree death resulted from secondary to emerald ash borer. That was the cause of the tree death. And in a more recent study, they estimated that a third of premature deaths from a 2015 heat wave in Europe could have been avoided with 30% more tree cover. There are many reasons why trees increase health, which include better air quality, reduced stress, less heat island effect, increased physical activity in nearby neighborhoods, and more recently discovered chemicals secreted by trees called phytonicides that improve immune and pulmonary function. So as one researcher concluded, urban trees are an essential part of our public health infrastructure, and they should be treated as such. Across the board, the benefit of trees are astounding, and they come at a lower cost than many other solutions to healthcare. The annual cost of planting, preserving our street trees versus the cost in healthcare and lives lost is many, many millions of dollars. So this researcher said, and I agree, these findings amount to a prescription for policymakers i.e. you all, I hope, to plant and protect more trees. Time has come. The data is there. There's tons of studies like this. It is time to limit and provide better oversight over utility vegetation management. And management is a misnomer as far as I'm concerned. There's been extensive, horrific removal of trees, and you all know some of their benefits. There should be informed consent, like we physicians give patients regarding surgery and its complications. There should be informed consent that includes the benefit of street trees to provide to private and municipal tree owners when utilities inform them of
You have 30 seconds.
vegetation management. Please do the right thing and exert more detailed control and limits. Thank you for your time. I appreciate it.
Thank you, Dr. McCarthy, and really appreciate your comments. Obviously, Connecticut is a very wooded state, but has some very barren areas, mostly in urban environments. And I do believe that there is a bill that has been raised in another committee to make sure that there's adequate tree cover in the urban centers.
Mhm.
And I think that's a good start, but Connecticut is largely woods now, whereas 75 or 100 years ago, it was largely pasture land. So I think that there is a significant tree cover here, and that's not quite the issue. It's how is that distributed? So looking to see if anyone else has any comments. Thank you so much for being patient. Susan Dobahansky, Families for Freedom. Is Susan out there? No. Tom Swan. Tom is not here. No. Okay, great. Natalie, are you up? Natalie Tallis?
Yes, I can, hold on one second. I can be up. Good afternoon. I'm sorry, I'm late to this, so I will read you my testimony. Is that the procedure?
You don't have to. You can just tell us about it.
I'll do it quickly. So my name's Natalie Tallis, and thank you for having me this afternoon. I live in Darien, and I became familiar with Eversource's vegetation management strategy in May 2021. I didn't know what vegetation management was back then, but I once heard it described as a fancy word for tree cutting. Bill 5108 introduces a discussion about the process voters who object to tree removal proposals by utilities must endure. And anyone who's ever received a door tag or a call from a utility telling you that they want to take down trees on or near your property already appreciates how unbalanced and unfair the playing field is for the public. Some try to frame this debate as a choice between trees and electricity. It's not. And I've had a lot of conversations, and the one number that anyone trying to rationalize or explain why Eversource is taking down so many trees is they'll tell me 90% of all outages annually are caused by trees in Connecticut. I went to the Eversource website. What Eversource actually says is when a storm with high winds or heavy wet snow comes through New England, more than 90% of the outages on our system are caused by trees and tree limbs. So basically a major weather event causes this number of outages, and the 90% number is all of New England, not just in Connecticut. The other number that I've never heard brought up is 25%. That same paragraph says, and again, all from the Eversource website, during the course of a year, trees are responsible for approximately 25% of all service interruptions. When you go one layer deeper and look up how Eversource defines a service interruption, not an outage, and they're very specific with their language. A service interruption is caused, and I quote, by bad weather, an automobile hitting a pole or another piece of equipment malfunction, rodents or other animals interfering with electric equipment and tree limbs. No mention of entire trees, just their limbs. As you listen to testimony, or you've been listening and reading the testimony that's been submitted about improving the process to object to tree proposal plans by the utilities, please remember that keeping a healthy and mature tree in the ground is not statistically likely to turn the lights off. Eversource tells us that. I've included detailed recommendations in my written testimony, and I hope you have time to read those. But the most important change I would like to ask this body to consider is the expansion of PURE's authority so they can regulate the environmental impact of Eversource's vegetation management program. Eversource's strategy of aggressively cutting down trees, and if you haven't been to Darien recently, please come through. They're taking down trees that are in no way threatening the electric grid, and it requires immediate attention to stop them. They're cutting down an unknown number of trees. They say they don't even keep a reliable count. And with every tree cut down, a priceless environmental service is taken away from voters. The Nature Conservancy calls these services a tree's superpowers. And trees do a huge amount of free work for us as a society. Eversource doesn't pay attention to the cost benefits of these services because they don't pay for them and they don't directly generate income for the company.
Natalie,
However, the public who rely on these critical environmental services do value them, which is why cutting down healthy and mature trees has become incredibly controversial, as you all know, throughout the state. And I'm happy to take questions if you have any.
Thank you so much, Natalie. I appreciate all the work you put into this. Does anybody have any questions? I don't think so. Thank you for your patience today. I'm going to go back up the list. Susan Sabahansky. Still not on. Tom Swan. No. Ann Manuski. Sorry. Nope. Rosemary Vinci. No. Alexander Petals.
You have a winner.
You've won the lottery. You push the button.
Okay, there we go. Good afternoon, honorable members of the Energy and Technology Committee. I'm here today to speak to HB 5223. I ask that you include language from HB 5221. Along the East Coast, there have been 174 humpback deaths since 2016, triple the number in previous years. This is believed to be due to the 46 incidental harassment authorizations that were permitted for underwater surveying. The monopiling will be louder than those surveys. This is not Europe. Given the threat of lawsuit and damage to the whales and the long-term benefit of alternatives for Connecticut, it does not make sense to use monopiling. While gravity basins will cost 3% more, they will last at least twice as long. In recent years, whale deaths in Europe have increased greatly as well, but the cause hasn't been proven. Proving sound causation is extremely difficult. I remind you, sound travels about 4 times faster. And of course, whales are sensitive to sound. And while Europe may have had no problem with installing monopiles, it also doesn't have the same freedom to sue for damages as our country does. Being as gravity basins would have so many benefits for our state and fewer potential risks, it doesn't make sense for us to go with monopiles. And the moment enough evidence support does become present, not only will it have expensive lawsuits, the projects will end up being stopped, which will be costly. And we will end up having nothing to show for it, as the infrastructure benefits will have all gone to Europe. Businesses care about their own profits. Look at the most recent incident that Connecticut relates to is PFAS. They knew decades in advance of the harms of that, but it didn't matter to them. And the repercussions to businesses is just about always a slap on the wrist. And being as though these developers clearly lied to the people's faces about job creation, I don't understand why we can't cut them off immediately and switch how this project moves forward with these laws taking effect immediately upon passing. As earlier testimony said, peak peak jobs that we got were 200, which is about 18% of what there was promised. And we now have, I guess, 60 regular jobs, which is about 5% of what was promised. If someone came in here and spat in your face, you'd kick them out. I don't see why we shouldn't treat this any differently. I expect there are state or federal laws mandating that we keep to such promises that can be used to end or swiftly alter the current contract requiring this changes you've been made aware of today that will be beneficial to everyone in the state of Connecticut. Monopiles bring nothing of real benefit, but does bring quite a bit of risk. Also, P.S. someone asked about the birds. By painting one of the turbine blades black, it decreases the bird deaths by about 3/4. Oh, and also you can consider using, there's currently studies for night use of UV lasers that is expected to have positive results.
Thank you, Alexander. I appreciate that. So I'm going to just run down the list. Oh, I'm sorry. Did anybody have any questions? Oh, sorry. Representative Mashinsky.
Thank you. I just wanted to thank you for bringing up the paint one blade black because I had forgotten about that. And I knew you had the question. It was in my head and I was trying to remember the answer. But you remember the answer. So thank you for that. There is one technique that works pretty well.
Thank you.
Thank you. You want to just hit the mic? Thank you so much. I'm going to run down a few names that I don't think are on, but I'm going to run down Robert Ham, Jerry Martinez, Jennifer Tracy Carlo. Not here. Eric Hammerling.
I am here.
Hi, Eric.
Hello. Good afternoon, honorable members of the Energy and Technology Committee. My name is Eric Hammerling, and I'm the Executive Director of the Connecticut Forest and Park Association. I want to thank the committee for raising HB 5108, and with it, many issues and varying perspectives around the statutory public notice process that utility companies use when implementing vegetation management. Extending the time period for abutting landowners to object or suggest modifications to utility vegetation management plans, as Representative Mara suggested, is a good idea, though I don't have a specific recommendation on how many days more than the current 10 business days would be appropriate. I was honored to chair the State Vegetation Management Task Force in 2012. The goal of that task force, which is cited in section 16-234, was to balance reliable electricity with a healthy roadside forest. As one of the participants in that process said, I wouldn't want to live in a community without electricity, and I also wouldn't want to live in a community without trees. The public notice provisions of 16-234 were developed and updated in 2013 and 14 with significant input from utilities, tree wardens, DEEP and PURA, and tree conservation advocates. This legislation established the 8-foot utility protection zone stretching across private land as well as municipal and state rights of way, where utilities are encouraged to perform regular vegetation management, and also defined the process that utilities would use to inform and work with tree wardens, abutting and private landowners in their communities. In my testimony, I summarized comments we've received over the past decade from various participants in this process on how to improve the implementation of 16-234. If the committee uses this opportunity to make improvements, I would suggest two. First, as documented by PURA in docket 18-12-25, UI improperly used a provision in 16-234 intended for emergency situations only to avoid normal public notice. PURA's orders in that docket should be codified to disallow the use of the emergency exception to perform non-emergency work and ensure only the minimum amount of pruning is used to resolve a situation with tree limbs touching wires. Second, to focus utility vegetation management expenses on hazardous rather than healthy trees, we recommend the committee disallow cost recovery from ratepayers when healthy trees are removed outside of the 8-foot utility protection zone. Thank you, and I'd be glad to respond to any questions you may have.
Thank you, Eric. It's good to see you. And just looking to see if anybody has any questions. No, thanks so much.
Thank you.
Warren Van Wyck.
Hello, committee members. I'm speaking in behalf of SB 123 as far as nuclear and hydro. For the record, my name is Warren Van Wyck, and anyone from New York City will debate whether that should be Warren Van Wyck, but that's another discussion. A brief bio, I was in the Vermont legislature for 6 years, 4 years on the Energy and Technology Committee, and I've been following a lot of this since then, writing various programs and to get numbers out there. So what's important, as I wrote in my 4-page testimony, Connecticut and New England in general has very high electric rates. Top 11, 6 states in the top 11. So that's a concern, and that's a concern for this bill. I also mentioned, and I'm going to try and put some of the graphics in here. Here's a graphic of Connecticut supplying a lot of energy. Connecticut is punching above their weight, and the bottom here is nuclear. So the Millstone plant is producing a lot of electricity for New England, and that's why I'm from Vermont here. Why do I care? Because Vermont's part of ISO New England, and if ISO New England has problems, we're all kind of in it together. As I listened to testimony with Chair Nettleman a year ago when they had a seminar, a hearing on this. So basically, telling we want to have an all-in approach on this, because the biggest concern is these blackouts. Texas had a blackout a while ago. Just Christmas Eve, we had North Carolina and South Carolina having blackouts. New England has been close to blackouts. In my testimony, I have graphs and the importance of an all-in approach. If it wasn't for oil, we probably would have had the lights out here on February 4th when it was 10 below in Hartford and 20 below in Montreal. And if you'll look at some of my graphs, you'll see that on that Saturday morning, we were getting no energy from Hydro-Quebec because they wanted to keep the lights on, people warm in Montreal and Quebec. So again, in favor of elevating the step hydro and nuclear. I'll entertain any questions. Otherwise, I'll return to my regularly scheduled programming. Thank you.
That's great. Thank you, Warren. I think that the nuclear issue is something that we're all very interested in right now, and it is remarkable how times have changed. It provides a critical asset to the state and to the region. Anybody got there? Yes. Representative Cheeseman or Representative Buckby or Senator Fazio. No. You guys couldn't decide.
I tell you, it ain't easy, huh? Thank you very much, Mr. Chair, and thank you, Warren, for your testimony. I think the critical pieces, you're there still, right?
Yes, I'm here.
All right, good. Just making sure. Technology can be a question in this building from time to time. No, I appreciate your comments, and I obviously, one of my big points this year has been on hydro, and I think that's a critical piece. You touched on it briefly on the importance of the hydro piece moving forward for ISO New England. I'm curious if you had more you'd like to say on that. I know you felt a little rushed toward the end, but that was something you touched on that strikes a chord.
Well, I've been following this closely for the past 4 years, and especially when we find that it's all about peak. And in New England, the peaks are in the summer, but there's a lot of natural gas. So we're not in a critical situation in New England. It's in the winter, and it's the winter when it gets really cold here. It's really cold in north of us. And even though we generally might rely on Hydro-Quebec giving us 1,500 megawatts all day long, on a really cold day, that 1,500 megawatts goes to zero. And in fact, interestingly, on that January 4th, then was shipping power to Quebec. So that, coupled with the fact that New York City now plans to get 1,250 megawatts coming down the Champlain, Lake Champlain and Hudson River to power New York City, one wonders how's all this power going to come to New England. And thankfully, we've had quite a mild winter, and the oil was able to sustain us for that short cold snap. But if there's a prolonged cold snap, as ISO New England very well knows, and they have all these scenarios mapped out, if that lasted for a week, we'd be in a world of hurt here.
Absolutely, and I appreciate that. I think it's great hearing from our neighbors to the north as well. I think that's a huge piece for us to consider. We've talked a lot about ISO New England and why that's important for us to work together. So the collaboration with another legislator, former legislator, even regardless, somebody who sat on the Energy and Technology Committee up in Vermont is definitely good counsel for all of us, I think, at this point too, especially talking green energy with a Green Mountain State guy. I mean, this just makes sense for us to be listening to as well. So I appreciate your input. I know there's other questions. I'll let get to that. Thank you, Mr. Chair.
Thank you, Representative Cheeseman.
Oh, you got demoted.
I ain't moving upstairs, guys. But thank you, Senator Needleman. Thank you. And I think Representative Buckby touched on much of this, but I think one of the items I found very interesting in your written testimony was the fact that New England, Connecticut imports almost 20% of its energy. And I think that's a little known fact. But obviously we touched on the power coming down from Hydro-Quebec. What are our other sources of imported energy, if you know?
Well, we also get a lot from New York State. Actually, I watched the grid statistics, and a lot of it comes across what's called a number of tie lines that come over from New York State. So very, very important that we rely on them.
It occurs to me, if they are as well going down the road of increasingly using renewables, if they are dealing with that, the need to provide backup, the ability to import power from New York State may be affected by their particular needs in the same way as Quebec's desire to send us power is directly linked to their need for their own power. So thank you very much for your answers, and thank you, Senator Needleman.
Thank you, Representative. Senator Fazio.
Representative Van Wyk, thank you for your testimony and expertise. In the past 10 years, you've seen Vermont Yankee, the nuclear plant at the southernmost part of Vermont, closed for economic reasons. And we've seen Pilgrim in Massachusetts closed for economic reasons. And as we talk about reliability into the future, we don't want to see those sorts of closures of reliable and clean energy as we also move towards our environmental goals. And, since then, Massachusetts has developed its own sort of RPS, sub-RPS for nuclear as well. I guess the premise here would be that you want to send a message, both economically, but also generally politically, that reliable and clean energy has a home in the regulatory structure and the incentive structure in New England. Do you think that if those sorts of signals and structures were in place in the last 10 years, there'd be a better chance maybe of Vermont Yankee or Pilgrim or some of the other nuclear facilities in the Northeast reconsidering closure?
I would have to speculate, but I can tell you what New York State did. They have an incentive, just not renewable, but non-carbon. So even though they closed the 2 reactors at Indian Point, and because of that now burn a lot more natural gas and have a higher carbon footprint, they still have 2 nuclear plants up on the lake, there, so that there's a incentive for them to stay open because it's non-carbon. So if New England looked at nuclear as non-carbon, there'd be a greater incentive for them to stay open. It's nuclear plants are competing with wind, which is highly subsidized by production tax credits. They're also the shale oil boom has caused natural gas plants to be able to run at a lot lower cost. So, but there's a lot of reasons. If you look at the base load that nuclear provides for New England between Seabrook and Millstone throughout the day, it'd be impossible to replace that. And if you look way in the back of my graphs there, you can see the contribution that wind and solar have done in February here. Let me just show you how wind and solar have done meeting the load here in New England. It's minimal, and solar is a special challenge in New England in the winter, shorter days, snow, and you can see how solar output drops off. Not to be long-winded, but I also have a graph of Block Island Wind Farm. And there in the summer, wind really dies off, and that is when absolutely the highest demand is in New England. So there's a lot of things to balance here and take into consideration. Again, I think nuclear is got to go with that, go with the hydro too. Thank you.
Thank you, sir, for your time and your testimony. Appreciate it.
Thank you, Senator, and thank you so much for testifying, Warren. I appreciate it. You have a lot of experience. Thomas Palapiano, did I get that right? Thomas? Thomas, you're on, but you're muted. All right, we'll go back. Swanwee Wang. I'm not sure if I pronounced that right. Swanwee Wang. Not on. Rashan McCormick from McCormick Oil. Sorry. Not on. Fraser Blaylock, Covanta Energy. Not on. Julia DeWall. Oh, Julia. Ronald P. Marriott. Go with Tim Smith.
Hello, I just wanted to testify in favor. I'm Tim Smith from Andover, Massachusetts. I just wanted to testify in favor and broad principle SB 123 of adding nuclear energy to the renewable portfolio standard. And I think there's 2 key arguments. One is I think nuclear is a renewable source of energy. So if we're going to continue to call it the renewable portfolio standard, I think nuclear has to be included in it. I think if you look at the lifetimes of the plants, the reason we don't, I think we've just through the hearing today, there's been a lot of discussion that a lot of these offshore wind farms and solar installations might only last 20 years, but we're, there's already been discussions with the DEEP and the administration, the governor's office, about having Millstone run for 80 years. So if you look from the perspective of the lifetimes of the facilities in nuclear, they're very long. The fuel, the issue with spent fuel, of course, is much of the energy in the spent fuel, as much as it's an issue this committee has discussed, that is at Millstone, there's a significant amount of energy that is in that fuel that is, you know, put in back of Millstone. In the primary, one of the reasons, as while there are some parts of it, some isotopes that will have to be sent to a deep geologic storage facility, the reason we don't recycle it is primarily an economic one, that we have such abundant reserves of uranium that at this point in time, it doesn't make sense to recycle it economically. And right, when I mean abundant reserves of uranium, is not just very large mines that have been discovered in the last 20 or 30 years in places like Canada and Australia, but even technologies that could conceivably give Connecticut a homegrown source of uranium, such as extracting it from seawater from Long Island Sound. Again, this is all very hypothetical, but I genuinely think if you were doing a technical and scientific definition of renewable, and if you look at the sources of, for example, wind, solar, hydro, nuclear, when you actually look at the life cycle and the fact, I think in my mind, and I think there's a lot of scientific fact that shows it is as renewable as things like wind and solar and biomass that are traditionally thought of renewable and are currently part of the RPS. The second point I will make is the RPS was passed 20 years ago. There's been some discussion, well, adding nuclear to the RPS would only incentivize existing nuclear facilities that have existing support programs, and it would discourage new renewable facilities from being built. Well, one issue, and I can understand that distinction and that importance. One issue is when the RPS was passed 20 years ago, Connecticut had a policy against new nuclear construction that had dated and had gone back, almost I believe to 1980, for almost 40 years. Yeah, and Connecticut just last year repealed that policy in part, but yet by repealing that policy, new nuclear, while it is now permitted in Connecticut, cannot compete. There's no means for it to compete. It is not part of the renewable portfolio standards. A new nuclear that is now legal to build in Connecticut as of last year, it cannot sell RECs, nor do the programs that allow for the existing purchase of power at Millstone. That legislative authority to DEEP does not extend to, let's say, purchasing power from a new expansion of Millstone that is now permitted under the law. So keeping those two things in mind, SB 123 provides one solution to this, and perhaps there are other better solutions. But I think in principle, nuclear, and I want to especially say new nuclear, if we're concerned about actually promoting new generation facilities, there needs to be some mechanism that, even if you consider it very unlikely that new nuclear would be built, there is not a level playing field that you could even compare it.
Tim, I think we
Yes.
need to wrap up.
Okay, that's all my comments.
I do appreciate all your comments, and but we are here late, and so I Representative Buckby.
Thank you, Mr. Chair. I know we want to keep it brief. I do appreciate the support and the amount of thoughts you put into that. I know it's been a long day for all of us, and certainly for you to stand by us. We appreciate you taking the time to present your testimony, and it is greatly appreciated by the committee. But truly some great ideas, and thank you for that. It definitely will help us as we move this forward. Thank you.
Thank you so much. I think that who do we have? Fraser Blaylock is back on the line.
Yes, sir. Can y'all hear me? Yes. Okay. Thank you, Chairman Needleman and Steinberg and members of the committee. I am Fraser Blaylock here representing Covanta Energy, and just wanting to focus on one portion of the bill, one particular piece, which would move waste to energy from tier 2 to tier 1 in the state's RPS. As you know, Covanta has operated waste to energy facilities here in Connecticut since they first began serving the state in the early 80s. At that time, Connecticut prioritized taking responsibility for its own waste generation and embraced the development of waste energy facilities. This allowed the eventual closing of all the in-state landfills, making Connecticut a model for the rest of the country, and really very much in line with how Europe is handling their waste. I don't need to tell you that landfills emit methane, a very potent greenhouse gas. The UN and international scientific community are continuing to place more emphasis on the importance of reducing methane. With the closure of the Mira facility, the state has begun exporting approximately 800,000 tons or 40% of our non-recycled trash to out-of-state landfills. Throughout the growing waste disposal capacity crisis, Covanta has been asked if we would consider expanding either of our 2 existing waste to energy plants or building a new waste to energy facility in Connecticut. As the energy and waste markets stand now, the economics of developing a new facility do not work. Our challenge is to make the economics of our existing facilities work. And this is made all the more difficult with the energy from out-of-state landfills being incentivized above Connecticut's in-state waste to energy generation. And that is in the form of landfill methane gas being in tier 1 and waste to energy being in tier 2. The ACP for waste to energy in tier 2 is 2.5 cents. The ACP for tier 1 generators, which includes landfills, is 4 cents per kilowatt hour. So this incentive structure is contrary to DEEP's own waste management hierarchy and sends Connecticut electric ratepayer dollars to support out-of-state landfills that compete with our own waste energy infrastructure. I know energy, I can't see the time, but I know energy is a very, energy rates are a really sensitive issue in all the states, and particularly in Connecticut. So I don't want to appear like I'm not in tune with that by saying we think that the ACP for waste to energy should be moved up to 4 cents. But what I would suggest is if that is not a possibility, perhaps another alternative is to tie the ACP for waste to energy to the CPI, which would at least give us a little ability to move with the economic winds of the economy. So that's just an idea, but I appreciate your thoughtfulness on all this and respectfully submitted testimony in advance and would welcome any questions. Thank you.
Thank you, Fraser. I appreciate your testimony. Anybody have any questions? Yes, Representative Piscopo.
Thank you, Mr. Chairman, and thank you, Fraser. It's good to see you, and thanks for hanging in there with Covanta and Bristol. I think a third of my district uses Bristol waste energy, so I appreciate that. My question is just a real quick one. We did make strides last year, I think, in bringing you to a tier 2. Is that correct? And how is that working?
Yes, Representative, what happened last year, the change that was made was that there was a tier 2 was open to tier 1 generators selling into that tier. So we couldn't sell into tier 1, but tier 1 could sell into us, if you will, because we're the only generators in tier 2. So you all, the legislature did close that loophole, if you will. So it definitely did provide some added certainty to the value of our RECs. Didn't increase them, but it did provide some much needed certainty. So thank you. Good point.
Thank you again, Fraser. And thank you, Mr. Chairman.
Yes, and I'm glad we were able to do that last year. That was part of a complicated negotiation with the administration. And I think that actually may have ended up in the implementer, but that was a good move to get to that point. And I hope it's provided some backstop on the value of the energy now that energy prices have dropped as rapidly as they have.
Thank you. Yes, certainly has. Thank you.
That's great. So now we're going back down the line. Chris Phelps. Is Chris on? No. Charles Rothenberger, Save the Sound.
Thank you so much. Co-chairs Needleman and Steinberg, ranking members Fazio and Buckby, members of the Energy and Technology Committee. My name is Charles Rothenberger, climate and energy attorney with Save the Sound. And I'm here this evening to testify on several bills that you've heard a lot about. I'm here to testify in support of HB 5223 regarding the Mitigation Compensation Fund for offshore wind developers, in support of SB 997, which makes several welcome changes to Connecticut's clean energy statutes, and in opposition to SB 123, particularly the changes that are proposed for the renewable portfolio standard. Save the Sound is a strong supporter of the development of our offshore wind resources, but recognizing that those need to be done in a responsible manner. We think the establishment of an environmental mitigation fund makes a lot of sense. And that was something that was actually proposed by the existing Commission on Environmental Standards. Speaking of the Commission on Environmental Standards, we would also recommend, along with Audubon Connecticut, that there be some language included in that bill to strengthen and make permanent the Commission on Environmental Standards, so they can be an ongoing source of advice to DEEP as we continue our procurements of offshore wind energy. And then finally, with respect to the other issue that was raised regarding environmental standards for offshore developments, we certainly support the application of protective standards in the development of offshore wind facilities that reflect the best available science, practices, and control technologies. With respect to 997, we are in strong support of the bill, particularly wanted to call out the elimination of the sunset provision for the shared clean energy program, which has been extremely successful over the course of its first 3 years, and is focused primarily on providing the benefits of clean renewable energy to low-income households. And then finally, with respect to SB 123, the changes that are proposed to the state's RPS, I think really reveal a fundamental misunderstanding of the purpose of the RPS standards, which is really to support the development of new renewable electric generation facilities. I think you've heard a lot of folks testify already today about the devastating impact these changes to the RPS would have by opening it up to nuclear, large hydroelectric, and the trash to energy facilities. I did read the testimony of Dominion, who spent a lot of time talking about the Massachusetts program. And I would just note that the Massachusetts program is a separate tiered program that's separate from and in addition to the Massachusetts RPS. So I know there's a lot of interest in nuclear power here in Connecticut. Without taking a position on that, we would recommend that the RPS, regardless of one's position, is the wrong mechanism in order to support nuclear power. And we would hope that you do not eviscerate the state's clean renewable energy programs through this bill. And with that, I'm happy to take any questions. Thank you.
Thanks, Charles. Anybody got any questions? Nope, really appreciate your time. Bonnie Rosewig? Not on. Ralph Carlo?
Good afternoon.
Great. Afternoon.
We all here?
Ralph, yeah.
Okay, I'd like to testify in regard to Bill 6056. Good evening, and thank you for the entire Energy and Tech Committee for listening to my testimony. I know it's been a long day for all of you. My name is Ralph Carlo. My wife Jennifer and I are third generation owner of Tracy Energy. We're a 92-year-old heating oil company based in New Haven. For the last 36 years, Jen and I have been operating the company. Like I said, she's third generation. We've been here since 1987. During that time, we've always participated in the LIHEAP program or the Connecticut Energy Assistance Program, mostly through the New Haven Community Action Agency. There was 1 year we did not participate, about 4 years ago. During this time, I probably testified about 10 times to a few different committees. I think once with energy and tech. Most of the time, I think it was with human services. Right now, I just want to concentrate on one aspect because I could go on for a long time with this program. So I want to just stick to one. Originally, when we were participating in this, when I got here, the company had already been doing business with Community Action Agency and DSS directly. There was 2 programs. And at that time, you price your tickets at your full price. Whatever your retail price was, that's what you put on your ticket, and that's what you were paid. Right now, it was about 20, I'd say a little over 20 years ago, we went to this margin over rack program. And propane, liquid propane and kerosene got to stay with full pricing of their retail price. They did not go to a margin over rack. And I've been adamantly opposed to that ever since. I don't think it's really fair that the program dictates to the oil companies, many of us who are small family businesses, what we should be making per gallon on LIHEAP gallons for these customers. The reason we stay in this program is for the customers that need it, have deserve it. They've been longtime customers. I'm not going to, force them to go find another oil company because I don't want to participate anymore. But the margin over rack that was forced on us has never been fair. It's never been equitable. It puts all the risk on the oil company as far as buying the oil, securing the oil. I've heard multiple people testify today, just recently, how this long weekend, Monday, the market was closed, but we had oil to deliver. How do you price that? The state gave us a price on Friday that we had to carry all the way through till Tuesday. The market went up Tuesday morning, and we don't get a chance to adjust for that.
Your time is up, Ralph. Please summarize.
Okay. In summary, I think we should be treated just like everybody else who does these kinds of programs, whether it's fuel assistance or energy assistance through natural gas, the electricity or electrical utility, propane, kerosene. Chris had mentioned how the SNAP program, people can go to whatever store they choose to, and it doesn't matter what the price of milk, bread, or eggs is. The store gets their full price. I don't know why heating oil has to subsidize this program. And that's pretty much all I have to say. I definitely would be up for any comments or questions.
Thank you, Ralph. I think we're hearing the message loud and clear, and we're being told that Human Services is actually going to address this. I'm going to double check with our respective colleagues on that committee to make sure that they are. But this does seem like a very inequitable situation, and it's going to just lead to fewer and fewer participants in the program.
Absolutely, for sure.
Not good.
All right. I will look forward to testifying with that committee next week, but I did want to speak tonight about Bill 6056.
Thank you so much.
Thank you. Have a good night.
You too. Juliet Kane.
Oh, good evening, Representative Steinberg and Senator Needleman and distinguished members of the Energy and Technology Committee. Thank you so much for letting me speak tonight. I plan to talk on HB 5108, dealing with utility companies and vegetation management. I thank Representative Murrah for introducing the bill and agree with the point she made earlier. Unfortunately, when I seem to be the last person to speak on this topic today, and so all the good points have already been made. I have submitted detailed written testimony, and I hope you'll be able to look at that. I wanted to, I had originally planned to talk about some of the benefits of trees, and Natalie Tallis had mentioned the eco services that trees provide. You know that about trees capture and store carbon dioxide, and they emit oxygen, and they provide shade which lowers surface and air temperatures, and they filter harmful particulate matter from the atmosphere, reducing stormwater runoff and helping to control flooding and erosion. And it's for these reasons, and as the GC3 reports have consistently stated, that trees and forests afford us natural solutions to climate change. And when we have large-scale removal of trees, which is what's happening with the utilities, particularly healthy, mature trees, we're destroying a significant means of mitigation and resilience, and we exacerbate the conditions that give rise to severe weather and its consequences, like flooding and erosion. Eversource is cutting down 20,000 trees a year, and in its filings with Pura, is stating that it's going to continue to do so for the foreseeable future. So we're creating a vicious cycle. We're creating by allowing this full-scale, wholesale tree removal, we're just exacerbating our climate change problems. Dr. McCarthy mentioned the health benefits of trees. And for all of these reasons, I think that we shouldn't have a system where people are forced to choose or feel they have to choose between trees and electricity. I think Eversource has contributed to this feeling by blaming trees for the failure of our grid to be reliable and resilient. And that's diverting attention from the need to bring our aging infrastructure into the 21st century by undergrounding or other methods that are less destructive to us. Eversource's door hangers and website imply that trees are the only things that are standing between us and our electricity supply. And that scares people and intimidates them. I've even seen a door hanger that Eversource has left behind, where the consent box for tree work was actually pre-checked by them. So we clearly need change. In my written testimony, I've made suggestions for the objection process under the statute. And one of the suggestions is we give rights to a broader group, because it isn't just the abutting property owner who's affected by tree removals. In Darien, as you heard today from Emily, a whole community has been devastated by it. And you'll read in testimony from Reading that the same thing is happening there.
Juliet, your time is up. Please summarize.
Okay, I would really like to see this bill address some of the substantive problems that we have with tree removal. I think there should be consequences for utilities unilaterally expanding the utility protection zone, and to have penalties or limitations on their ability to work outside of that. I do appreciate Representative Meska's mentioning or supporting the idea of clear communication, but I think until we address the underlying issue of the utilities operating outside of the statute, that the administrative or the procedural issues are less important.
Thank you so much, Juliet. Anybody have any questions? Nope. Matthew Butler.
Hello, it's Matthew. I'm one of the owners of Ives Brothers. We are located up in Willimantic and have served the surrounding region since 1917. I'm here about 6056. We had been doing the energy program since before it was known as SEEP. I think its old name was WACAP. But this year I had to make the heart-wrenching decision to not do the program after so many decades because I just couldn't afford it. The decoupling of prices from New Haven to the terminals I go to in Wethersfield and Hartford, on July 1st, that difference was 58 cents, the same day that the diesel tax went up 9 cents for the fuel my trucks need. Even November 1st, the gap to my terminal was 34 cents from the average that was going to be the base. I just couldn't afford it. The midday price moves last April had 15, half the month, that had days with a midday price change. There was a midday price change yesterday, but I just couldn't do the program this year. And I felt awful for my customers, but I couldn't afford to put myself out of business supporting the program for one more year when we've done it for so long. I know it has hurt the customers and it hurt my gallons, but at least I can pay my oil suppliers. So I want to go back into the program, but as it stands right now, I can't afford to. This past year, I was waiting 20 to 30 days to get paid. There were days last season that I happened to get a payment just in time to avoid being cut off, which would have hurt all of my customers and everyone in this region. And we do kerosene as well. And this year we've had kerosene customers that are normally on energy call us and pay out of pocket for their kerosene delivery because they couldn't get a delivery before they would run out. And, you know, so they'd get a minimum delivery to tide them over until energy assistance could get a delivery to them. And for them, I think they were having to get oil with additive. Fortunately, this winter's been warm. But the payment terms really need to shift to 5 days from that 20 to 30. And I'm also in an area where I'm on the intersection of 3 counties. So within a mile of my office, I have 3 different payment terms.
Matthew, please summarize. Your 3 minutes just ended.
That's all I needed to say.
Thank you, Matthew. I appreciate your testimony. We're hearing it again and again, and we're getting the message clearly. Meredith Angwin. Hi, Meredith.
Hello.
See you. How are you?
Fine, thank you. It's good to see you again, and it's good to be talking to the committee again. I appreciate being invited here. Can you hear me?
Can hear you fine. Thank you.
Great. Okay. I'm going to be talking about SB 123. There are 2 parts of it that I'm going to be in support of. The first part is about actually part 2 of the bill, which is transparency. My name is Meredith Angwin, and I live in Vermont, and I have been working on following the grid and being in the ISO New England Consumer Liaison Group for years. And I recently wrote a book called Shorting the Grid, The Hidden Fragility of Our Grid. One of the things that I stress in that book is it's very hard for people to find out what actually is going on the grid. ISO New England is not the most open group, neither is NEPOOL. So I'm going to just say that the second part of SB 123 is transparency. It's about what's on the bill to the homeowner or to the renter or whoever is getting the utility bill. And my feeling is that the more that you can get, the better, because otherwise people just don't know what is going on. For example, the distribution charge isn't just the cost of getting the electricity to your home. It's also quite a few other carve-outs and line items and so forth that have nothing to do with putting electricity at your home. Okay, the other thing I wanted to say is that I want to encourage the addition of both nuclear and hydro to the RPS system. One person said a while back, he says, well, no, the RPS system is all set up so that to get us to build lots and lots of renewables. Well, no, I thought the RPS system was set up to get clean electricity. And whether it comes from renewables or doesn't come from renewables, I thought it isn't a matter of we're trying to build renewables with this. We're trying to get a clean grid and a reliable grid. And I'd like to say that I did a lot of research on that, and I want to say that if you do only solar and wind, you actually lock in natural gas, or in Germany's case, oil, coal, as a backup for when the sun isn't shining and the wind isn't blowing. And another thing I wanted to say is that we have some really great examples, not theoretical, actual stuff. Germany shut its nuclear plants and relies on wind and solar, and with lots of fossil backup. And I looked up, and it produced 349 grams of carbon dioxide per kilowatt hour in 2021. Ontario shut its coal plants, uses very little natural gas, and relies on hydronuclear. It produced 25 grams per kilowatt hour in 2021. In other words, Germany, let's see, 350 divided by 25. I don't want to try and do it in my head, but it's more than 10 times as much carbon dioxide per kilowatt hour. So we have an obligation, I think, to keep Connecticut with a very steady source of power, which is the nuclear, and to keep Connecticut encouraging clean sources of power, nuclear and hydro. And that's about it. And I'll take questions.
Thank you, Meredith. I once again want to thank you for, helping us with that forum last year about reliability. I think it was the year before last, because it was in the fall of 2021. I think it's reading your book and talking about it in this forum highlighted the need for grid resiliency as we're trying to move ahead and decarbonize our grid. And I think in Connecticut, we came to the realization a while ago that keeping our one large nuclear power plant alive was critical, and we followed that up by removing, in a very limited way, but removing the moratorium on new nuclear in the state on the Millstone site. So we're prepared. I think that not sure that we need to add that into the renewable portfolio or do what someone else suggested, create a zero carbon portfolio standard yet. But I think that that's going to be in the cards at some point soon. And the hydro, we agree with 100%, except in a limited way, some of the small hydro within the state impacts the fisheries. And there's some nuance to the way the laws are written here. But appreciate the fact that you are a great resource to us, and your opinions really matter. Thank you.
Thank you very much. I was delighted to come to talk to the forum and happy to come here too. Thank you very much.
Thank you, Representative Buckby.
Thank you, Mr. Chair, and thank you again. For us to, it's always important that we hear from everybody involved and we hear from every constituent. But I think when we have experts outside of that realm, I think it's important that we heed your advice and listen to what you have to say. So your input is certainly appreciated, especially now that it feels like it's much later than it is, but it's been a long day, here. I would like more of maybe more of your input on that, as the good senator just mentioned about hydro, because that's kind of my piece of this that I'm excited about in expanding that. Could you talk about that a little bit more? You started touching on it a little bit. I'd like to hear a little more from you on your feedback in the renewable portfolio standards.
Well, my feeling is that the renewable portfolio standard really should include all low carbon sources. And I also have noticed that if you give some kind of advantage to one kind of power source over another, that kind of power source tends to stay on the grid and the others go away. It's quite amazing what the incentives can do. So I tend to believe that we need to give incentives like the being in the renewable portfolio standards for the clean energy of renewables and hydro. Now, in terms of hydro, I have to say that I think it's hard to build more hydro in New England. I don't think it's impossible, but I think it's hard. And so you might say, well, why bother putting it in the renewable portfolio standards? I think that putting something in the portfolio standard should be a mark of its usefulness, not a mark of its probability of actually being implemented. Let time and markets and demand, I mean, think about the amount of demand we're going to have if we really go to heat pumps and electric vehicles. I mean, so what I'm trying to say is that it may be hard to figure out where to site more hydro in New England, but New England was ultimately built on hydro. A Connecticut Yankee in King Arthur's Court. Why was he a Connecticut Yankee who was a great little inventor? Well, because Connecticut was a great invention state because it was hydro. There was so much hydro.
Yeah, I can't say as I can agree with anyone more than what you're saying. It makes it very difficult to agree more, but certainly. I think the other part of that is too, we're not the first to try to cross this bridge in updating older hydro that exists. The bridge over hydro, yeah. Bridge over troubled hydro. These guys are all coming up with the puns now instead of me. It's kind of fun. Well, you know, I have to tell you, I'm not used to it from you guys. Just so newer, you're a little wet behind the ears. But there's a lot of water puns. My apologies. However, the fisheries the senator brought up as well. I know that's become a little more of a touchy subject too. So on the fisheries, I'm sure we're not the only ones who have faced that concern going forward as well. And you might be able to tell us a little more how others have done this too. The fisheries and my other piece is the updating of equipment that's already out there, because we don't want to necessarily build a ton of new dams and a ton of new hydro, but how do we upgrade those to be more efficient maybe?
Well, you can upgrade it to be more efficient. And I am concerned about the fisheries. I'm also concerned about the fact that really when you get right down to it, there's just not that much hydro here compared to what a nuclear plant can do. So in my opinion, if you're going to build a lot more stuff, it probably should be nuclear. But I don't like the idea of you don't want any hydro, you're going to tear down all the dams. I mean, those are useful. On the other hand, Vermont Yankee, which I very much supported, closed down, and it was considered to be too small or whatever to be economically viable. It was 620 megawatts. I can see the Wilder Dam from my house because I live in Wilder, Vermont, and it's 43 megawatts. So you see, there's a big difference between the hydro and what a nuclear plant can do for you. So if you really want a lot of clean energy, keep hydro, upgrade hydro. But if you really want a bunch, you've got to go with nuclear.
We should have had her on earlier in the day to speak all day. I know my good colleague to my left here is gushing because she can't speak highly enough of your book as well. So truly, thank you so much for taking the time to let us to speak with us as you did a couple of years ago here, and I would love to certainly talk to you more in the future as well. Thank you very much.
Thank you very much. Thank you.
Thank you, Meredith, and thank you for staying on all day waiting. We appreciate that, and be well. Leonard Green. You know, Leonard Green, not on. Oh, well, sorry, no hydro. Estelle Rufiak, not on. Betsy Gara.
Good evening. Thank you, Senator Needleman, members of the committee. My name is Elizabeth Guerra. I'm the Executive Director of the Connecticut Waterworks Association, which represents municipal, private, and regional water utilities throughout Connecticut. I'm looking forward to getting a copy of Meredith's book too, so very interesting. I did want to comment, I have submitted written testimony in opposition to House Bill 5163, which we are concerned adds another layer of regulation to an already highly regulated industry, the water industry. As I mentioned in my testimony, water utilities, including municipal water utilities, are subject to extensive state, federal laws. In addition, municipal water companies are also required to adopt rules and regulations and are governed by a local board or commission. And so again, we feel that the legislation is unnecessary. I did want to respond briefly to the proponent's testimony in support of the bill. I know that he had mentioned a couple of examples, which he did not provide any particulars, so it's hard to respond to the specifics. However, I have represented CWWA for more than 2 decades now. The 31 municipal water companies in the state are active, very active members of our organization, and none of those issues rang a bell at all. So I would be happy to follow up and figure out what those issues are. I am familiar, however, with the bill's proponents, the issues that he personally has been having with respect to water utilities. He's the managing member of Miller's Pond LLC and has been looking to sell or develop the pond as a water supply source for several decades now. And I know he has pursued litigation to try to ensure that this was going to happen, but unfortunately for a variety of reasons, it was not viable. And I know that he's frustrated that he's not been able to resolve this in the courts, but I don't think that adding another layer of pure regulation is the answer. And so we continue to oppose the legislation. Thank you.
So thank you, Betsy. So what you're saying is there's an isolated issue, but not a widespread problem. Am I reading that correctly?
Exactly. Good summary. Thank you.
Okay. You know, I'm always concerned about throwing more administrative work about an agency that's understaffed, that works really hard to regulate the things that they regulate, to put them in the middle of a million other issues, to me seems impossible without getting them more staff. And I know that that part would be a heavy lift. So I really appreciate your testimony on this. Anybody have any? No. Thanks again for sticking around all night.
Thank you.
So who came back on? Well, we're down at the bottom. We have Amanda Trinzi. Are you on, Amanda? Oh, okay. And then we'll go back up to Susan Zabahansky, Families, for Freedom.
Hi. Sorry to enter in late. I'm testifying on a couple bills today, and it's been a little bit hectic. I'm here to support SB 123. Obviously, I think it's important that we reverse some legislation that has caused rising costs in utilities, utility bills. I think it's, unfortunately, overregulation, as someone mentioned prior, is what's really hurting the state, hurting a lot of businesses. And I'm hoping that we can get this bill passed so that we can see some kind of relief to the amount of inflation and, rising prices that are really killing me as a single mom, only parent to my child, and a business owner. So when we over legislate things, I think we sometimes don't see the unintended consequences, and I think everybody in the state's hurting. So I'm just asking for support for SB 123. Thank you.
Thank you, Susan. Anybody? No. Okay. Thank you so much. And don't drive while you're testifying.
I'm not. I'm in a parking lot.
Thank you. You got me nervous.
Right.
Nathan Frelling from the Nature Conservancy.
Thanks. Bye-bye.
Wow, we made it to the end of the night. Thank you, Chairs Needleman and Steinberg. Good to see you. And recognizing also Vice Chairs McCrory, Foster, Ranking Members Fazio and Buckby, and all the good members of E&T. Thanks for the opportunity to testify anytime today on HB 5223, which you've heard a lot about already. I am Nathan Froling, Director of External Affairs for the Nature Conservancy, and we express conditional support for 5223, depending on how it's written. Our mission is to conserve the lands and waters on which all life depends, which includes working to address climate change, as we know, an existential threat to people and nature. And with that urgency, we believe offshore wind development must go forward at a pace and scale needed to meet climate goals. As a conservation organization, we also care about safeguarding wildlife and ecosystems to the full extent possible within the necessity to develop offshore wind at pace and scale. And we appreciate the importance of working with affected communities so that the clean energy transition is a just one. So in all cases, we believe the environment, fishery communities, and wind developers will be best served if we address and resolve the issue of mitigation compensation in a standardized way, so the overall process is efficient, predictable, and ultimately most effective for the environment and all those concerned. With this in mind, we support 5223, but believe the first step should be to carry out a study that presents the best way to set up such a fund. Secondly, it should call for Connecticut to engage and coordinate with similar efforts that are going on now in the region. That's important because what Connecticut does should benefit from the broader effort and be coordinated with that broader effort to leverage the most benefit, again, for all concerned. One significant effort going on now is by the Federal Bureau of Ocean Energy Management, or BOEM, who are figuring out a standard approach for a fisheries mitigation fund that could be replicated in each state and also could serve as an example for a wildlife environmental fund. That kind of standardization will benefit everyone. For environmental and fishery interests, it assures a minimum set of benefits. For developers, it provides a predictable approach that doesn't need to be negotiated on every project. Additionally, we recommend that 5223 include a provision making Connecticut's Commission on Environmental Standards, or CES, a permanent entity. And you heard, I think, a little bit about this earlier today. The CES helps assure environmental protection and wind energy development for the state. As it stands now, a new CES has to be formed each time there is a procurement or a new procurement. An established CES could also aid in completing the compensation fund study that we're talking about. Finally, we recommend including language that reflects the goals of proposed bill 2221, which you've also heard a lot about today, that would establish noise limits for offshore wind facilities and job creation standards in the state's wind energy bidding process. Although we must not be too prescriptive in how wind energy is designed, it is appropriate to set strong standards for protecting whales and other marine organisms. There you go. Thank you for this opportunity to comment.
Thank you, Nathan. Anybody have any comments, questions? You appear to be the last one on our list, Nathan. So thank you for being the most patient.
Oh, you bet. And I'm happy to be the last one that you've got to get through so you can go to your night. Thank you so much. Good to see you all.
And the pizza just arrived. So
yeah, there you go.
With that, barring anything from any of the other committee members, we're going to call this public hearing over. Thank you.
See you next tomorrow.
Same bat time.